audio and the video going. Good morning, everyone. Welcome to the Joint Standing Committee on the Judiciary. This morning, we will have one public hearing and a number of work sessions. I want to outline the day's work, and then we will do our usual committee introductions. So we'll begin with a public hearing on LD 811 and then move into works. It's a technical procedural vote. And then we'll do a work session on 1899. And then we'll move on to work sessions on 1626 and 585. And our plan is to have our analyst, Janet Stocco, go over her bill analysis on 585 first, because that seems to fit well with our timeline this morning. And then we'll take a midday break for lunch and for caucusing. And then we'll return and go into our work session on LD 1626. And then if time permits, also do a work session on 585. So that's kind of the outline for the day. And I see a hand up. Representative Evangelos.
Thank you, Madam Chair. Last week when we did 1626, I had to leave at 4:30 and Janet was about 60% through her bill analysis. Did anything else happen that day, or did she just complete that work? I just want to make sure I didn't miss anything.
Oh, thank you. She completed that work. And then we tabled the bill so that we could resume the work session today.
Thank you.
You're welcome. Senator Kime?
Thank you. Yes, I just wanted to clarify the plan. So 585, you're taking up before 1626, and your intention is only to go through the bill analysis and then table it and then move to 1626?
Yeah, depending on the timing, actually what I think would work probably well would be to do the bill analysis on 585. If we have time, members, the Veterans and Legal Affairs Committee had reached out to our committee asking to have an opportunity to speak to us about the sports gaming provisions in 585. And so we invited the chairs and leads from that committee to join us and just briefly address us on their concerns. And so if time permits, depending on how long this morning takes, we would have an opportunity after the bill analysis to hear from those the chairs and leads of VLA.
Okay. And when you say if time permits, what are you referring to exactly?
So for example, if the bill analysis on 585 takes us until 2 p.m, then probably we would need a little lunch break.
Okay, understood. All right, thank you.
Yeah, it's just, we don't know when in the day we're going to finish with the bill analysis on 585. Thanks. All right, let's move on to committee introductions. And I am just going to call on people as they appear on the screen. Representative Libby, why don't you go ahead?
Thank you, Madam Chair. Good morning, everyone. My name is Laurel Libby, and I represent House District 64, which is part of Auburn and all of Minot.
Representative Babbage.
Morning. My name is Christopher Babbage. I represent House District 8, which is the sunny and currently windy town of Kennebunk.
Representative Reckitt.
Morning. My name is Lois Reckitt, and I represent District 31. Is it 30? Yes, it is 31. I am tired. And the ocean end of South Portland.
Representative Poirier.
Thank you, Madam Chair. I am Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Representative Evangelos.
Good morning, everyone. Thank you, Madam Chair. Jeffrey Evangelos, House District 91. I reside in Friendship.
Representative Moriarty.
Hello, everyone. I'm Steve Moriarty. I represent my hometown of Cumberland and part of Gray in District 45.
Representative Thorne.
Thank you, Madam Chair. Good morning from Carmel. My name is Jim Thorne. I represent House District 103, which are the towns of Carmel, Herman, and a portion of Etna up in beautiful Penobscot County.
Senator Sanborn?
Thank you, Madam Chair. Heather Sanborn, Senate District 28, half of Portland, half of Westbrook, and it seemed my house might blow away this morning.
Senator Keim?
I'm glad to hear everyone else had such a windy night. Oh my gosh. I hardly could sleep. So my name is Lisa Keim and I represent Windy Senate District 18, and I won't tell you all the towns because we don't have enough time. 38 of them, and 2 communities in Androscoggin as well.
And Co-Chair Harnett?
Thank you, Madam Chair. Good morning, colleagues and those in attendance and members of the public. My name is Tom Harnett. I represent House District 83, which includes the town of Farmingdale and the city of Gardner, where I reside.
Thank you. And I'm Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. It was also very windy here tonight. My dog kept getting woken up by the noise of the wind. And so we will, I want to also introduce our OPLA analysts. We are joined today by Peggy Reinsch and Janet Stokoe. And then also our committee clerk, Susan Soupy-Panette. Thank you all. And then one other announcement for members of the public. This time of year where committees are working very hard to vote out all of our bills by this Friday, committee members will be torn in a lot of different directions. And so you may see people jumping in and out of the Zoom screen, but please know that we're all working hard and we're here as much as we can be given the other legislative demands. And so with that, we will open the work session on LD 811. And let's see if I'm not sure that Senator Breen will be able to join us. It does not look like that is the case. Yeah, so I'll open up the public hearing on LD 811 and just want to, by way of introduction, let committee members know that LD 811 is a concept draft. There's actually no content to it right now. We've been requested by our colleagues on the Health and Human Services Committee to re-reference that bill to Health and Human Services because they do have the need for a bill that they can populate with some content, and I'm not exactly sure what that is. But as a courtesy to our colleagues on Health and Human Services, I'm asking the committee to, in this public hearing, to please re-reference the bill to the Committee on Health and Human Services. I'll take any committee questions. Representative Evangelos?
No questions. I'm ready to make a motion if you're entertaining it.
We actually, we're still in a public hearing.
Okay.
And so we have to close the public hearing and move into a work session. And I'm going to recognize Representative Harnett for that.
Thank you, Madam Chair. I move that we suspend the rules to go immediately into work session on LD 811.
Is there a second? Seconded by Representative Evangelos. And then Representative Libby, did you have a question?
I just wanted to verify that we had ascertained that there was no one from the public wishing to speak on this bill.
I can certainly ask. I wasn't aware that anybody was planning to attend, but I will ask. Is there any member of the public who wishes to speak on 811? Please raise your electronic hand. I am not seeing anyone. And again, it's just a re-referencing. And so we have a motion to suspend the rules and go into work session by Representative Harnett, seconded by, I'm actually not sure who seconded it. Who seconded that motion?
Evangelos.
Thank you so much. Seconded by Representative Evangelos. Is the committee ready for the vote? Let's do the vote to go. This is the vote to go into work session. I feel like we could do this by a show of hands. And if there's not unanimity, then we can do a roll call. But if you're in favor of going into work session, okay, it looks like we'll need a roll call. Soupy, thank you.
You're very welcome. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime. Representative.
No,
I apologize.
no, sorry.
Yes, that's fine. Senator Kime votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
No.
Representative Poirier votes no. Representative Libby.
No.
Representative Libby votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Senator Sanborn.
Yes. Yes.
Thank you, Senator. Senator Sanborn votes yes. Representative Hagan. Representative Hagan is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 8 members voting in the affirmative, 4 members in the negative, and 2 members are absent. That is the vote of the committee.
Thank you. And so the motion to suspend the rules and go into work session passes. And at this point, we'll open up the work session on LD 811. And Representative Harnett, did you wish to be recognized?
I do, Madam Chair. Thank you very much. I move that we re-refer LD 811 to the Joint Standing Committee on Health and Human Services.
And is there a second? Seconded by Representative Moriarty. Any discussion? And it looks like we are ready for the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Kime.
No.
Senator Kime votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
No.
Representative Poirier votes no. Representative Libby.
No.
Representative Libby votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Representative Hagan. Representative Hagan is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 8 members voting in the affirmative, 4 members in the negative, and 2 members are absent. That is the vote of the committee.
Thank you very much. And so with that, the motion to re-refer LD 811 to the Committee on Health and Human Services passes. And we will close the work session on LD 811. Thank you, everyone, for helping us take care of that procedural issue this morning. And now we will open the work session on LD 1899, an act to ensure safe entry and access for people seeking health care and other constitutional rights. And Peggy has joined us and is going to give us the bill analysis. I will check to see if the bill sponsor is available and wishes to join us. And I see the bill sponsor, Representative McCreight, is here, and so she'll join us on the panel. Welcome, Representative McCreight.
So if you're ready, LD 1899 amends the current law already in the main Civil Rights Act as a provision about protecting access to healthcare facilities, including prohibiting noise at high volume and that it interrupts things inside. What this bill does, what LD 1899 does, is it establishes a medical safety zone around healthcare facilities, and the medical safety zone is 8 feet from the entrance of the building in which the patients receive health services. Representative McCreight offered an amendment to clarify that the 8 feet is measured from the center of the door. So not around the whole building, it's from the door. It also, the bill also prohibits during the posted hours of operating making noise at any time after a law enforcement officer tells somebody that they need to stop making that noise, when that noise can be heard within a building and with the further intent either to jeopardize the health or persons receiving health services within the building, or interfere with the safe and effective delivery of those services within the building. And right now, it is not a crime. This bill would make that a Class E crime. So all of that is already prohibited. It's a violation of the Maine Civil Rights Act to engage in obstruction of the building, making repeated telephone calls, activating a device or exposing a substance that releases noxious and offensive odors within a building, or making the noise that disturbs, that's loud enough to jeopardize health of persons receiving health services within the building or interfere with the safe and effective delivery of those services. So this bill would make that a Class E crime, which means the Criminal Justice Committee would need to review it under Joint Rule 319. And then it also provides that a new Class E crime, that it's a knowing violation to remain in the medical safety zone, with the following exceptions: a person entering or leaving the building, a person using the public sidewalk or street right of way adjacent to the building solely for the purpose of reaching a destination other than the building, a law enforcement officer, firefighter, emergency medical services provider, employee of a construction company or utility, or employee of a public works department or other municipal service acting in the course of employment. So they just happen to be in that zone, but fulfilling their public service duties, or an employee or agent of the health service or the operator of the building acting in the course of employment. So it's a Class E crime for any other person to knowingly enter into, remain, or create an obstruction in a medical safety zone during the posted hours of operation. And the provider of the health service can request a municipality to mark the boundary of the medical safety zone. So that the law that this is amending has been in place since 1995. And Attorney General Fry mentioned that there have been several cases that the Attorney General's office has brought to deal with violations of either the First Amendment rights of protesters or the the rights that are protected under this act with regard to access or noise. And I sent that to you. Leanne Robin is the Assistant Attorney General who has actually handled some of these cases. She is in the attendee room and can answer your questions. I did send you that whole list and all the individual complaints that were part of that list. And you'll notice that a lot of them, most of them, it seems like the majority, are actually protecting the protesters from harassment or things being thrown at them or vandalism, although there are some that were actually violations of this law itself. So short, this bill provides an additional demarcation of a medical safety zone and makes it clear that the noise, once someone's been warned to stop the noise, if it continues during the posted hours of operations, that's a Class E crime. And it's a new Class E crime to basically obstruct the medical safety zone. We don't have any information about the fiscal analysis yet. And my bill analysis includes a memo that Darlene Shores Lynch in my office researcher has put together generally about safety zones and bubble zones and how the courts have looked at those. Really, shortcut is they can be considered constitutional, especially if they're not overly broad, so too big to carry out the compelling state interest to protect the people who are accessing those facilities. Again, Leanne Robin can answer questions about specific cases or about how the act is applied in Maine. And I'm happy to answer any other questions.
Thank you, Peggy. Committee members, are there questions for Peggy? Representative Thorne, go ahead.
Thank you, Madam Chair. Peggy, you mentioned that the building owner can request that the municipality mark off the 8-foot boundary from the front door. Was that right?
Yes, that's what the bill provides.
Not that they must, but that they.
Actually, at the request of the provider, then the municipality is required to do that.
And okay, and did it set a timeline or just a?
Yeah, it says not later than 30 days after the date that the municipality receives a request from the healthcare provider.
Okay, thank you. Thank you, Madam Chair.
Committee members, any additional questions for Peggy? Senator Kime?
Peggy, I was hoping you could just review, so you talked about the constitutionality question, and then I just didn't know if you could just give us an overview of how this would differ from, I think it was a Supreme Court decision about something similar.
So there was a case in Massachusetts where I want to say the buffer zone was 35 feet. And that was a fixed 18-foot buffer zone and a 6-foot floating buffer zone. No, it was the 35-foot fixed abortion buffer zone that violated the First Amendment to the Constitution because it limited free speech too broadly. So that was in 2014 that the US Supreme Court struck down that Massachusetts buffer zone that was 35 feet. After that, so Massachusetts took it off their books. After that, the Massachusetts amended a statute to create a 25-foot buffer zone, and I believe that's still valid in Massachusetts. Montana also has a buffer zone. New Hampshire has a buffer zone with up to 25 feet. So it's a balancing between the free speech rights of the protesters, and also there's a legitimate interest in protecting, in being able to provide counseling and information to people who are walking through that zone. So if the zone is too big, that means that the people who are trying to provide information, potentially to patients, are unable to do that. And that's a legitimate, the US Supreme Court has said that's a legitimate First Amendment right, is to provide that information. So if the buffer zone is too big, then they can't carry that out. An 8-foot buffer zone, I don't think has been struck down. Portland originally had a 39-foot buffer zone. It was struck right after the Massachusetts case in 2014. Portland repealed that. And protesters had already filed an action claiming, trying to seek damages, and note that it was unconstitutional. And actually the federal district court allowed them to go ahead and seek damages for what they were prohibited from doing while it was in effect. And that was settled. I don't know what the details of that settlement was.
Okay, that's helpful. Thank you.
Representative Babbage?
No, thank you, Madam Chair. Not that it need stifle any discussion, but I'm prepared to put a motion before the committee.
Thank you, Representative. You can go ahead with your motion.
Colleagues, I would like to move that we ought to pass as amended, the amendment being the clarification of the 8-foot zone being from the center doorway.
Thank you, Representative. Representative Moriarty?
Second the motion.
Thank you. So the motion before the committee is ought to pass as amended. Is there committee discussion on the motion? Senator Keim and Representative Harnett, your hands are still both up. Did you have discussion on the motion? Okay, go ahead, Senator Keim.
I don't have discussion on the motion. I had another question for Peggy.
Okay, go ahead.
Peggy, you mentioned a fiscal note, and I was just wondering, would that be a fiscal note like for municipalities, or what do you think the cost involved in this is?
Right. I don't know. We submit every bill for a fiscal note. So I don't know. I don't know if this would be determined to be a mandate, because a municipality would have to comply with the request to paint or somehow, mark what the medical safety zone is. It might not be a mandate because it is not required by statute, and it would only be triggered at the request of a healthcare facility. So I don't know. That's not, our office doesn't do that analysis, and so we'll be waiting for that.
Okay, thank you. That's helpful.
Representative Libby?
Thank you, Madam Chair. I will be voting against the pending motion and supporting ought not to pass. I did not hear a single testimony that indicated to me that any Maine persons failed to obtain serious medical attention, that this bill would be solving that problem. And I feel like the First Amendment concerns here are paramount, and so I will be voting against the pending motion.
Representative Thorne?
Thank you, Madam Chair. And I guess I have another freshman question, and I'm not sure. Obviously, it is an ability to put in statute that the state would require a municipality to incur a cost from a law, but I'm just curious if anybody is aware of another example of this where a law that is incurred mandates or incurs cost to a municipality based on a statute?
Is that a question for the committee analyst representative?
Perhaps, or if any of the knowledgeable colleagues on this panel are aware of another bill that was written in such a way that it obligates a municipality to incur a cost, in this case, to paint or to mark otherwise the boundary. If there's another bill, if anybody's aware of one that a state law mandates a municipality incur a cost. Just
Let-
out of,
Peggy, are you able to answer that?
Right. Well, I can give a little bit of background. So the Constitution has a provision that says anytime that a municipality is required to change what they're doing and it incurs some kind of costs, it also applies to counties, any local government, based on a law that is newly enacted, then there are a couple of things that can happen. That the legislature, the state is expected to reimburse or cover 90% of that cost. If the state's not going to do that, then if the legislature says we think this is so important that this needs to happen and the local government is going to incur these costs, they can the legislature adds what's called a mandate preamble, which requires a 2/3 vote in each the House and the Senate in order to override that provision that the state has to provide at least 90% of those costs. So those are, if it's determined that this is a mandate and people don't want to establish an account and fund it that municipalities would draw from in order to carry out this bill, then the legislature could put a 2/3 mandate preamble on and pass this bill by 2/3, and then that would take that out of the obligation for the state to cover those costs. The other thing that can happen is the statute provides for this. If the legislature, if it's identified as a local government mandate and the legislature does not provide funding and the legislature does not enact it with a 2/3 mandate preamble, then it means the municipalities are free. They have discretion of whether or not they comply with it. So every time that it's identified, it starts with the Office of Fiscal and Program Review. Every time they identify a local government mandate, it could be something that the counties have to do. And for example, paying process servers. We had a bill last year about paying process servers, and a lot of those are county employees. That is a local government mandate, and the legislature has to deal with it one way or another. Anything that if you required a municipality to carry out certain functions that they're not already doing and that it increases their costs, then it's identified as a mandate and the legislature has those options to move forward. Is that helpful?
Follow-up? Yes, it is very much so, Peggy. Minor follow-up, if I may, Madam Chair.
Is it about this specific bill or is it generally about that process? I'm just trying to keep us focused on the bill at hand.
You lost me where I'm getting off track. I'm talking about this bill and whether or not the provisions in this bill mandate that a municipality pay, or does a municipality have to come back to the legislature, or they can opt not to accept it, or that the legislature, like Peggy said, would put in a provision that would require a 2/3 majority to approve that a municipality would in fact have to pay that 90 or incur 90% of that.
Okay, so it sounds like your question to Peggy is actually about the bill. So go ahead with the question.
Right. I think I understand your question. You don't need to say it again. I don't think. What we're waiting for, just like we wait for every bill, every amendment, is for the fiscal office to do a thorough analysis and then provide you with information about what the costs would be. They will identify whether or not this is considered a local government mandate. And at that point, I will, if they determine that is a local government mandate, I will bring that back to you and you can decide, the committee as a whole can decide how to go forward with it. If they decide it's not a local government mandate and there's no fiscal note, I will also let you all know that, because then, you know, that would, well, you'll have to sign off on the amendment anyway. So, right, you will definitely have an opportunity to hear their decision about whether or not it's a local government mandate.
Great, thank you. Thank you, Madam Chair.
Thank you. Representative Babbage?
Thank you, Madam Chair. And my question is really as it relates to the bill, but it's for Peggy. Peggy, regarding the relevance of this bill in the mandate process, we have received reports back in the past of incidental expenses. I know that we're really concerned about assigning to local government an ongoing expense and so forth, but is there a threshold or is that subjective as to when the mandate applies, or whether the expense is too small to put in a numerical assessment?
I think the threshold is cost, any kind of cost. So the threshold might be zero. Well, not zero, anything above zero. I have seen a mandate identified for the cost of a stamp. So that's what the Constitution says. If it causes in this case, municipality to change what they do, and there are costs involved in what that municipality has to do, then that is considered a local government mandate under the Constitution. There's a statute that implements what the process is for going through that. And one of those provisions is if it's identified as a mandate, no money is provided. There's not a mandate preamble, so it's not enacted by a 2/3 majority. It gives the local government the discretion to not comply.
If I may clarify, am I correct that we have had reports come back that have, I don't know if the word's incidental, but they have not been able to put a number on a mandate,
Yes.
but they say there may be incidental costs?
And they've identified it as a mandate, yes.
Really? Okay, thank you very much.
Yeah, and it might be easier for us to address these questions once we get the fiscal note, so that we know whether this is even implicated by LD 1899. It's hard to do it in the abstract. Representative Reckitt, go ahead with your question.
My question is for the bill sponsor, if I could.
Go ahead.
So, and I have to plead semi-ignorance on this topic, but I only know of two places. Now, this is clearly a bill to protect abortion clinics. There's no question about that in my mind, even if it doesn't say the words. My question is, how many places in the state are we talking about? I only know one in Portland, one in Bangor. There must be others, but can't be a million. It just, I mean, I applaud the opponents of abortion. This is a clever ploy to try to get this bill to go down, but it's just, I mean, I'll go out with a paintbrush. I mean, it's like, it just seems to me that it's really the magnitude of this is minuscule. Not just the cost of painting a line, but the number of places where it might be applicable is minimal. And I'm asking whether or not I'm right about that to the sponsor, who may well know how many places in the state such a thing would apply. We talking 2 towns or cities, or are we talking 50?
Representative McCreight, if you can go ahead and answer the question.
Thank you, Madam Chair. Representative Reckitt, I don't have an exact number, but you're definitely right that we're talking about a very small number. If you look at what was sent from the AG's office, there were some incidents. I believe one was around a sign, one was around, again, as Peggy said, many of the issues are around protecting protesters' right to free speech. So there's a facility in Topsom that doesn't perform procedures, but does other kinds of medical care, and Bangor and Portland. I think Nicole Clegg is here. If you wanted to double check the number, I think she would know, but you're definitely right. It's a very small number that we're talking about. The bill is broader in saying healthcare facilities, not to avoid talking about abortion, but because we don't know what the future is going to hold, and different procedures at other healthcare facilities may be come up later or soon. I don't know, but it wasn't intended to avoid the topic, but to say that it could be elsewhere. But again, you're absolutely right. We're not talking about very many places, and I would join you with a paintbrush.
Thank you.
Senator Kime?
Thank you. Another question for Peggy. Currently, there's only one case I saw, correct me if I'm wrong, that this idea of making noise, like I think one of the suggestions was that somebody comes along and makes noise after there's already been given a warning about noise. And I've only seen in all of the information cases that the AG gave us that there was only one instance of that. So my question then is that, just so I'm clear, so if one person makes noise, and they're given a warning, then another person that same day comes in and is making too much noise, then that second person doesn't get a warning. They are then committing a Class E crime with possible 6 months of incarceration and $1,000 fine. Am I understanding that correctly?
No, I don't think that's what the change does. You're looking at section 2 of the bill. It doesn't change that. It changes it. What the Attorney General's office is supporting was in paragraph D, where it says at any time after the order. So each individual person would still have to be warned, but it doesn't mean it starts over the next day. That it's once they've been warned, that warning is good, and the next time they violate it, and by creating that much noise, then they can be arrested and they would be subject to this crime.
Okay, so it's not just any person because I think one of the examples that was given was that, well, then that one person stops making noise and then they ask somebody else to make the noise for them. So I think I heard that when we had the public hearing. So that's why I was trying to clarify, because that.
You're right. You're right. That was the testimony. And I don't think that this language changes that. I think what it changes is that the warning against that person would continue if they came back later in the day, or they started making noise again, or if, the next week they start all over again.
Right. So it stays with, so the warning or whatever stays with the person, not necessarily with the incident of the day or the day.
That's my understanding. You might want to double check with Lee and Robin in the attendee room, but that was my understanding, that the really important piece of this was at any time after the order, and not that it warning, person A applies to person B.
Okay, thank you. I guess if Leanne Robin thinks it's something different than that, if she just wanted to raise her hand, otherwise, then I'm good with your answer. Thank you.
Before we move on to Representative Moriarty's question, let's bring Leanne Robin in and ask her the question. Leanne Robin, welcome to the Judiciary Committee, and thank you for being available today to answer our questions. And I was wondering if you could briefly respond to Senator Kimes' question, and well, we can ask her to restate it if you need that.
I'm good. I think I understood what Senator Kime was asking. It does still require that the person who is in violation have received a direct order from a law enforcement officer. And although we found a problem with the tag team yelling, this bill would not necessarily address that. But I just want to make clear that at all times we have to prove the intent to interfere with the operations of a clinic or a healthcare facility. So it's not just the noise; it's also the intent to violate the rights of those people trying to get healthcare inside.
Thank you. Does that answer your question, Senator Kime?
Yes, and if I could have just one follow-up with her?
Yes, go ahead.
Okay. Thank you for being here and for answering my question. And so then I guess the only other question I think around that is what sort of, is the measure only intent, or is it also sort of a measure of how loud you are? Like, is there a decibel level or something, some very structured, because I didn't notice that in the bill, but maybe it's in other language somewhere.
No, that has actually been one of the challenges to the statute and the statute's been sustained against the fact that it doesn't have specific decibel levels. The measure is, can the volume, can the noise be heard within the clinic? That's where we draw the line. If it's heard within the clinic and it's with the intent to interfere with those services, that's when we bring an enforcement action. And I think you had also asked, there's just one noise complaint. For 20 years, we had this law on the books and we didn't have a problem. And then suddenly this protester comes on in 2015 and we've got a problem. And my understanding from Meredith Healy, who spoke to you, that problem has continued with new protesters who have come in. So most of the protesters are complying. It's these aberrant people who are coming in and using volume to disrupt the services that we are looking to prevent, so that the patients can get the health care that they deserve.
So does that become sort of a he said, she said? If they say in the clinic, I heard it, and then outside they say it wasn't that loud, they're not telling the truth?
That has been one of the factual issues in these enforcement actions. And what the clinic employees have done more and more is actually take out an iPhone, record the volume of the noise inside so that they can prove it. Because remember, we still need to prove these cases beyond a reasonable doubt. And so it will come down to the credibility of individuals. And that's why the warning is so important, so that people know that they can be heard within the clinic and they have an opportunity to come into compliance and bring the noise down.
Oh, thank you so much. That was very helpful.
Thank you, Leanne Robin. And I am going to send you back to the attendee place because you've done a great job of answering our questions. And Representative Moriarty, go ahead with your question.
Thank you, Madam Chair. Peggy, the bill already imposes costs upon the clinic in terms of the placement of at least one sign. So if OFPR comes back and says that the cost of painting an 8-foot semicircle around a door is a mandate, do we, as the committee, then have an option to revisit that issue, and specifically to impose that cost of painting or putting up temporary markers upon the clinic as opposed to the municipality?
Many committees, once they get a fiscal note or a mandate determination, will go back and change the language of the bill so it would avoid kind of triggering that whole analysis. So you could do that, yes, and change it from the municipality marking it to the healthcare provider doing that, although I'm not sure what the implications are if you're doing it on a public street or a public way. That might be something we'd have to talk about, but maybe maybe that's something that could be resolved easily. But yes, you could, once you get that information back from the fiscal office about the mandate, about the fiscal costs, you can, reconsider. If you vote today, you can reconsider and change the language.
Okay, thanks. Thank you.
Representative Babbage, did you have another question?
I do not. Thank you, Madam Chair.
Representative Reckett, do you have another question? No, okay. Is the committee ready for the vote on the ought to pass as amended motion? Senator Kime?
Yeah, I just wanted to state my reasons for opposition before the vote. So I will be voting in opposition to this bill. Obviously, respect is paramount for any sort of engagement with people, whether you agree or disagree. And so I think that's important. But I mean, one of the, I guess, almost all of the issues that we were given by the Attorney General of things that had come up, almost all of them are actually against the protesters, right? So there's, if there's something that needs strengthening, it may be the protection of people who are exercising their First Amendment rights. And so I find this to be stepping into a public space and taking away rights where there's very few inappropriate actions being taken on the behalf of the people that this is sort of aimed at. So I really don't see much of an issue. And so I think without that, I'm opposed to creating space where people don't have free access to public property. And so I will be voting against the pending motion. Thank you.
Committee members, is the committee ready for the vote? Looks like we are, and our committee clerk has appeared magically on the screen. Thank you very much, Soupy, and we're ready for the vote.
Thank you, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kime.
Yes.
Oh, I'm sorry. My apologies.
Yes.
Senator Sanborn votes yes. Senator Kime.
No.
Senator Kime votes no. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Libby.
No.
Representative Libby votes no. Representative Thorne.
Nay.
Representative Thorne votes no. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 8 members voting in the affirmative, 3 members in the negative, and 3 members are absent. That is the vote of the committee.
Thank you very much. And for those who voted against the motion, could you please let us know what your report is?
Ought not to pass.
Okay, same. And Representative Libby, is that also yours? Okay, thank you. And so the ought to pass as amended motion carries 8-3 with 3 absences. And with that, we will thank the bill sponsor for coming before the committee. And we'll close the work session on LD 1899.
Thank you to the committee.
Okay, and we are going to move on to our work session on LD 585. And our analyst, Janet Stocco, has appeared. And Janet, we were also appreciative and impressed with the bill analysis on 1626. And I know that you have prepared materials for us on this legislation. Are you thinking that it makes sense to do screen share, or how would you like to proceed?
I generally do that in VOA, but I don't know what you all prefer. So I'm fine either way. I have it pulled up on my screen if you want.
Okay. Committee members, would we appreciate the screen share? Unanimous nodding heads on that one. So we'll open up the work session on LD 585 and begin with the analysis from our OPLA analyst.
And I promise it's not as long this time. So is that a good size?
Yeah, I think so. Is that okay with everybody? Readable? Yeah, I think so, Janet. Thank you.
Okay. So as you know, this bill originally had a different title, but the sponsor proposed an amendment that was available for the hearing held this year on the bill. And so the new title is here, an act to enhance tribal state collaboration to revise the tax laws regarding the Holton Band of Maliseet Indians, the Passamaquoddy tribe, and the Penobscot Nation, and to authorize off-track betting facilities and federally recognized Indian tribes to conduct sports wagering. And the bill analysis is only going to focus on that proposed amendment. And it has, as the title suggests, 3 separate pieces. And it's important to note right at the outset that all of the provisions of this bill are located outside of the MATE Implementing Act. So they're all in other provisions of state law. They're not amendments to the Implementing Act. So the first part of the bill, I'm going to probably accidentally say the bill, but it's really the amendment. Hopefully you'll just indulge me and understand what I'm saying. But the first part, Part A, is the enactment of a new Tribal State Collaboration Act, and that would be within Title V of the Maine Revised Statutes. And it would apply to all 4 of the federally recognized Indian tribes in the state. So that includes the Micmac Nation, the Holton Band of Maliseet Indians, the Passamaquoddy tribe, and the Penobscot Nation. And it lists a series of departments of the executive branch and also the Office of the Public Advocate and the Public Utilities Commission that each have to engage in certain consultation processes. So first, what they have to do is to develop a policy that promotes positive government-to-government relations between the state and federally recognized Indian tribes within the state, that promotes cultural competency in the agency's interactions with Indian tribes and tribal members, and that establishes a process for consulting with Indian tribes regarding, quote, the agency's programs, rules, and services that substantially and uniquely affect the Indian tribes or tribal members, end quote. So that's, so you know the scope of the type of agency actions that are subject to this policy. The policy must require the agency to make reasonable efforts to complete the following before final action on a program or service, or before publishing the proposed rule that meets this substantially and uniquely affecting the Indian tribes or tribal members test. So they must, as an agency, provide advanced written notice to the Indian tribes, allow the Indian tribes an opportunity to provide information and input, and require the agency to consider that input. In addition to the requirement to develop a policy under the Tribal State Collaboration Act, Part A of the amendment requires that the agency inform its employees of the collaboration policy requirements. It must also, for the agency, designate a tribal liaison to implement the Act's requirements and to facilitate communication with the Indian tribes. The Tribal State Collaboration Act would also provide mandatory training on require the agencies to provide mandatory training on cultural competency, effective collaboration, and positive government-to-government relations between the state and the Indian tribes, 2 agency employees who are responsible for consultation under the policy, as well as any employees whose work substantially and uniquely affects Indian tribes or tribal members. And then beginning January 10th of next year, the agencies would be required to biannually file a report with the legislature and with the Maine Indian Tribal State Commission, which I'll refer to as MITSIC for short, providing an update on its responsibilities under the Act, and its being the agency's responsibilities under the Act, identifying the agency's proposed programs, rules, or services, again, that quote, substantially and uniquely affect Indian tribes or tribal members, end quote, and the agency can make recommendations, if any, for expanded collaboration under the Act. The Part A of this amendment also specifically provides that failure of an agency to comply with the Act's requirements does not itself create a right of action or constitute a ground to invalidate, reverse, or remand an agency's action. So if the action does fall within the substantially and uniquely affecting an Indian tribe or tribal members, and some of the collaboration pieces aren't followed, that alone wouldn't be a ground to invalidate it. But if there's another cause that would exist under current law, that still could be pursued. Part A also requires the governor to annually convene a tribal state summit with the leaders of the Indian tribes to address issues of mutual concern, including implementation of the Tribal State Collaboration Act, improving communication between the state and the Indian tribes, and the implementation of the requirement that already exists in current law to include Maine Native American studies in the Department of Education systems of learning results. The last piece of Part A of the amendment also would include the Holton Band of Maliseet Indians within the list of parties that may join an interlocal cooperation agreement under Title 30A, Chapter 115 of the Maine Revised Statutes. The purposes clause of that chapter explains that the purpose of the chapter is to permit public agencies of the state or any adjoining state, including but not limited to municipalities, counties, and school administrative units, as well as federal agencies and Indian tribes and their political subdivisions, to make the most efficient use of their powers by enabling them to cooperate on a basis of mutual advantage, and thereby to provide services and facilities within the state in a manner and pursuant to forms of governmental organization that will accord best with geographic, economic, population, and other factors influencing the needs and development of communities. So under current law, if you look at the actual text of the proposed amendment to 585, you can see that the Passamaquoddy tribe and the Penobscot Nation are also already included as parties that can enter into these interlocal agreements. And so what the amendment would do would add the Holton Band of Maliseet Indians. So that's all Part A. Part B of the proposed amendment is a legislative findings and provision supporting all of the state tax law changes that are in Part C to H of the amendment. And these tax law changes apply to the Passamaquoddy tribe, the Penobscot Nation, and the Holton Band of Maliseet Indians, but not to the Micmac Nation. So under Part C, there are some general provisions. So there are some definitions about tribes and tribal lands. Most importantly, at least as I read the proposed amendment, it defines the Holton Band Trust Land by reference to the Federal Holton Band of Maliseet Indians Supplementary Claims Settlement Act of 1986. And this is in blue. Anything in blue throughout, you can click on and just get right to the text of it. So there is a definition of Holton Band Trust Land in the Maine Implementing Act. We talked about it with reference to LD 1626 last week. There is some difference in opinion on whether that definition ever took effect because it was passed through a 1981 law and perhaps the contingencies weren't met. So by defining the Holton Band Trust Land by reference to this federal law, there wouldn't be any question that that's a clear definition. The federal law is definitely in effect. It also defines Passamaquoddy Indian Territory and Penobscot Indian Territory by reference to the relevant procedures of the Implementing Act, which is a state law, if you remember. It also defines tribal land to include all three of these types of land and tribal member as an enrolled member of one of these federally recognized Indian tribes. It also contains a definition of tribal entity for state tax law purposes. And this definition is not the same as the definition is in LD 1626. And if you have the tax chart that I put a side to side together, you can see that there are some differences. For example, the threshold of ownership is different. So under LD 585, it would require for something to qualify as a tribal entity entitled to the sales tax provisions of this amendment to 585, it would have to be either wholly owned by any combination of the 3 federally recognized Indian tribes or their tribal members, including either spouse of a married couple if one spouse is a tribal member, or if not wholly owned by a combination of those governments and individuals, at least 75% of the ownership interests must be held in aggregate by one or more of these 3 federally recognized Indian tribes, and the entity must be controlled and managed by one of these tribes under the management and control tests that are developed by the Federal Small Business Administration. In this provision of the Code of Federal Regulations, there is a typo here. This is a very long provision, and I forgot some of the numbers. There's a 124.109 here, but if you click on it, it is linked to the correct provision, and the quote below is correct. But I just forgot some of the numbers here. I guess I thought there shouldn't be that many numbers in that provision. But this is the control and management test that would be used to decide if something that's not wholly owned, is only at least 75% owned, is in fact controlled and managed by the tribes in order to qualify for the sales tax provisions of this amendment to LD 585. So I'm not going to read through them, but there are clear tests here, and the experts who are in the attendee room, I bet, could explain these tests to you far better than I. The other part that's in the first part C of the amendment that involves tax is a provision that provides that the Passamaquoddy tribe and the Penobscot Nation are deemed to act in a governmental capacity and not in a business capacity for purposes of applying the state's sales tax and income tax laws, and are therefore exempt from these taxes, notwithstanding a specific provision of the Maine Implementing Act. So this provision is quoted below, and that provision states that the Passamaquoddy tribe and the Penobscot Nation would be exempt from taxes if they are acting in their governmental capacity, but not if they're acting in a business capacity. And so this provision would say we are going to decide as a matter of state law that these 2 tribes are always acting in a governmental capacity. I believe that the governor's office submitted some proposed technical amendments to this amendment to 585, and it would add in the Holton Band and Maliseet Indians here. And then I had some technical suggestions below about how you might want to reword this provision, but we can get to that. I just wanted you to know that there was a proposal to add the Holton Band and Maliseet Indians specifically here, and it wouldn't just affect those 2 tribes that are listed currently. So those are the sort of the general provisions for tax, and then there are some more specific provisions. So under Part D, there are provisions about the sales tax, state sales tax, and it would exempt from the state sales tax all sales for any purpose occurring on or after January 1st of next year to the 3 affected Wabanaki nations as nations. So to the Holton Band of Maliseet Indians, the Passamaquoddy tribe, or the Penobscot Nation as tribes themselves. It would also exempt from the state sales tax, again, January 1st, 2023, for sales to tribal members or tribal entities. Remember, we had that definition of what qualifies as a tribal entity. So sales to them that are sourced to tribal lands. But it does provide that the use tax applies to such sales if the exempt property or service is used primarily outside of tribal land during the first year after purchase. As far as deciding whether something is sourced to tribal land, there is a provision of current law. I'm just going to show it to you very briefly. I'm not going to go through it. And it talks about sourcing of where a sale is considered to have occurred. And so that same rule would be applied here to decide where to source the sales, to decide whether a sale to a tribal member or tribal entity is considered sourced to tribal lands, and therefore that sale is exempt from taxes. Of course, it went back to the top. That was not helpful. And it got rid of my zooming in. That'll teach me to click on it. So then the next provision about the transfer of sales tax revenue. So under current law, the amount of sales tax revenue collected by the state that's attributable to sales occurring on the Passamaquoddy reservations at Pleasant Point or Indian Township is returned by the treasurer of the state to the Passamaquoddy tribe on a monthly basis. So just to remind you, as mentioned a little bit earlier on in the quoted phrase from the Maine Implementing Act, sales tax apply to tribal lands currently. So these sales taxes are collected currently, and under current law, if those sales taxes are collected on the reservations for the Passamaquoddy tribe, they are returned, those revenues, to the tribe on a monthly basis. In the amendment to 585, in Part E, it would expand the transfer of sales tax revenue in a couple of ways effective January 1st next year. First, it would expand for the Passamaquoddy tribe the sales tax transfers to include taxes on sales occurring on all of Passamaquoddy Indian Territory, not just the reservations, but also the trust lands. And it would authorize sales tax transfers to the Penobscot Nation and the Holton Band and Maliseet Indians, again, for sales on their Indian Territory or the Holton Band Trust land. So it expands it in two different ways. The next part, in Part F of the amendment, involves a couple of taxes that aren't just strictly the state sales tax or income tax that we talked about with respect to the other bill. So first, there's a commercial forestry excise tax in Title 36 currently, and Part F of the amendment would exempt tribal land from that commercial forestry excise tax, which is currently imposed on commercial forest land of greater than 500 acres, if it's owned by a person greater than 500 acres throughout the state. There would also be an exemption from the wild blueberry tax. So right now, wild blueberries are subject to a 1.5 cent per pound tax. And if those wild blueberries were grown on tribal lands, then they would be exempt from that tax. There is also an exemption in Part F of the proposed amendment from the sponsor that would exempt potatoes grown on tribal lands from the 6 cent per hundredweight state potato tax. So we've talked about sales taxes applying to the tribal governments and tribal members and entities. We've talked about the sales tax transfers, the three specific other types of taxes, and now there are also provisions about income tax. And Part G is where you can find those provisions about the income tax. So first, and all of these are still effective January 1st of next year if you pass this amendment. So first, Section 17, corporations. So Section G2 provides that a tribal corporation organized under Section 17 of the Federal Indian Reorganization Act of 1934 is not subject to state corporate income tax. So what is that corporation? I tried to find the easiest way to describe it. So there is this U.S. Department of the Interior publication called Choosing a Tribal Business Structure. When I searched online, that seems to be the most helpful explanation, but there are experts in the waiting room who can tell you exactly what a Section 17 corporation is. But for purposes of this analysis, I would say that according to the U.S. Department of the Interior, in advising tribes on whether they might want to establish a Section 17 corporation, they explain that a Section 17 corporation is wholly owned by the tribe, but is separate and distinct from the tribal government. And that generally speaking, these corporations are not required to pay federal income taxes, whether they are operated on or off of the reservation. So what this provision of the bill does, the amendment does, is it says that these Section 17 corporations wholly owned by the tribes would not be subject to the state's corporate income tax. And as far as other income taxes, sections G1 and G3 to G5 of the amendment create a state income tax modifications for tribal members who reside on tribal land and for the estates of its decedent who was a tribal member just residing on tribal lands. And that exception to state income tax applies for the amount of income or loss derived from or connected to sources on tribal lands. So the test for determining whether a tribal member resides on tribal land, that is included within this amendment is very similar to the test for determining whether an individual is a resident of the state for income tax purposes. So the language is very similar. So that may be helpful for you to wrap your head around what this amendment does, because I know we don't talk about tax law a lot in this committee. So whatever test is used to decide if your income is, first, if you are a resident of Maine, is going to be the same type of test to decide if you're considered a resident on tribal land. And then the test that is used, again, for folks who are not residents of Maine, to figure out if your income should be sourced to Maine for income tax purposes. That same type of test will be used to decide whether your income, if you're a tribal member, should be sourced to tribal land and therefore exempt from state income tax. So again, I just want to remind you that for tribal members, the exemption for state income tax only applies if two things are true. You have to be residing on tribal lands and your income has to be sourced to those tribal lands. Otherwise, you would be subject to the state income tax if this were passed. And then there is a provision in Part 8 that allows the Bureau of Revenue Services to adopt routine technical rules to implement these provisions for tax laws. And then the third, yes.
Could we just take a pause here, first of all, to thank you. And secondly, to see if committee members had questions for you about the collaboration section and the tax section before we move on to the sports wagering?
That is fine. Would you like me to stop sharing so you can all see each other?
Yeah, that sounds great. Thank you. Okay, so let's take these sequentially and first open up the floor to questions for Janet regarding the collaboration piece. Are there any questions on that, committee members? Representative Moriarty?
Thank you, Madam Chair. I had a question for Janet. Actually, I have two questions for Janet. First, we've been aware all along of the 4 federally recognized tribes in Maine. And on page 1 of your analysis, this is the first time that I have seen what I have always known to be the Aroostook Band of Micmacs, now referred to as the Micmac Nation, and the word Micmac itself, the spelling has been changed. So my question is, has there been a so-called official change of name of this recognized tribe, or what else may have happened since in the recent past?
So I did want to say that I did put that in 1626, but I really breezed over it, so you might not have noticed it. And I had seen a newspaper report, actually Peggy showed it to me, and then a friend of mine in the revisor's office also showed it to me. And the report was from the Bangor Daily News indicating that the tribe had changed its name officially. And then in deciding whether to put it in the bill analysis, because I try and keep just to legal things, I looked at the Department of Interior's website and it lists the Micmac Nation as the Micmac Nation, and it doesn't list it as the Aroostook Band of Micmacs. So I figured that was good enough for me. But as far as knowing what happened to make that change in effect, you would have to ask a representative of the tribe itself.
Of course. Well, so going forward then, in this and in every other piece of legislation that references this particular recognized tribe, should we make that change?
I would suggest that you probably should, but I would reach out to the Micmac Nation and just double check that that's what they would prefer. But it seems logical to me that if their name has been officially changed, that the state should refer to them by the official name.
Okay. My second question is also fairly quick. I don't quite grasp the concept of income sourced to a piece of tribal land.
Representative Moriarty, I'm going to ask you to hold that question because we're just looking at the getting questions.
Oh, that's right. I'm sorry.
Now.
I'm into the second part. My fault. I'm sorry.
No worries. No need to apologize. I just want to keep us focused on collaboration for a moment. Senator Keim, did you have a question on the Part 1 collaboration? Thanks.
Yes, I do. Thank you. Janet, again, astounding job here on working through this. So appreciate it. And so I have a couple of questions. One is around, I guess I would like further information on when it says notice to employees, inform agency employees of the collaboration policy requirements. I think I'd like to know a little bit more. Because I'm looking at overall the man hours impact of this. So there needs to be a liaison, and I'm wondering how many liaisons. Like, is it for each agency? That part I don't. It's not really well defined here, and the idea that, so how many reports, like who's filing a report and how many will there be?
Certainly, I'll start with that if I can.
Yeah.
Okay, so if you look at the language of the proposed amendment, it's in 11053, and then subsection 3 says that each agency shall designate an individual who reports directly to the head of the agency to serve as the agency's tribal liaison. And there have been a question posed to the governor's office about this, and it's my understanding it would just be one existing member of staff would be designated as the tribal liaison, at least under the governor's office interpretation of this provision.
So are you saying that the governor's office has one tribal liaison, or every agency has a tribal liaison?
I'm saying that they interpreted it to me as each agency picks one tribal liaison, but it wouldn't necessarily be a newly hired person. It would be somebody would be designated, could be existing staff, and may always be. I just can't guarantee that.
And how many agencies is this? Is each agency listed as well?
Yes, so it's agriculture, conservation, and forestry. These are
I'm
the
sorry, are you finding this in the bill somewhere? Oh, yes, right here. I see it now. Yes,
Yep,
okay. So
whole-
every single one of those agencies listed has to have a liaison to the tribes.
Correct.
And then the mandatory training has to be with the liaison or with everybody in the government, in everyone working in all of those departments.
So the mandatory training you'll find in 11054 subsection 1, and the training has to be provided to the tribal liaison, other employees responsible for tribal collaboration under the act. So it might be the folks who are sending out the notices about different policies that are possibly going to be adopted, and then other employees whose work substantially and uniquely affects Indian tribes or tribal members. So other employees would not have to be trained, so there wouldn't be a mandatory training, but nothing prevents that training. Just those are the groups who have to be trained.
Okay. And so I guess a follow-up to that would be how many people that might entail.
That I do not know.
Right, so that's a question we would have further. And my other question is, so the Tribal State Summit, here we're telling every governor in perpetuity that they have to convene a Tribal State Summit. Do we actually have the authority to tell the governor what to do? What if they just decide not to?
Well, I hadn't thought of that question. I think there are other provisions of law that talk about, like, governor must make nominations for certain things, but those sort of derive from the Constitution. So I don't know. I hadn't thought about that question, but there wouldn't be any penalty. You know, it's not like the governor would be thrown in jail or anything if they chose not to comply.
So I guess for maybe a follow-up at another time, I just wonder about the separation of powers and if we actually have authority to say that. I guess I would be curious. I mean, it's pointless to put something into law that we actually don't have the authority to make happen. Thank you. That's all I have for the moment.
Thank you. Representative Babbage, go ahead.
Thank you, Madam Chair. With regard to this section, Janet, if you could help me, under the policy of tribal state collaboration, promoting a government-to-government a relationship between the state and the federally recognized tribes. We can do that without actually amending the implementing act. Is that correct?
Certainly, and this is not an amendment to the implementing act. It's a freestanding act in Title V. Well, Part A would be a freestanding act in Title V, a Tribal State Collaboration Act.
But the implementing act does not recognize a government-to-government relationship. So I guess what I'm saying here is the word promoting a positive government-to-government relation, is that the distinction?
I think that the implementing act doesn't address this unless, LD 1626 would affect this. But if we look at just the implementing act now, it doesn't address this, and the implementing act doesn't lack recognition of the existence of tribal governments. It just doesn't give them the same rights as other tribal governments in other states. But I wouldn't say that it doesn't recognize that tribal governments exist. So I don't know if that answers your question.
It doesn't recognize that they exist with any separate jurisdiction other than a municipality. I mean, that is the implementing act. But I guess where I'm going with the questioning is when Representative Moriarty mentioned the Micmacs, the Micmac Nation, my understanding, what I'm asking is, does the international aspect of the Micmac Nation impact at all not only how we refer to them, but also the government-to-government relationship that we're promoting here? Like, for instance, the two major tribes, we've been told that the Passamaquoddy tribe also has an international aspect to it, but their membership is defined as residents. I don't believe the Penobscots have an international aspect in the same way, but their membership does not require residents on the reservation. I don't know what the rules are for the Micmacs, but I wondered if the Micmacs in New Brunswick would be included if we refer to merely the Micmac Nation, or if the Aroostook Band of Micmacs designates merely those on this side of the border, or is that not the distinction? That's really what I'm asking.
So I mentioned the Micmac Nation so you would know that the way that the amendment is drafted, it would include them, but it is not actually referenced in the proposed amendment. What the proposed amendment says is Indian tribe means a federally recognized Indian tribe within the state of Maine.
Okay.
So I think that takes care of your concern.
Thank you. Thank you for that clarification. Appreciate it. Thank you, Madam Chair.
Representative Libby?
Thank you, Madam Chair. And I have a question that may be appropriate for you rather than Janet, because I don't think Janet will have the answer, but it is related to this section and the mandatory training. I'm wondering if the question would be more appropriate for the sponsor, but I'm just wondering, I'm looking between the analysis and the bill itself, and there's a lot of vagueness in the mandatory training. And so I'm wondering how the training is defined, if there are hour specifications, which employees exactly would be included, and who would make those determinations. So I'm happy to hold my question for the sponsor, but I just don't see any answers between either the bill, the amendment, or the analysis.
Thank you for that question. I can try to provide an answer. The types of detail, like the hours of the training and who specifically would provide it, often that level of detail is not established in statute, that it can be a process adopted by a state agency or even a municipal agency, depending on what the requirement is. And so that I would just say that it's not unusual for a statute to not get that granular. That I guess I think that's probably why this didn't get that granular. It specifies the content of the training, but not the hours and the people and that sort of thing. And that's pretty common.
So theoretically, then Department of Public Safety could have a 15-minute online module, while the Public Utilities Commission could have a 3-hour in-person. It would be dictated by the department themselves.
Well, I think the training, I mean, what I like about this provision is that it specifies the goals of the training. And I don't know if a 15-minute online module would meet the requirements of paragraphs A, B, and C, but that's certainly something that someone subject to the training could raise, or that would be, I mean, one could challenge a 15-minute module and say, hey, wait a minute, this doesn't really meet the goals that are established by the statute.
Okay, thank you.
Representative Thorne, go ahead with your question.
Thank you, Madam Chair. And I don't know if Janet can answer this or not, but we'll give it a shot. I don't know if now or in the future, it would be allowed and or permissible to have a state agency located on tribal land, or vice versa, have a tribal entity that was located off reservation, how that would apply in this situation, or would there be provisions for it, or would that just never exist? It just wouldn't make sense to either entity.
I think you'd have to ask the chiefs maybe about what they would think about it. The tribes would have jurisdiction over their lands, and the land then would either be on the reservation or it would be trust land. So the state agency, if it wanted to have a presence in the tribe, would have to, lease the property, or wouldn't own property in the state, wouldn't own property in Indian Territory or home band trust land. But I don't know why they couldn't open an office. But that would be something to really ask the chiefs who know. And I don't know if the tribes, if they have fee land outside of their Indian Territory or trust land, would have a need to open an office for some other purpose. But if it's located outside of their Indian Territory or home band trust land, then it would be subject to the laws of the state, just like any other property owner.
In a follow-up, if I may, Madam Chair?
Yes.
Thank you. And Janet, does it specify coastal waters? Does it go up to the shore, would be considered tribal land, or would that extend offshore and still be considered under tribal control and applicable laws?
So first, I would say nothing about this bill before you changes the definition of Indian Territory or home band trust land. It's just, there are references to the definitions for purposes of administering the tax provisions, but nothing about this proposal changes the scope of those lands. And I know there has been litigation over whether waterways are included, and I would not want to misspeak because that is an area that has been litigated, and there are definitely people who know the answer who are not me, and I don't want to be wrong by what I tell you.
Right, and you just mentioned, like, blueberries and potatoes and such, but I'm just thinking aquaculture is a up and coming business, and I didn't know how that would apply in this case, and I don't see any specific provisions that would define a collaboration between the state and the tribes as that occurs now elsewhere. So, okay, we'll answer that later. Thank you. Thank you, Madam Chair.
And Representative Thorne, I did want to point out that I think the state agencies that are listed in the definition section of the collaboration provision, and then the collaboration provisions regarding communication between the state agency and the Wabanaki nations, that I think that aquaculture, for example, is something that could come under that collaboration process. Do you think that
But
might
we
be
don't
the
know
case?
that for a fact, though. We're just speculating at this point.
Well, Janet, did you want to weigh in on that, or should we?
Well, if a state agency was going to enact a policy or rule about aquaculture that could substantially, let me get the quote so I don't tell you the wrong thing.
I just didn't know if it
That
was
substantially
defined.
and uniquely affects the tribes, then there would be consultation involved in creating those aquaculture rules.
Mm-hmm. So between inland fisheries and wildlife, that would be perhaps a predefined agreement that's already in existence somewhere that this
No.
would define further?
No, if there are any policies in the state already, they're not governed by this Collaboration Act. But once this Collaboration Act is enacted, if it is enacted, then should an agency want to adopt any program, rule, or service that substantially and uniquely affects the Indian tribes or tribal members, then it would have to engage in the consultation process in doing so. There would be nothing preventing the agency from going beyond that and just collaborating or consulting anyway. But if that type of rule that was going to be considered would substantially and uniquely affect the tribe, then there would be this consultation process added on top of current requirements of law.
So anything that happens in this with the collaboration between the state and the tribe would supersede any existing laws?
No, all of the existing laws would still be imposed. So if there's public comment required, all of that would happen too. It's just that there would also be this consultation piece as well.
Okay, thank you. Thank you, Madam Chair.
Representative Libby?
Thank you, Madam Chair. Upon reflection, I just wanted to ask if Janet had anything to add regarding the mandatory training question that I had.
I just wanted to say that the only thing I didn't make clear, I do think it's, I agree with Senator Carney that that kind of detail isn't always included in statutes, but there's no reason why it couldn't be. And also I did want to say that the liaison, one of their specific tasks is to coordinate the training. So I believe the liaison would have a lot of control over deciding how to organize that training and how to conduct it, and possibly even how to pick the employees, although I imagine the head of the agency would want to have some say in that as well.
Thank you, Janet. Where in the amendment would I find that regarding the liaison having that responsibility? I missed that.
It's in 11053, subsection 3 is the tribal liaison.
Section 3.
And it's paragraph C. And actually,
yes,
maybe I should have just showed you the side-by-side chart, because that's where I quoted all the language. And on the left-hand side of that chart, I kind of give you the topic.
Okay.
And so it's not always in the same order as the amendment, so that you can kind of like, look, what topic do I want to ask a question about? And you just see the language. I don't try and interpret it or summarize it. I just gave you the actual language. I find that helpful, but I don't know if you do as well, but that may work.
Okay. Thank you. That explanation is very helpful.
Senator Kime?
Thank you, Madam Chair. So Janet, I'm guessing you probably don't know the answer to this, but I would like the information. When we look at the required policies that have to then come under some sort of review by the tribes, policies or rules, I don't actually have a good grasp on how many that might be in each of these departments per year. I mean, is it 1? Is it 200? I have no idea. So I was wondering if you don't know, if you could find out if they could give us some idea on what these, I mean, maybe every single rule or policy the Public Utilities Commission, for instance, does every year would somehow affect the tribes. I'm imagining it very well may, but maybe not the Department of Transportation or Marine Resources or whatever. So I just want some sort of number to try to understand the magnitude of collaboration that would end up being required for these liaisons.
And I agree that I don't know the answer to that question. And to the extent we don't get it later today, I will ask. But I did want to point out that it's not any policy that might affect the tribes. It's written much more narrowly. Well, I interpret it as more narrowly, maybe others do not. So it's an agency program, rule, and service that substantially and uniquely affects the tribes and tribal members. So if it's just something like, I don't know, everybody must use this color of paint or something like that, it doesn't affect the tribes any differently than it would affect anybody else, then I don't think that's included just because somebody who's a tribal member might have to use that kind of paint. It makes sense.
But then the word substantially, when I think about the Department of Education, a lot of the policies they make substantially affect education, so I don't know how, I understand the word uniquely seems more narrowly tailored, but the word substantially seems to possibly have a broader implication. So maybe whoever's, what's that?
It's both. So it has to be substantial.
Oh, substantial and unique.
Yeah.
Oh, gotcha. Okay, great. Though that is helpful. Thank you for pointing that out. And yes, so maybe we could still find out the information then, because that definitely narrows down the scope. Okay, thanks.
Thank you. Committee members, any other questions on collaboration? Oh, great. Janet, are you ready for questions on taxation?
With the caveat that tax is really outside of my scope of knowledge, so I will do my best. And we worked really hard to get folks from Maine Revenue Services here. And I might just have to say, I defer.
Okay, thank you. And I know that we haven't been pulling in people from the attendee space on the collaboration, but I am wondering if we get to the point, committee members, where we're asking very technical tax questions, because again, it's not Janet's area, that maybe would make sense during this segment to bring in Maine Revenue Service members. So let's start, Representative Moriarty, with your question. Oh, we're not able to hear you.
That's right. Sorry. Thank you. My question is more of an admission, and that is that I don't grasp the concept of income sourced to tribal lands. I wonder, Janet, if you can just elaborate on that a little bit.
The best elaboration I can say is that there are tax principles about how you decide where to consider income to have come from. And it's just the same theoretically, just at a high theoretical level. There was a time when I lived in New Jersey and I worked in Philadelphia. And so I was subject to Philadelphia taxes, Pennsylvania taxes, and New Jersey taxes. And so there are tests to decide, where do you source my income? If I live in one place and work in another, that's not going to be how it works for the tribal members. But I'm just giving you an example. There are established tests for how you decide where the income is from. And it's my understanding that the provision of Maine law that is used to decide sourcing for income of non-residents and whether they would pay the state income tax is the model upon which the amendment to 585 uses to decide sourcing for tribal member income, whether it comes from tribal lands. Beyond that, you have exited my area of expertise, and whether there are any slight differences between the two tests, I would not be able to tell you.
Thanks.
Senator Kime?
I have tax questions, but my first question was just to you on process. So you mentioned we haven't brought in anyone from the outside. So were you planning that we would sort of take it in chunks and bring people in to talk about each section after we complete the whole bill with Janet? Or when were we going to be asking outside, people in the waiting room or whatever questions about portions of the bill, and we're going to take them all separately, just so I understand?
Yeah, so my thought was, to the extent that we can do the bill analysis on 585, the same as we did it on 1626, we would do that. However, because of the unique situation here with taxation, if there was an answer that a committee member needed on a specific taxation point that Janet was not able to answer, I think we could consider whether it makes sense to bring in the main revenue service person at this point. Otherwise, we can put those questions on our to-do list and complete the bill analysis on 585 and take them up this afternoon. I don't know that people are going to have that sort of highly technical question that we would need to do that.
Okay, so we will have a chance at a later time to kind of go back and discuss this with people outside.
Absolutely.
Okay, all right, thanks.
Yeah. Okay, other questions on the taxation committee members? Questions for Janet on taxation? Representative Babbage?
Thank you, Madam Chair. Janet, I'm working off, I have the original bill. I have the sponsors amendment in boxes, 585 amendment. I have the comparison of tax proposals, and then I have this bill analysis. I'm not sure if I'm missing an intermediary status of the bill when we're talking to specific wording. But working from your bill analysis, you mentioned that the management and daily business operations of a tribally owned concern must be controlled by the tribe. I just wondered if there was an understanding of what controlled means in that sense.
So you are quoting from the Small Business Administration's, the Federal Small Business Administration's regulations for deciding control and management of tribally owned entities. And
Okay.
what the bill does, you won't see it, the amendment you won't see it in the text of the amendment because it references the Code of Federal Regulations. And because there's no way to know what that means, I just quoted it for you. How that test works is definitely something that I know the Main Revenue Services folks know about. But it is an existing regulation that is used in other areas of federal law to figure out control and management of tribal businesses.
Thank you. That's reassuring. Thank you.
Committee members, any additional questions for Janet about the taxation provisions? Senator Kime?
Thank you. So I was wondering, so this includes reservations and trust lands. So, but I think it also includes some territory or some land that's outside of either one. I think there's 4 parcels. I was looking for this while I was trying to, before I asked you the question, because of 2 things. I was wondering if there was a map that we could see of what these are, but also their trust lands can still be expanded at this point. Is that right?
So I don't see the other 4 parcels. I'm sorry. If I'm missing something, the definitions of the lands for the tax piece are in Part C, and it's very possible I'm missing that. But the Holton Band Trust Land has a definition, and it's referring to the federal law's definition of Holton Band Trust Land, which is, in a very brief nutshell, the land purchased by the Secretary on behalf the U.S. Secretary of the Interior in trust for the benefit of the Holton Band and Mousy Indians using Federal Settlement Act money. And then Passamaquoddy Indian Territory is defined specifically by reference to the Implementing Act. The same with Penobscot Indian Territory, specifically with reference to the Maine Implementing Act. And so if we just ignore 1626 for a second, although I know that there's possibly both could be enacted, you look at the Maine Implementing Act and it has those defined geographic regions where the Passamaquoddy tribe and the Penobscot Nation can have lands put into trust status on their behalf. We went through that whole chart with 1626. All of those current law rules apply to decide whether something can be included within their Indian territory. And that's the only land we're talking about here. The Indian territory does include their reservations as well, the way it's defined, but it's the reservations and trust land. I don't know of any fee land being included here, but I am happy to be corrected on that and then correct my answer to you.
So, and that's fine. I don't know where it is at this time, but I do remember talking about it with the governor's representative. But what I guess then one of my questions is the trust lands at this point, they haven't all been purchased, right? There's still the ability to expand. I just am trying to make sure that I have that.
Right. And in current Implementing Act, there are specific places where those trust lands can be located. A lot of unorganized towns, or for example, if you remember, there's a provision about for the Passamaquoddy tribe to obtain certain land in Calais if certain requirements are met, including entering a tribal state contract under AGRA, which isn't going to happen because the court has said AGRA doesn't apply in Maine. So there's all those same specific categories of where the land can be located. There is another kind of a catch-all provision in current law that says for the Penobscot Nation and the Passamaquoddy tribe, other lands can be taken into trust if recommended by MITSIC and if the legislature agrees and if the local town, city, plantation, the government agrees if it's not in an organized territory. So there are ways to go beyond the limitations. And as I think Peggy mentioned during the 1907 work session, this has happened a couple of times in the past, or maybe it was the 907 work session. I can't remember. I was listening to them because I had to miss them for my family thing last week. And there are times in the past when it's been expanded beyond what's specifically stated, but that requires action by the legislature, recommendations from MITSIC, and approval by the local government if there is a local government and it's not unorganized territory.
Okay. All right, that's helpful. And then I had another question about these. I have too many papers in front of me, so I keep flipping through them and losing myself. A certain corporation that you were talking about, a certain type of corporation, and that they can currently have. Okay, a Section 17 corporation. Here we are. So I think that they currently have these in the state, and is this expanding them? I'm trying to remember what I had a question about this, but because I was wondering if we knew how many there were.
I do not know how many there are. No.
Okay. And then yeah, so I guess I need to kind of think back through this one, because as we bounce from topic to topic, I lost track of my thoughts on that. So I'll just go on to the other question. I'll have to circle back to that when I remember it. But for the tribal members to get the income tax modification, they have to be living on tribal lands, and in addition have to have derived their income from the tribal land. So it's both.
Correct.
It's not one or the other. Okay. I thought that was the case. I just had to clarify. Thank you.
And if you want to see that in the bill itself, it's sections G3 and G4. G3 is the income addition modification, G4 is the income subtraction modification, And this is where I get out of my depth, because you add the absolute value of the number and then you subtract the regular number. So that's where you're going to have to talk to the Maine Revenue Services folks. But I would say, if you look, it says a tribal member has to be residing on tribal land to have the benefit of these additions and subtraction modifications to their state taxable income. So both residing on tribal land, and then later in the sentence, it says for income derived from or connected with sources on tribal lands. So it's a two-part test. And failure to meet either part would mean then you would be regularly be subject to state income tax.
Thank you, Janet.
Representative Libby, go ahead with your question.
Thank you, Madam Chair. And again, it is a question that I'm not sure if Janet is the right person to answer, but if you are not Janet, I will re-ask when the appropriate person is here. But my question is, why does this apply to the Holton Band of Maliseet Indians, but not the Micmac Nation? Why are they not included in this portion, but they are included in the prior portion with the liaison to the governor of the tribal state collaboration?
I agree. I'm not the right person to answer that.
Okay, I'll hold my question till later then. Thank you.
Thank you. Representative Babich, did you have another question?
Oh, I'm sorry. No.
Okay. Great. Any other tax questions for Janet? I am not seeing any. Oh, Representative Babich, go ahead.
Yes, thank you very much. Let me get back to, and perhaps Janet, I wondered if, regarding the sales tax, it provides that the use tax applies for the period of a year. And I wondered if you might have an example or help me to understand what that means.
Sure. So if someone is a tribal member and that person or individual, were to purchase, I don't know, a vehicle on tribal lands, and then for the first year only ever use it off of tribal lands, maybe that person actually resides off of tribal lands and only ever uses it there. My understanding would be, but I'm sure the Maine Revenue Services folks are listening and will correct me if I'm wrong, that if that's the primary use is not actually on tribal land, then the person would have to owe use tax. Just like if you or I were to purchase something in New Hampshire, we're supposed to pay use tax on it because we didn't pay, the state sales tax there, but we're using that item in Maine, really.
Thank you. Appreciate that.
I'm not going to ask you if you paid the use tax, though. I'll be kind.
Very good at that.
Senator Kime.
Thank you. I was wondering, did we get any testimony regarding the impact that these changes in sales tax and might have on surrounding areas? Did you remember? I don't remember seeing any, so I didn't know if you saw any, Janet. Okay.
I didn't notice any. I glanced at all of the pieces of testimony. Anything that was seemingly different, then there was a bunch of testimony that was very similar. Mm-hmm. But anything different, I printed out and read through. I don't remember that, but I could have, in glancing through, have missed something, I must say, between this bill and 1626 with over 1,500 pieces of testimony. I did not read every word. I tried to focus on anything that looked slightly different.
Okay, thank you for that. And then a follow-up, another question about this, sort of around impact as well. Do we have any idea? I guess when I look at the wild blueberries, I know that I think that part of what their tax pays for is the Wild Blueberry Commission to just kind of promote wild blueberries. I eat a lot of them myself, in case anyone's listening. I'm promoting them right now. But my question is the overall impact of the exemption of these. What kind of impact does that have on whatever the forestry excise tax is used for, or the wild, the wild blueberry and the potato tax. I don't know how much, what portion the tribal lands represents of this overall amount that's taken in. And other than what the wild blueberries is, I'm not even actually sure what those taxes go to support. So I guess that's sort of an impact question. If you probably don't know, but maybe if you could find out for me.
I wrote that down. I would say the potato tax is similar to the blueberry tax, where it funds the main potato board, and I gave you the statute there, and you can click on it and see what it does. I don't remember what the commercial forestry excise tax promotes. So, but there's a potato board just like there's a wild blueberry commission.
Right, and I knew that. And okay, so then what, I guess I would just be wondering what percentage, what's the loss to these boards? What's the impact on these boards? And then the same for the forestry. What's the impact of the loss?
Yeah, I wrote that down.
Thank you.
Representative Harnett?
Thank you, Madam Chair. And just as a follow-up to Senator Kimes' question, Janet, wouldn't we receive that information in a fiscal note, the impact on those various taxes?
I would think we would, but I haven't seen, tax fiscal notes, but I would expect we would.
Okay, thank you.
All right, committee members, anything else for Janet on taxation? Representative Babbage? We're not able to hear you, Representative.
Thank you, Madam Chair. Janet, I think this is my last one. Can you help me to understand how tribal entities, which I understand is a corporation that, or could be a created entrepreneurial corporation that may have up to 25% ownership beyond that of the tribes, how they are treated differently than a Section 17 corporation?
Sure. A Section 17 corporation would be exempt from corporate income tax, but the tribal entity would not. The tribal entity only gets the benefit of the sales tax provisions in the bill.
Thank you. That's why I asked. Thank you. You're very good.
All right, thank you. And so it looks like we're done with questions on taxation. We have been meeting for a little bit more than 2 hours straight. And so I would suggest that we just take a little 5-minute break and let's come back at 11:10 and we'll dive into the sports gaming or sports wagering aspect. So see you all at 11:10. And Representative Babbage, I did want to let you know that your video is still on. I don't know if you intended to leave it on, and your hand is up too. Thank you. Committee members, if you are able to return to the meeting, please do so. Janet, welcome back. Thank you so much for all of your answers to our questions. All right, so we have resumed our work session focusing on the OPLA analysis of 585. Representative Evangelos, your hand is raised. Go ahead.
Very quickly, I just want to make sure about where I am and where we are. We're simply going through the bill analysis with Janet, but then there will be a further work session on talking and deliberating and bringing in people from the outside if necessary. Is that correct?
Yes, that is correct.
Thank you.
You're welcome. All right, Janet, are you ready to dive into the final section?
I have one thing I forgot to say earlier.
Okay.
Oh, I might have said it. I can't remember. So I'm going to make sure I say it now. The governor's office did propose some technical changes to those tax provisions. And if you recall, during the work session on 1626, there was reference to a tribal attorney's proposed amendment to that. So because each affects the tax provisions in some way, in that chart I have where you can look at the two side by side, anything shaded in that chart represents, on the left-hand side, when you're talking about 1626, the tribal attorney's proposed amendments to the tax provisions. And if you're looking at 585, it's the governor's office that proposed some technical changes. So those are shaded as well, so that you can see right in the provision itself how all of those proposed amendments, it's odd to say an amendment to the amendment, but you know what I mean, how those look right, sort of right in situ where it would belong in the language. And then you can compare it side to side. I actually, even if nobody finds that helpful, I found it helpful to be able to compare them myself. So it was definitely worth it for me to do it that way.
Can I just ask you a quick follow-up question, Janet? So the side-by-side comparison chart, are you saying that that takes into account the technical changes that were suggested after the amendment to 585 was introduced?
Yes, but those are shaded in gray so that you can see that that's a proposed change. So if you ignore the shading in gray, then you'll see the way it's written now. But you can see also in the shading in gray what the governor's office proposes technical fixes. I'm saying the governor's office because it came from Jerry Reed, so I assume that's how I should refer to it.
Okay, that's great. And we those are technical changes that are not intended to change the way the language works, but just to make sure that it's clearer.
Right, there's nothing, so I wrote the bill analysis before I had those in my hand. And the only thing that I felt like that was really different, as far as other than just being purely technical, was where I mentioned earlier, there is a provision early on in the tax provisions that says that the Passamaquoddy tribe and the Penobscot Nation are deemed to be operating in a governmental capacity for the the sales tax and income tax laws of the state. And there was an additional sentence there proposed by the governor's office to add in a sentence about the Holtman and Maliseets to the same effect, that they're considered to be operating in their governmental capacity for sales tax and income tax law purposes. I don't know that in the end that would be different if you didn't put it in there, but it is significantly different as opposed to just seeming technical to me. Everything else seemed very technical. So that's why I pointed that one out when I was talking about it. But everything else, it does change how it reads. And I know that the folks on this committee really like to see the language the way it would look. So I thought it was worth putting it in the chart. And then it turns out that was helpful to me too, to understand how the provisions worked.
Thanks. I thought the chart was very helpful as well. Committee members, does anybody want to actually look at the language that Janet is talking about right now, because she could screen share it since that is more by way of a substantive change. If you raise your hand if you'd like the screen share on that one. We've got, do you mind, Janet?
Well,
Sharing the
before we,
screen
if
and-
you don't mind, before we do that, I'm a little lost on what papers I should be looking at, Janet. So I see, I have things that are comparison, but I don't think I'm looking at what you're talking about because the bill analysis doesn't list anything in it about 1626. It just lists 1352 and 585. So I think I haven't printed everything off, and I was hoping you could help me understand what paperwork you're looking at.
I think that's an excellent question. So I did just want to, because you pointed out the bill analysis talks about 1352. I put that in there because that seemed to be discussed a lot during the hearing. But the rest of the bill analysis, I focused just on 585. But it occurred to me after last week that perhaps maybe you would like comparisons on all different pieces. So that's why I came up with the new charts. They're just not mentioned in the bill analysis because I'd already made that and we'd already published it for that last work session. So I just didn't change it. But let me go. I'm going to share my screen to the electronic committee file and show you where all these documents are. So you can see what the documents I'm talking about are. That just seems the easiest to me, if that works for you.
Yes, that would be fine. Or yeah, or just tell me the name of it and when it was put up or something, because I will print it off. Like you said, there's a lot of different things in our files right now.
Sure. So you're going to see my bill analysis, which I actually shared for you right from the electronic committee file. So this is the file for 585. And the way these default sort is all the speaking testimonies up top, and then usually right under that are the documents that we post from OPLA. I don't know why it default sorts that way. It just does. I like it. It's handy. So the technical tax amendments that were proposed by the governor's office are linked right here. So this, I'm just going to screen share because I was asked to, and then I'll show you all the other documents.
Okay.
So it's just this first box here. If you remember, it's the tribes deemed to be acting in government capacity. The gray shading is what I put in the bill analysis as a suggestion for possibly rewriting it in a little bit different way that I thought would be more legally sound. And then the yellow sentence is what the governor's office is suggesting adding. And it says that it's adding it by virtue of a request to include a reference to the Holton Band of Maliseet Indians. So in the bill itself, or the proposed amendment that was heard in on February 17th, it would say that the Penobscot Nation and the Passamaquoddy tribe are deemed for purposes of Part 3 and 8 of Title 36. Part 3 is sales and use tax. Part 8 is income tax, that they're deemed to be acting in a governmental capacity. And then that same type of sentence would appear here to say the same is true for the Holton Band of Maliseet Indians. The rest of the proposals seemed very technical to me. I could be wrong, and that's what they were called. But all of the other proposals, all this yellow stuff was does seem very technical about sort of how do you administer these tax provisions. So that's that document. The bill analysis is linked here. That's what I've been reading from. There was request for some figures about state revenues from casinos, and that you can find in the Gambling Control Board's annual report. I will mention to you that the sports betting provisions have some public records exceptions in them. Those were also the same public records exceptions in 1352. So you already reviewed them as a committee last year. So I just gave you the memo from BLA and the memo you wrote back. So you can see those here. MITSIC proposed that this committee look at a consultation statute for tribal state consultation that was enacted in Minnesota. So that is posted here. And then the comparison charts for the tribal state collaboration proposals. So this is where you see the topic. This is what I was looking at when you were asking me specific questions, because I tried to put it in organized kind of topic way. And so, for example, when you asked me who does the training apply to? I just looked on the left. Where's training? Where's training? Really fast. Ah, there's training. And then over here, it gives you the exact language. And then I put the section so you can find it in the proposed amendment if you want to find it there. But this is the exact language there. And then if, for example, there's something that's only in one proposal and not the other, you can see that too. Or you can compare what's the training under 1626 and what's the training under 585. And it's not that I'm suggesting these should be alternatives, but I didn't know if there was one version of it that you liked better. And if you were inclined to vote for both, would you want to put it in both or not? So that is there. And then there's also the tax proposals. And here is where, so again, the left, well, the middle column is 1626. The right is the sponsor's proposed amendment to 585. It's organized by topic the way I organize it in my head. Hopefully it's helpful organization. But as you can see, a lot of these provisions, the tribal attorney's proposed amendment changed some of the language. So I just tell you this one was amended or proposed to be amended, and this is what the amendment would be. So you can find it shaded. The same happened with the governor's office proposed technical amendments, and you look for the shading, and that shows you what they proposed to do. And so, for example, here's the piece we just talked about. It adds this new sentence about the Holton Band of Maliseet Indians, and they adopted the suggestion that I had in the part of bill analysis we haven't gotten to yet about maybe reorganizing this first sentence a little bit. Because to me, it makes a little bit more sense to do it that way, but that's obviously up to the committee, not me. But apparently the governor's office liked it because they included it in their proposal. So I think, and then a lot of people have asked for the text. So if people are watching right now, a lot of people have said they couldn't find the text of the proposed amendment, and it's here. It's just maybe not everybody knows how to find the electronic committee files. So if you're watching and you're not a member of the legislature, if you go to the Judiciary Committee's homepage, it has a link for committee materials, and then you can search by the LD number and you can find the information for LD 585. It'll bring you right to this page we're looking at right now. And the text of the proposed amendment is right here. So this is the one that we've been talking about, the actual text. I think those are all the documents. There is information. The only other new thing is information that came from the Sports Bidding Alliance. You had asked for information. It's not referenced in my bill analysis because I just realized it was posted on the wrong hearing page. So I reposted it last night. So you can sort by submission date. If you do that, you can see the very last thing added was this Sports Betting Alliance. So that document might also be helpful because it's a direct response to a question this committee asked during the hearing on this bill. Those are the documents I think that are important to have in front of you.
That was really helpful, Janet. Thank you. Would you like me to talk about sports betting now?
I think we're ready for that, Janet. Thank you.
Goodness.
Senator Keim, did you have another question before we moved on? I just wanted to check in with you. No, okay.
Sorry, no, I'm just trying to go print those things and wasn't paying attention to the hand.
Okay. Thanks. All right, Janet, I think we're ready. Thank you so much. That screen share with links to the documents was helpful.
Certainly. So part I of the amendment from the sponsor to 585 would set forth legislative findings that are related to Part J, and Part J is the sports betting piece, which would legalize and authorize the Department of Public Safety Gambling Control Unit and the Director of the Gambling Control Unit to regulate sports wagering in the state. Part J is similar to, but not identical to, provisions of LD 1352, an act to regulate sports betting, as amended by the majority BLA committee amendment and by a House floor amendment. And full disclosure, that House floor amendment was necessitated by me not understanding the vote. So you shouldn't view that as a change to the majority committee amendment. That was literally a mistake on my part that was fixed through the floor amendment. I'm just going to be honest there. I had not written down one piece of their amendment. So I tend to think by topics. So I organized this table by topics, and this is not a direct quote table. This is a summary, because as you can see, the provision is long. So although the chart, to be honest, is kind of long too, sorry. So the first topic would be facility operators, and those are the operators that are authorized to accept sports wagers that are placed by customers within a physical location within the state. And I just didn't know where to put this provision. There is a provision in the bill that says municipalities retain home rule authority to enact zoning and public safety ordinances related to sports wagering facilities. So that was in this provision as well. So under the proposed amendment before you to 585, who would be eligible for those licenses? They would be off-track betting facilities that are licensed under Section 275D of Title 8. And those off-track betting facilities are currently located in Waterville, Sanford, Lewiston, and Brunswick. 275D is the general off-track betting facility licensing statute. It also refers to an off-track betting facility licensed under a public law enacted 2016 chapter, that might be 2019. Look at the text, chapter 626, and that is currently Scarborough Downs has that off-track betting facility license. There's a technical piece at the bottom of the bill analysis, not here, but it talks about there was a lot of discussion at the public hearing whether the Bangor Raceway, which is affiliated with, but not the same as Hollywood Casino, whether that was included. I've done investigations through the Harness Racing Commission and speaking to Chris Jackson, who represents the Hollywood Casino in the legislature. And it turned out that technically they are not listed here, but I know language that you could use to include them if that is somebody you would want to include. Each of these off-track betting facilities can receive one license, and that license would not be able to be transferred or assigned. And there is a requirement that no more than 7 licenses may issue. So anything shaded in this chart is intended to highlight a difference between what's before you and 1352. I do not know whether for your purposes you would like me to compare them now or just to tell you what you have before you. So I'm going to look for guidance on that.
Senator Kime?
Sorry, I'm not giving you guidance. I just had to back you up for 1 second because I missed what you said about Hollywood Casino. I think you said that we would have to add them separately because you're saying they're the only one not in this section.
Right, so they do accept what we would consider in the vernacular to be off-track bets. So at the commercial track, Bangor Raceway, they can accept bets on simulcast races. So not races currently be conducted live right there, but they're being simulcast. So I would consider that to be an off-track bet, and that's how we talk about it. And so I had reached out to the lobbyist, Chris Jackson, and I inartfully asked my question during the hearing, and he said, yes, they can conduct off-track betting. But upon further investigation, it turns out that they can do that. They can accept those bets by virtue of their commercial track license. So they're not licensed under 275D, and they're not licensed under this separate public law that authorizes just Scarborough Downs. It doesn't say Scarborough Downs in it, but that's who has that license. So if you wanted to include them, I proposed some language in the technical part just because that was something people had talked about a lot. And I wanted you to know that there is a solution to that if that is somebody you want to include. If it's not, then they're not included now, so you're fine.
Okay, thank you.
And then Janet, I'd like to give some feedback on how you go through the chart. Since both bodies considered and voted on LD 1352 last session, and also members, the chairs and leads of the VLA committee have been invited to give us some feedback. I think it would be helpful if you can do as you've been doing, take us through the proposal in 585, but then it is helpful to me in understanding 585 and the policy decisions that we'll be required to make. If you can speak to us about the differences between 585 and 1352 as well. Just think it completes our understanding. Is that, committee members, are we okay with it proceeding that way? Not seeing any concerns raised. So let's go ahead that way, Janet. Thank you.
Okay, so in the proposal before you, it's just going to be off-track betting facilities, and you have that one question about whether to include Bangor Raceway, which is not technically an off-track betting facility, but accepts off-track bets. And then in 1352, there were 4 categories of entities eligible or persons eligible for the facility license, and that would be a commercial track, and this is what would include Bangor Raceway. An OTB, the same ones over here. A casino or slot machine facility, so that would be Hollywood Slots or the Oxford Casino. Or Hollywood is now casino too. It was originally a slot machine facility. We don't really have a slot machine facility in Maine anymore, but both are included in 1352. And then also any federally recognized Indian tribe in the state. So that is all 4 of the Wabanaki nations. And each of these could receive 1 facility license under 1352 as it is currently on the special appropriations table. And you might think, well, if I said each could only receive 1 license, why did I highlight the 7? Because there are not 7 OTBs now, so it allows for some growth. There's nothing preventing growth over here, but it's growth to as many OTBs or as many commercial tracks or as many federally recognized Indian tribes as there are, whereas in the proposal before you, there is an upper limit of 7 total licenses that could issue, if that makes sense. The second piece,
Janet, I'm sorry to interrupt you, but I think Senator Kime might have.
Oh, sorry. Yes.
And Senator Carney, if you would like us to not ask questions till the end, I can do that if you'd like. But my question was specifically on this one section, which is, I think you said in this section on 585 that it doesn't include Hollywood Casino, but then I just wanted to verify it doesn't include Oxford either, right?
Oh, right. I was just talking to the Bangor Raceway.
Right.
Because there was confusion about whether they were included or not. And upon further examination, investigation, they aren't.
Right. Okay. Thank you.
The person who drafted it may have thought they were included, but I'm really nothing. So for mobile operators, oh, there's another question.
Go ahead, Representative Libby.
Thank you, Madam Chair. Yeah, so Janet, then as written, 585 would change how casinos are currently functioning and could function in the future. It would change how they're able to operate by accepting sports wagers.
So 585, the way it's written, doesn't affect casinos at all. So casinos can operate as casinos right now. So 585 is this middle column. Sorry, it doesn't work to highlight the way I wanted it to. So this middle column is 585. There is currently no legal sports betting in the state. So all of this would be new law. If you were to adopt 1352, the casinos would be able to, as casinos, have a facility sports wagering license. So you could go into Hollywood Casino, Oxford Casino, and in addition to playing table games or operating a slot machine, you could also place a sports wager right there physically in the casino if they were to obtain a license.
Okay, thank you. That was a helpful clarification. Got confused.
The next category are mobile operators. So those operators are authorized to accept sports wagers from customers who are physically located within the state, and those wagers will be placed through mobile applications or digital platforms approved by the Gambling Control Unit Director. So if you look for 585, the proposal before you is that the only entities eligible to be an operator for mobile sports wagering would be federally recognized Indian tribes in the state, each of which would be allowed to receive 1 license, which would not be able to be transferred or assigned, except to a business entity wholly owned by the tribe with a principal place of business in Maine. If you look under the proposal that's on the special appropriations table, each federally recognized Indian tribe in the state could receive a mobile operator license as well as a
I think that Janet's video computer has frozen. Let's just give her a minute to reconnect.
I disappeared for a second. I do not know why.
You froze, and I think something happened, and you got
Sorry
reconnected.
about that. I know I talk too much. You don't need to kick me out of the meeting. So in the sports betting world, there are actual operators who have the license.
Janet, I'm sorry to interrupt you, but I think we actually missed the information that you were going to provide us on 1352 with regard to mobile operators.
Oh, okay. So in addition to federally recognized Indian tribes, which is the proposal before you, 1352 also allows a casino or an OTB or a commercial track to obtain a mobile sports wagering license.
Thanks.
So for management services licenses, this is an area that I learned about in the sports betting world. You might have a license if you're a casino, for example, or a better example would be an OTB. You might be eligible to get a mobile sports betting license or a facility license, depending on which proposal you're looking at, but you might not yourself in-house have the expertise to conduct the sports wagering, to set the VIG, which I will defer to Representative Evangelos to explain exactly how sports betting works with the percentages that everybody wins. He told me I could refer to him today because I know he knows this. But you might not personally have the expertise. So there is a provision in both the proposal before you and in the bill that's on the table to allow someone who is given the authority to obtain a mobile or a facility license to actually enter into a contract with a company, usually a company that has expertise in this area. And that company is called a management services licensee in these proposals. So those are entities that have to have sufficient sports wagering knowledge and experience, and they may obtain a license and enter into a contract with either a facility or a mobile operator to manage that operator's sports wagering operations. They're not allowed to subcontract any of those responsibilities to another entity. So if you are, for example, an established mobile sports betting platform, you could get a license from the Gambling Control Unit director, and you could enter into contracts with whoever obtains the licensed facility or mobile sports wagering licenses, and you would then enter a contract, and that would say, I will provide these services, I will provide my mobile app and all of the geolocation technology to make sure wagers are only placed by people located within Maine, and help set the odds to decide, what odds should be given for each bet. And then in order to do that, you first need to be licensed in Maine. So, and the contract that you enter into with the operator also has to be approved by the Gambling Control Unit director. So the proposal before you would include, above and beyond the requirement that the contract be included by the director, a specific additional requirement that if a management services provider who has this license enters into a contract with more than one operator, so more than one facility operator, for example, more than one OTB, or more than one mobile operator, for example, more than one really recognized Indian tribe, then the Gambling Control Unit director must approve the method that the licensee, the management services licensee, is going to use to separately account for each operator's sports wagering receipts. So I hate to use real examples because I'm not trying to promote or not promote any specific business, but I think it might be easiest to understand. That there are different things like FanDuel or DraftKings out there. If one of those, FanDuel or DraftKings or MGM or Barstools. There's a bunch of different companies. If one of them were to get all of the contracts with all of the different recognized Indian tribes under 585, that's before you. The question would be, when somebody would be placing a bet through the mobile app, which tribe does that bet get allocated to as far as income and the payment out of any winnings? And there would be a requirement that in the contracts, the director must approve how that's going to be determined. That's what that means. In addition, there's an additional provision that doesn't appear in 1352 that would require that the management services provider, so the actual operator of the sports betting, would not be able to receive more than 30% of the adjusted gross sports wagering receipts. And the adjusted gross sports wagering receipts are the amount of bets placed less the winnings earned and less any federal tax paid. So really the profit to the licensee. So the management service provider wouldn't be able to receive more than 30% unless the director concludes, after evaluating the proposal, that the receipt of up to 40% of those adjusted gross sports wagering receipts is commercially reasonable. And there's a little bit of language in the amendment to 85 about some of the factors to consider. So that's a little bit different from 1352 before you. It's sort of an add-on, if you will.
Janet, can we just check in and see if there are committee questions on that? Because that's a lot. And
Yeah.
It looks like there are at least one question. Senator Keim, go ahead.
Thank you. So I guess the way I'm understanding just that last piece that you talked about is that it's a hard stop at 40%. Like there,
Yes.
like so if there has to be review if it's over 30%, but there's a hard stop at 40%.
Correct.
And that is a protection, and maybe this isn't even a question for you, but I'm guessing that's a protection aimed at trying to contain this so it actually is tribal owned in reality and not just sort of on paper. I'm guessing that must be the point.
The testimony from Attorney Hinton on this point was, I think he said in his testimony, this is similar to a provision of the Indian Gaming Regulatory Act, which has limits to make sure that the income from gaming is kept locally to the tribe and not all outsourced. I don't know if the limits exactly match, but I think that's what his testimony was about. But obviously ask him directly if you want.
Mm-hmm. Mm-hmm. Yes, thank you so much.
Representative Moriarty?
Thank you, Madam Chair. I'm kind of hitting the saturation point as we compare 585 against 1352. So I have one question. 1352 is already enacted legislation sitting on the table. If 585 passes, is it also going to go directly to the table? And then is AFA going to have to basically fund one bill or the other, or in effect recommend one bill or the other?
So some of that's a political question, which I obviously won't get into, but I will first say 1352 was finally enacted in the House. It was not finally enacted in the Senate. It was because it goes to the table pending final enactment. So that final enactment vote never took place in the Senate. There were preliminary votes approving of all of the amendments and everything. So it wasn't like it wasn't approved in the Senate in some form. It just hasn't been finally enacted there. That would require it be taken off the table first. And then as far as everything else, I think in your questions were more political. That wouldn't be mine to answer.
Okay. Okay, thank you.
Representative Babbage, go ahead with your question.
Thank you, Madam Chair. Yes, Janet, so my understanding is 1352 has no caps. 585 does implement a 30% cap, but then leaves to one person whether or not that should be expanded to 40%, which technically could be a difference of millions of dollars still. But is that accurate?
It's mostly accurate. So there's nothing in 1352 as statutory language that would impose a cap. But the gambling control unit director would have to approve these contracts and may, currently it is a male, so I will just say he for short. He may think that there should be a cap. And in addition, the gambling control unit director is required by either proposal to adopt rules regarding the minimum requirements for the contract between the management services licensee and the operator, either facility or mobile. And it may be that there would be caps in the rule. I just don't know. It would have to happen through rulemaking or through the approval of the director. So it's not that there couldn't be a cap, there just wouldn't be one mandated by the legislature.
Thank you. And that would be in the control of the gambling control unit director.
Correct.
Thank you. Thank you, Jim.
Senator Craig?
So I had my own question, but then I was confused by Representative Moriarty's question just a little bit, and that's that 585, so 1352 went to the appropriations table, which I guess in just a one or two sentences, can you explain why it's costing money? And then I guess the assumption is that 585, since we're dealing with the same thing, must also have to go to the appropriations table.
Yes, that was the part I didn't answer. Yes, if it has a fiscal impact, it would be the same. Generally, it would go to the appropriations table. Obviously, the Senate can choose not to send it there. But, that's following what the body decides to do. But I will say, this was not something that was obvious to me when I started in this position. I've learned it over time. Bills that have costs, we all think of as going to the appropriations table, and there are costs involved with requiring to administer this program and to make all the rules and to do all the inspections and everything else. So there are costs involved with either proposal, but there are also revenues. And 1352 does have costs associated, but it has more revenues associated than costs, so it's revenue positive. But bills that have positive revenue impact still do go to the appropriations table. I believe, although you could ask OFPR better because they understand that process far better than me, I think it's so that the AFA committee can take into account sides of the balance sheet and minus sides of the balance sheet and to figure all of that out to make sure the budget's balanced, but I'm not the expert on that process.
Thank you. That was helpful reminder for me. And then, so then the question that I had myself was, when we talk about the provision in 585, it says each may receive one license. This is your bill analysis, which may not be transferred or assigned except to a business entity wholly owned by the tribe with a principal place of business in Maine. So I guess then I'm wondering, so online sports betting doesn't necessarily have a location, but then does it consider to be have a location? Because then this ties into sort of the tax implications in this same bill. So then if somebody works for this mobile gaming facility, they live on the tribal land, and they get paid for this business, so they're tax exempt, though they don't have to pay income tax for this. And then, so I'm just wondering how this wording then ties in with the tax piece, I guess. Is that
Sure.
something you can explain?
Yes, so the tax piece is about state income tax. So just to be clear, there are sports wagering taxes involved here, and those taxes that we're going to talk about later, the actual tax on the sports betting operation, that is not included in the tax piece. So there's no possibility of exemption. That tax would have to be paid. So that's one piece of tax. The other thing is, as far as the income tax, if you are a member of a federally recognized Indian tribe residing on tribal lands as defined in the tax piece, and your income can be sourced to tribal lands. Maybe you work for the mobile sports piece and you are doing that, and that's for the company, either the tribal government itself or the company that it's my understanding that the whole idea of allowing the tribe to transfer it to a corporation, I am not an expert in this. I know the tribal attorneys can talk to this, but sometimes when engaged in endeavors, the tribal governments like to form that separate corporation to engage in those endeavors. That's why there is a Section 17 corporation ability under federal law. So that might be the example of the corporation that would be formed to then be the licensee for mobile sports betting. So if you work for that corporation on tribal land, I would imagine that your income would be sourced to tribal land, but you could check with the Maine Revenue Services folks. And then yes, that income would be tax exempt, just as if you were to work for any other company. If you're residing on tribal land, you are a tribal member, and your income is sourced to tribal land under this proposal, your income would be tax exempt. But I didn't want you to think that the sports wagering income is tax exempt, because that is separately provided for. That's not income tax. That's not sales tax. That's sports wagering tax, and it's right in the bill. And that provision.
And that is the case even if they were to place this sports wagering business into a Section 17 corporation.
I believe so, because those have to be wholly owned by the tribe, and that's what the requirement is, that it be wholly owned by the tribe. Then the only thing that the tax piece says is that those Section 17 corporations are not subject to state income tax. State corporate income tax. So the sports betting tax is not state corporate income tax. It is sports betting tax. So it applies.
Okay. Thank you.
Representative Thorne?
Thank you, Madam Chair. And Janet, I'm going to apologize in advance. I was never good at algebra. And this seems like a formula. And if I don't get the formula now, I'm going to lose everything from here forward. But am I to assume that we're paralleling 1352 and 585 so closely that there are implications to one and the other if X and Y apply? Is that why? No, is that why they haven't gone through the Senate yet? Is it depending upon what gets amended or stated in 585 would have implications on 1352's passage, the end result?
I think these are proposals that, if they were both enacted, would be in conflict. So I do not know why 1352 is still on the appropriations table. That decision is completely out of my understanding or jurisdiction. But it is there now. If it were enacted and then this bill were to be moving forward, it could still be enacted, but then there would be a conflict in understanding, which controls. So that's the best answer I think I can give you on that question.
So it's fair to say that one would affect the other, or one would be altered if the other were to cover it, so that they didn't bump heads, as it were.
Yeah, they do authorize, different entities to get the licenses, and they do have some differences in, for example, the tax rate or this specific requirement that's shaded in gray on the screen. So in that sense, they are in conflict. And I just don't know if the bodies would enact both, but if they did, they would be in conflict.
Okay, thank you for that. I'll pay close attention. Thank you, Madam Chair.
Representative Libby?
Thank you, Madam Chair. So Janet, I'm looking at this and understanding that GCU is the gambling control unit under the Department of Public Safety. And I'm just wondering, so are the rules that you mentioned that aren't in existence yet, but that the GCU director would be overseeing. Are those major would those be major substantive rules, or would those all be considered minor rule changes? And then given that 585 is dealing with tribal licenses, would that come back to us? Are we going to be, if 585 goes through, will we then be hearing from the GCU with those rule changes, or where does that go?
Excellent question. So all of the rules to be adopted under the sports wagering proposals, both proposals, are routine technical rules. It's not possible for the legislature to review them, but they are routine technical rules. Just like any other rule, you could still review it through many different avenues. They're all routine technical.
Okay, thank you. That's very helpful.
All right, Janet, it looks, Janet, like we are done with questions on that section. Thank you so much for answering all of our questions.
Oh, no problem. So the next type of license, this goes all the way across because there's no difference between the proposals, is a supplier license. So only a licensed supplier would be authorized to sell or lease sports wagering equipment, systems, or services to licensed facility and mobile operators. Those equipment, systems, and services have to conform to standards established by the director by rule. And the rules could say that the director would say, you know, if it's been approved in jurisdiction X, that's also good for an approval here. A supplier may only sell equipment, systems, or services that have been tested and approved by an approved independent testing laboratory. As far as the license fees and terms, can you pause? Okay, there's one other type of license, it's the occupational license, but it's down on the bottom of this page, just so you know. So as far as the 4 types of license we talked about, the facility operator license, the mobile operator license, the management services license, and then the supplier licenses, so all the kind of like entity type licenses. The fees are different between the proposal before you and the proposal on the special appropriations table, only because the terms of the licenses are different. Otherwise, the fees are equivalent. So for example, a facility operator license is $4,000 for a 4-year term under the proposal in front of you. It's $2,000 for a 2-year term under the proposal on the special appropriations table. So the amount of money is not different. It's just the idea is under the proposal before you, all of these licenses would be for a 4-year term, and thus the fee set forth in 1352 is doubled. Does that make sense? So for a mobile operator license, it's a $200,000 license for a 4-year term. Anticipating a question, which maybe you won't ask, because I was in the VLA discussions on this. The majority of the market in sports betting is the mobile market. And so the fee was set much higher to get a mobile operating license because the potential profits are much higher as well. It's a much larger share of the market of who actually places wagers. And the management services and supplier licensees each have to pay a fee of $40,000 for a 4-year license term.
Janet, it looks like we have one question on that section. Representative Babbage, go ahead.
Yes, thank you. When Janet, when we're talking about licensing in this case, we are talking about state licensing, and that would be done by the Gambling Control Unit of the Bureau of Public Safety, which I assume would presently license like table games and suppliers and that type of thing. Is that true?
Correct.
Thank you.
Okay, so how do these licenses come about? Representative Babbage knew where we were going next. So first, there's the ability to obtain a temporary license, because as you're going to see, there's a lot of things that have to be checked to get your final license. So during that process, there's an ability for a temporary license under both proposals. And these temporary licenses are available for facility operators, mobile operators, suppliers, and management services providers. So all the categories we talked about above. Under the proposal before you, the director may issue a temporary license upon payment of the initial license fee as long as the director is not aware of any reason that the applicant may be ineligible for licensure, and if the applicant meets the requirements established by rules. So we're going to get to the rulemaking summary later, but one of the types of rules the director is directed to make is to make requirements, like sort of the minimal requirements to get this temporary license pending the investigation for the full license to be issued. A temporary license lasts for 1 year until the final decision on the application, whichever is shorter. So the difference between what you just heard and what's on the special appropriations table is, remember, these temporary licenses could be for facility operators or mobile operators. Facility operators are accepting bets within a physical location in the state. And so the proposal that's on the special appropriations table says that a federally recognized Indian tribe would not be eligible for a temporary facility operator license unless the tribe has a license to operate high stakes Beano. So I just want to scroll back up to the top for a second so that hopefully I can make that make a little more sense. If you look at who's eligible for a facility operator license, there's a licensed commercial track, an OTB, or a casino. These, by definition, have facilities that have been approved for some kind of gaming in the state. Not all of the federally recognized Indian tribes are currently operating a facility where gaming occurs in the state right now. So what the proposal that's on the special appropriations table did is say that you can get the temporary license for these facility wagers if you are somebody who has an approved gaming facility in the state. If you're wanting to look specifically at the proposal before you, the facility operators and the mobile operators, all of them are eligible for the temporary license as long as they meet those minimum requirements that are going to be by the director by rule. The off-track betting facilities do by definition have a place that's located in the state that's been approved for wagering. And the federally recognized Indian tribes are eligible for the mobile license, and there wouldn't be a need for a facility to be pre-approved because there isn't a facility involved in that where wagers are accepted. It's all on mobile applications or over the internet. So because of that, I did just want to explain the proposal on the special appropriations table does require, if the tribe would want a facility operator license, it needs to have a high stakes Beano facility in order to get the temporary license pending final approval. That same requirement doesn't apply to the mobile operator license for the reasons I tried to explain before, although there's a kind of policy reasons. That's my understanding of why that decision was made. You should ask the VLA folks who are here though, because they know why they voted for it that way. That was just the discussions I heard. Now, as far as background investigations, to obtain any of these licenses, there's a lot of detail in both provisions about the background checks that have to go on. So applicants have to disclose the identities of and consent to fingerprint-based background investigations of the applicant itself, each person that owns at least 10% of any corporate applicant or who has the ability to control the corporation's activities, and then each direct or indirect owner of a non-corporate applicant whom the director determines has an ability to control its business operation, and then all key personnel with significant influence over the applicant's relevant business operation. So the idea is if you have control over how the sports wagering is going to be conducted, if you think just basic principles of gaming, you don't want people who have sort of backgrounds that might suggest they might want to fix bets or things like that. You wouldn't want them to be issued licenses. Being very basic here, because I don't actually, I'm not actually involved in gaming, but that's the way I understand this provision. There's obviously a lot more considerations going on. So that's why you pick these people, or that's why they're listed in the provisions before you as the people whose backgrounds need to be checked. And then the grounds that are directed for denying an initial license or license renewal application, or for imposing administrative sanctions, for example, a warning on a licensee or a license suspension or a revocation on someone who is currently licensed as a supplier or an operator or anything else. There's a whole list of them. So if you include knowingly a statement on your application that you know is false, or you fail to disclose required information. For example, if you have a silent partner who owns at least 10%, well, it'll probably be who is an owner of your non-corporate applicant. You have a silent partner and you don't disclose that they're really controlling the business, and that's later discovered. That could be grounds for some kind of administrative sanction or for denying your renewed license application. Any past revocation of any gambling related license by any government authority, if that's discovered, then that could be a ground to not issue you the license. Past felony convictions or other convictions involving dishonesty, deception, misappropriation, or fraud. Past convictions for gambling crimes in any jurisdiction. Being a fugitive from justice, drug user, persons with substance use disorder, illegal alien, or dishonorably discharged from the U.S. Armed Forces. Not being current in your payment of taxes in any state or for federal taxes. Not being of good moral character, which is described as having evidence of dishonesty, lack of fiduciary care, and there's a list in the proposals, but they're identical. That's why this provision goes all the way across the chart. Having any violations of any provisions of the sports wagering laws or rules in Maine, then those could all be grounds. If there's something that pre-existed your application, to not granting your application in the first place, or not granting your renewal application, because each license only lasts 4 years, or for imposing a fine or some kind of administrative sanction. And then the types of penalties are up to $25,000 penalty for violations of the sports wagering statutes or rules. So all of those investigations and then administrative sanctions have very similar provisions. Does that make sense?
Yeah, thank you. Yes.
The next type of license, the last type of license, is the occupational license. So this is the license to the employee. So an employee engaged directly in sports wagering related activities must obtain an occupational license from the Gambling Control Unit Director. Under the proposal before you, this would be applicable to facility or mobile operators. Under the version on the special appropriations table, only the employees of facility operators are required to get this license. And then the fee would be an initial $250 fee that matches in both proposals. The renewal fee would be $25 for 1 year or $50 for 3 years under the proposal before you now. Just so that you know, this is a change that was made. Their casino employees are currently required to have occupational licenses, and this change was just recently made to the casino employee renewal fees. So I'm assuming that's where this derives from in the proposal before you. But the renewal fee is just $50 for 1 year under 1352. There is an exception in 1352 that is not in the proposal before you because it just simply wouldn't apply. And that is if you are a licensed casino employee. Remember, a casino has the ability to get a facility or a mobile operator license under 1352. So you might be a licensed casino employee who's also working on sports wagering related activities. And this exception says you don't need to get licensed twice. If you got the casino license because they did all the background checks on you, et cetera, and so forth, then that license is good enough to also be engaged in the sports wagering related activities of the casino. The next requirements in both proposals, they're identical, are about house rules. So operators, those are your facility and mobile operators, must adopt comprehensive house rules that meet minimum standards established by the director by rule. And these house rules might include specifying the amount to be paid on winning wagers, the effects of schedule changes. So for example, if you placed a bet on, this shows my complete ignorance of actual reality. I often understand laws, but not how the real world works. But I don't know if the Super Bowl is ever canceled due to weather or postponed. But let's say you placed a bet on the Super Bowl. What happens if the schedule changes and it's postponed? How is that going to affect your wager? That kind of thing has to be in the house rules. What circumstances would allow you to void a wager or require you to void a wager? The treatment of errors or late wagers and related issues, all of those would have to be described in house rules, and then anything else the director requires by rule to be explained in the house rules. And those must be approved by the director, advertised, and readily available to customers. So those are sort of protections to the customers so they know in advance what rules are going to apply to their bet. There are also provisions in both proposals, and they're identical, about who may not place sports wagers. So a mobile operator and a facility operator, both kinds, cannot accept sports wagers from anyone under 21 years of age. Any athletes, participants, or officials involved in the sports event that is subject to the wager. Any operator or management services licensee, employee of such a licensee, and persons living in their households, they can't place bets. Although if you're somebody living in the household of an operator, for example, maybe you live in the household of the owner of an OTB, you just can't place your wager through your spouse or your parents or your cousins. If you live in their household, you can't place a bet through their OTB, but you could through a different one. So that's how that's written. The director could also define other interested parties by rule who can't place wagers, and those could include the owners and employees of the teams that are part of the event, the owners and employees of other teams in that league, or the owners and employees of the league itself. That would all be worked out through rulemaking by the director of precisely who is too interested in this event to be allowed to place a bet on it. There are also provisions in both proposals to have a list established by the director of people who cannot place wagers. And you could, if you are worried about your gambling habits, voluntarily ask to be placed on the list. And then the mobile and facility operator would not be allowed to take your bet. And then also you might be placed involuntarily on the list under some standards established by rule. There is a similar type of list with voluntary and involuntary placement. For example, for casinos right now, you can voluntarily ask that casinos not allow you to go wager in their facility. There also is a prohibition in both proposals that if you are a third person, you can't make a wager on behalf of or as the agent or custodian of another person. So for example, the Sports Betting Alliance, I remember I showed you that there was testimony submitted late in answer to some of your questions. One of the things that they included in their testimony was an explanation of the geolocating provisions that the mobile operators use, because you're only allowed to accept bets on somebody physically located in the state. And there is all of this technology used to make sure they know exactly where you are physically located when you place your bet. So I have heard of former legislators, for example, who used to drive to New Hampshire once a week to go place their sports bets because they're not allowed to in Maine and you can in New Hampshire. And when you try to use your phone to place that sports bet and you're located in Maine, the New Hampshire sports books know that and they can't accept your bet. So what this provision does is it says you can't call somebody up. So if you live in a state where sports betting is not legal, you can't call me up and I'm physically in Maine and say, Janet, place a bet for me, because I would be prohibited from doing so. So if anybody found out, I'd be in trouble. And the operator would be in trouble, more importantly, for taking my bet. And then anybody who's an employee of the gambling control unit would not be allowed to place sports bets. There are also provisions in both bills that are identical about the types of events that can be subject to sports wagers. So those are professional, collegiate, or amateur sports or athletic events, including international events, so like your Olympics, motor vehicle races, and esports. Just for anybody listening who had to listen to me talk about this in VLA, it went out on the Twitter sphere, I think it's called, that I don't actually know what esports are. So that was a little funny incident in my past. Everybody here in Opla said, Janet, you were on Twitter, because everybody said you don't know what esports are. I've learned a little more since then, but I am not the expert on what an esport is. As far as exceptions, wagers may not be accepted on a high school event, an event with a majority of participants who are under 18, or a collegiate level event in which a main team participates. But wagers would be allowed to be accepted on games and matches in a tournament in which a main team participates, as long as the main team is not participating in the game or match. So for example, over the weekend, Colby hosted the NESCAC championships in men's ice hockey. And there was a game that I saw as an alum of Williams, and Williams lost, very sad, but Williams was playing against Trinity, and both of those teams are not located in Maine. So a wager could have been placed on that event, even though Colby was participating in that tournament. They weren't participating in that game. They played later and then won, although they did lose the final. Very sad. Other prohibited wagers for events with a sports governing body in the United States. Operators may not accept wagers on injuries, penalties, or outcomes of disciplinary or replay rulings. So those are just categorically decided as events that, as a legislature, you're saying we do not want bets on those types of activities. In addition, a sports governing body may request that the director prohibit certain other types, forms, or categories of wagering if it demonstrates good cause to believe that the wagers are likely to undermine the integrity or perceived integrity of the sporting event or governing body. The director must consider comments from operators for each of the requests made to eliminate a category of wager because they believe it undermines the integrity of the sport, but it can provisionally grant the request while it's making the determination if it's more likely than not that good cause will be shown. I can't think of an example off the top of my head, but this is a protection to make sure that the integrity of the sports event is preserved, even if it's not something like accepting a wager on an injury. There may be other types of wagers that you wouldn't want to accept, and there's a process here for the Gambling Control Unit director to work out those questions.
Janet, I see that we have one question, so we'll pause there. And Representative Babbage, go ahead with your question.
Thank you, Madam Chair. Other prohibited wagers. I was wondering, Janet, if the industry, or specifically here as it applies to what is proposed for Maine, has caps on the amount of wagers.
So the amount of the wager is something that the Gambling Control Unit director is specifically directed to consider whether to adopt a rule about.
Okay.
So there
we
obviously the director
Okay.
can adopt rules on many things, but that is a subject that the legislation specifically says consider whether that should be a rule.
Thank you.
So abnormal wagering activity, under both proposals, operators must report abnormal wagering activity that raises concerns about the integrity of the sports event or potential match fixing to the director and to the relevant sports governing body. Operators must use commercially reasonable efforts to cooperate with investigative relation information requests from law enforcement and sports governing bodies who are trying to figure out, for example, if there's match fixing going on. Information shared with the director by sports governing bodies for purposes of investigating or preventing this type of abnormal wagering conduct must be kept confidential by the director unless disclosure is required by the director, directed by the law, or the sports governing body consents to disclosure of that information. You can see that's a public records exception. This is one of the ones that I alluded to earlier that this committee reviewed for 1352, but you would still need to review it anew if this proposal goes forward. In addition, information shared with the sports governing body by operators must not be used for commercial purposes. So if you're a mobile sports betting operator and you share some of this abnormal wagering activity information, the sports governing body can't then use that sort of commercially against you, and may not be disclosed except in conducting and resolving these integrity related investigations, or it could be disclosed to the public to preserve the actual perceived integrity of the sports events of the body after notice to the operator and an opportunity for the operator to object to the disclosure. So if there's a concern that there might be some kind of match fixing or other thing that involves the integrity of the sports event, there's all these information sharing provisions, but then some restrictions on further sharing to make sure either that confidential things must be confidential or to make sure that the perceived integrity of the sport is kept, high so that people will believe in those sports events. There are record keeping requirements provisions. So in addition to requiring the director to establish record keeping requirements by rule, which I'm going to talk about all the rule provisions below, operators must also use commercially reasonable methods to maintain the security of wagering data and customer data, but must also maintain itemized records of all wagers placed and abnormal wagering activity for 3 years and video recordings of in-person wagers for at least 1 year. Operators must make those records available to the director upon request or as required by a court order. In addition, the operators have to maintain anonymized but itemized wagering information in real time and disclose this information to the director upon request or to the relevant sports governing body if it's conducting some integrity monitoring purposes, and if the sports governing body informs the director that's going to use the data for that purpose. So this is how the sports governing body might in fact realize that there is a potential for max fixing or some other sports wagering activity that gets to the integrity of the event, because there's some information sharing here that could go on. I don't know if Representative Babbage still has a question or not.
I actually do, Madam Chair, if that's possible.
Yes, go ahead. I thought it was residual. Go ahead.
Yeah, I'm sorry. It originally was, but Janet, so can you explain to me whether FOA is applicable here? I'm trying to determine if necessary information that the state should know is accessible, and also if the press would have access to that information.
I could do that now, or there is a whole piece later on about
No.
FOA, so I don't know.
Let's be efficient. Sure, I can hold on. Thank you.
Is that okay, Senator Carney?
Yes, I think that makes a lot of sense, Janet. Thank
Do
you.
not mean to be usurping your role.
No, I think you're right on.
So there are some advertising restrictions in both legislative proposals. So I'm going to start actually with a proposal on the special appropriations table. So in 1352, there's a provision that would be in statute that would say that signs and ads about sports wagering may not be misleading, deceptive, or false. They may not include advertising with a high probability of reaching or designed particularly to appeal to persons under 21 years of age, and they may not be within 1,000 feet of the property line of a school. And the Gambling Control Unit Director could also adopt rules to implement those those prohibitions. The proposal before you is different in that all of these advertising restrictions are just through rulemaking. They're not in statute, other than the statute directing the rules to be adopted. And the rules must prohibit misleading, deceptive, or false ads. They must require an operator to disclose that it's the licensed OTB, so that would be the facility operator, or federally recognized Indian tribe or corporation wholly owned by the federally recognized Indian tribe. So those are going to be your mobile operators. So you'd have to disclose who is the operator. And the rules would have to govern the restrictions to the extent permissible of advertising with a high probability of reaching or designed particularly to appeal to persons under 21 years of age. There's a provision later on at the very end of the bill analysis that talks about these advertising restrictions. And it's been pointed out to me in recent months, but after 1352 went through VLA, that there was a case about tobacco related advertising restrictions in Massachusetts that went up to the US Supreme Court. It's a Lorillard case that's cited later on in the bill analysis. And there were restrictions in Massachusetts, for example, of advertising, I can't remember if it was cigars or something like that, within 1,000 feet of the property line of a school, and the US Supreme Court struck that down. It said that those types of products were legal for adults. And so you have to balance First Amendment rights of the commercial entity and also of the adult to purchase a product that is legal to them versus the state's clear interest in preventing underage, in that case, tobacco use. In this case, it would be sports betting. And so categorical type bans were not favored. There has to be more of a balancing test. I'm guessing that's why this is written this way, to say that the rules as far as restricting advertising reaching minors must be to the extent permissible to allow for that balancing test to occur.
Senator Keim, go ahead with your question.
Thank you. Jana, is there any difference in how this is actually plays out by having it having rules adopted versus by statute?
Well, if it says by statute that the ads and signs may not be within 1,000 feet of a property line of a school,
Right,
unless and
that,
until,
that part I understand is very specific and understand why they might not have put it in the new bill, but then other than that, it's attempting, I think, to sort of mirror the same outcome, but one is doing it by statute and one is doing it by rule. So I just didn't know if you were able to help me understand the difference between those two avenues specifically.
right, well, they're very, very close. They're very similar, especially because the director can adopt rules to implement these provisions under 1352. But if the director were to say that there's no way to restrict any advertising with a high probability of reaching someone under 21 years of age, the statute would still provide for that if 1352 had been adopted. So unless and until a court were to strike down that statutory provision, then you could only do the backup of the rules. That's the slight difference. It's really maybe nothing in reality.
Okay.
But,
all right.
and then
Thank
of course there's this additional requirement that's not in 1352 to disclose who the operator is. Because remember, you might use a management services licensee. So for example, I hate to use real business names, but they make it clearer. I'm not promoting any business or not, but MGM has a sports betting book. There's FanDuel, there's DraftKings, the mobile kind of applications. If you place a bet on that, you wouldn't necessarily know if 1352 were enacted, is that bet like allocated to one of the casinos, to a commercial tract, to a tribe? You might know, but you might not know. And so this proposal says you also have to disclose who the bet's being placed with. Does that make sense?
Yeah, that was helpful. Thank you.
So there's a lot of required rulemaking and they're equal in both proposals. So there's a lot of different topics that the director of the gambling control unit has to adopt routine technical rules addressing. So any additional qualifications other than the ones in statute for all the different categories of license. Remember, we talked about there will be qualifications, sort of minimum kind of qualifications and the procedures for obtaining those temporary licenses. There would be directed for the director to make rules about sports wagering operations methods, including, this is something I think Representative Babbage talked about a little. Oh, no, that's the next bullet point, sorry. So there could be rules about the authorized wagering systems, whether credit cards or checks could be used, what receipts have to be kept, rules for the protection of patrons, for the promotion of social responsibility, requiring the display of resources about problem gambling at each facility and on each mobile application or digital platform. Here's what Representative Babbage mentioned. There could be a rule establishing a maximum per event per person wager if the director deems that necessary. So it's not a requirement, but the director is directed to consider it. Standards for the House rules and procedures for the approval of House rules, as we mentioned a little bit before. Some minimum design and security requirements for the facility sports wagering, including the premises security, if there will be a self-service kiosk so that you just go up to that machine to place your sports wager, you're not interacting with a person. What are the requirements for that kiosk? How are you going to prove your identity and age? Identity is tied to the age because you have to be over 21, remember, and then you also can't be one of these interested persons. How to require a refund of any wager placed by a prohibited person. So the design is, remember, there's all those folks who can't place a sports bet. The operator doesn't just get to keep your money, they have to give it back. Identification of interested parties. Remember, there might be others like league owners and things like that who might be prohibited from making wagers, but the director has to decide who those folks will be through rulemaking. For sports wagering equipment, there would have to be minimum design, security, testing, and approval requirements in rulemaking. Remember, we talked about the contracts between the operators who have the license and then the management services providers. So the minimum requirements for those contracts would have to be established in rule. minimum internal control standards and record keeping requirements so that there can be auditing of the records of the sports books would also have to be set forth in rules. And then the establishment of a list of persons, remember, who can't make wagers, including how you voluntarily get on that list and also how you involuntarily get on that list and how you can get off of the list. And then there is a provision at the very end of both pieces of legislation that would allow the initial rules to be adopted through emergency rulemaking, I think designed to get the market up and running as soon as possible. There also is a provision for child support interception. So if you place a sports wager and you are lucky enough to win, and your winnings are at least $600 and at least 300 times the amount of the wager, or winnings that less the wager amount of or at least $5,000, then the operator has to coordinate with a child support registry to determine if you owe liquidated child support debt. And if so, your wagers would be sent to offset that debt first, and then you could get any remaining winnings.
Janet, could I ask a question about that, please?
Sure.
Is there a similar child support interception provision related to other types of wagering than the sports wagering?
Yes, for casinos and I think even off-track betting, but some of the harness wagering as well. That actually, this child support interception involves some sensitive information like social security numbers and things. So it's part of the public records exceptions. So it's explained more in the memos that were sent back and forth between BLA and the Judiciary Committee last time. I just don't remember off the top of my head, but I know there are other provisions that this is modeled on.
Thank you.
And actually, we just did a bill about this for lottery offsets. So if you win lottery proceeds, similar. Okay, so then the tax piece. So first, it's important to understand what the tax is based upon, and that's the adjusted gross sports wagering receipts, which is sort of a mouthful. But what does that actually mean? You calculate that by saying, what are the total wagers that were accepted by this operator? And you subtract out any winnings they paid out to the winners or any federal taxes they paid. So basically, you can think of it as their profits. All of their profits are what you use as the tax base. And the facility operator tax is identical between both proposals. So it would be 10% of those adjusted gross sports wagering receipts. 1% of those adjusted gross, I'm not going to keep saying that. 1% would go to the general fund for the administrative expenses of the gambling control unit. 1% would go to the gambling addiction prevention and treatment fund. 0.55% would go to the fund to supplement harness racing purses. 0.55% would go to the Sire Stakes Fund, which is another harness racing related fund. 0.4% would go to a newly created agricultural fair promotion fund, which is a fund that goes out to certain agricultural fairs that have been around for a while and help support them in the promotion of them. And then 6.5% would go to the general fund. And that's identical in both proposals. There is a difference in the mobile operator tax, however, between the proposals. So the proposal that's on the special appropriations table, 1352, has a 16% tax. And the proposal before you now has a 10% tax. So it would match the facility operator tax. And because it matches, all of the exact same amounts go to the exact same places. Under the proposal before you, the increased this extra 6% in 1352, all of that money goes to the general fund, but every other piece here is the same. So no matter whether you're a mobile operator or facility operator under either proposal, all of these things and above, sorry, I'm not highlighting very well, all of these things are the same. 1% of your profits would go to the administrative expenses, 1% to the prevention and treatment fund, these amounts to the harness racing and agricultural interests. What's different is how much goes to the general fund. Under the proposal before you, it's 6.5% of the profits for a facility or a mobile operator. Under the proposal on the special appropriations table, it's 6.5% to the general fund for a facility operator and 12.5% to the general fund for a mobile operator. Hopefully that made sense.
It does, and I see we have a question. Representative Babbage, did you have a question?
Yes, thank you, Madam Chair. Janet, you mentioned gross sports wagering receipts, and you mentioned winnings and taxes being deducted from total wagers. When we talk about casino income, they have a line that's net income, and I assume that means including all expenses of employees and so forth. Would that be true here as well? I mean, is this truly a profits determination? Do you know?
So this is truly a profits determination. I am not aware of any casino tax that would subtract out the overhead expenses. There are two. So I'm remembering slightly off the top of my head. I know there are casino folks monitoring this work session, but there is, for one of the casinos, I can't remember which one, there's a 1% off the top where you don't subtract out taxes or anything else. And then the rest is sort of the equivalent here and adjusted income, so net income, but it's not talking about it overhead expenses. It's just talking about.
Well, that may have been my misinterpretation. I assumed net income meant true profit, not including overhead, but your interpretation would be that overhead is not included when we talk about this determination.
Correct.
Thank you. And the second question I had, if you don't mind, Madam Chair, in the 585 mobile operator tax, it is shaded. Is that an amendment that changes that number from a different number?
Right. So the mobile operator tax in 585 is exactly identical to the facility operator tax. That is not true. In 1352 adds 6% more to go to the general fund. And so because it's the difference between the two, I shaded both. Normally I only shade one side, but this is such a small 16% that I shaded both so you could really see that that's where the difference was.
The 10% matches, and that's not different than the original bill.
The 10% facility operator tax, so the facility operator taxes are 10%, they're identical in both. The mobile operator tax is different. So it's a 10% tax under the proposal before you. It's a 16% tax, so 6% more under the proposal on the special appropriations table. And where does that extra 6% go? It all goes to the general fund. Everything else is the same.
I see. My question really was, it didn't used to be 16 and 16 or 16 and something different. That 10 is merely the same as above, and you're just highlighting it for us. Thank you. Thank you. Appreciate it. Thank you, Madam Chair.
Now, as far as penalties that could be imposed for unlicensed operation of sports wagering, it's important to know that these penalties, they're just pulled in from current law. They're penalties upon the operator. They're not penalties for placing a bet incorrectly. So there's an unlawful gambling statute right now in Title 17A, Chapter 39, and it says the person, not the bettor, who intentionally or knowingly profits from unlawful gambling activities guilty of, could be convicted of a Class D crime. So if you're an individual, that's an up to $2,000 fine and 1 year of imprisonment. If you're an organization, that's up to a $10,000 fine. Apparently, we do not throw organizations in jail. And you have to forfeit all of the income that you unlawfully profited. There's aggravated unlawful gambling, also in Title 17A, Chapter 39. And it's the same as above. So a person who's not the bettor intentionally or knowingly profiting from unlawful gambling activity, except it's aggravated if it involves receiving or accepting more than 5 bets that total more than $500 in value in 24 hours. This is a Class B crime. So that ups the fines to $20,000 for an individual and $40,000 for an organization. And if you're an individual, you could subject to up to 10 years of imprisonment, and you still have to forfeit all of your income that was involved here, not all of your income in your whole life, just this unlawful gambling income.
Janet, can I just ask quickly? So we're neither 585 nor 1352 is changing this. This is just referring us for our education back to 17A. Is that right?
Correct. I can't remember if it says those apply. It may specifically say that. I looked directly at my bill analysis for 1352, which was for 1352 and many other bills that were pending at the time, and tried to pull the things that I thought would be important for you all to know the details. The penalties provision was something that had been mentioned in the chief executive's veto letter when there was a prior sports betting bill that was enacted and then vetoed and didn't, the veto was sustained. And there was concerns from the chief executive that the penalties were not significant enough. And the suggestion was, I can't remember if it was directly in there or this is what BLA took out of it, was to maybe use these existing crimes because the proposal that had been vetoed said that these crimes don't apply and there were different penalties and they were not to the chief executive's liking.
Thank you.
So for anybody who remembered it, I wanted you to know that this is what's in there and it's in both.
Thank you. Senator Keim, go ahead.
Thank you. My question is actually one step previous to this, and that's the mobile operator tax. So the difference here between, so the general fund in 1352 gets 12.5% and under 585 gets 10%.
I'm sorry. I maybe shouldn't have abbreviated it this way. So if you look at the chart above for the facility operator tax, it shows you where all the 10% goes. That's going to be absolutely identical in 585. So it's 1%, 1%, 0.5, you see there. Then this last item is general fund. The only difference in 1352 is that this last number for general fund is 12.5% for a mobile operator if you're looking at 1352, and it stays 6.5% for a mobile operator if you're looking at 585.
Okay.
So there's a 6% more tax rate, and all of that extra money goes to the general fund.
Right, in 1352. So so I have no idea what kind of money we're talking about here, the difference between the 6.5% to the general fund versus the 12.5 to the general fund. And so at some point I would like to find out that information, the difference between those two. I would imagine that in 1352, that was already part of the fiscal note, is some sort of assumption on how much money would come in.
Correct.
To the general fund. And so then I guess once we got a fiscal note for 585, we could just compare the two.
Yes, I think that would work because I know I gave you a link to the fiscal note somewhere in this bill analysis, not forgetting where at the moment. I think it's lower, but I can't remember if it broke out the revenues by mobile versus facility. It might have just said, this is going to be all of the revenue to these kind of funds. And so therefore we need more information from the Office of Fiscal and Program Review on exactly how that affects here. I don't know that we could straight calculate it by looking at the fiscal note. We might need more information.
Okay, thank you.
Representative Babbage, did you also have a question?
Just a quick one. Thank you, Madam Chair. Janet, do we know if that 10% or even 16% is in line with what's been enacted in other states?
So the BLA committee did look at that in other states. I cannot remember all of the data on that. If you can hold 1 second. Can you hold 1 second?
We can.
Thank you.
Yeah, so there is a chart that was given out along with the bill analysis. I emailed it to all of you. It is linked lower, so let me scroll down. Sorry. You asked me, here's Senator Keim's question. The fiscal note is right here. So there is a chart of other states' sports betting laws. I'm going to switch to that for just a second. This was prepared by our researchers for 1352, and that there's a tax rate column here that shows you what the different tax rates are, and they're all over the place.
Thank you.
And you can then compare there. And sometimes they have different tax rates and sometimes they don't, depending on mobile or facility, and you'll just be able to compare that for yourself. Sorry
Thank you.
for-
I will find that. Thank you.
Shall I go on?
Yeah, I think so. Do you need a seventh inning stretch? We're almost to the conclusion. Are you good to keep going?
I'm fine to keep going if you're fine to still listen to me.
Let's move forward then. Thank you.
So I listed here the requests for information that you had and the answers that I received to them, which weren't to all of the necessarily to all of the questions, but there is information on the annual gaming revenue from Hollywood Casino and from Oxford Casino and the Gambling Control Unit's annual report. As I read that report, it will tell you starting on page 10 how much money the state gets from these operations. It doesn't tell you, as I read the report, how much money those entities make sort of before they send their money to the state. Mr. Walker's testimony did have a chart on the last page. You'll have to blow it up a little because he tried to fit it on the page. It's a lot of information, so it was hard to do. But it gives a lot more detail on exactly how much money they get for the slot machines and for the table games on a month-to-month basis over the last year, I believe was what was included there. You did ask Mr. Mandel from the Sports Betting Alliance, who emailed me this morning that unfortunately he's not able to be here today, for information on the illegal sports betting market. That's where I showed you if you sift or sort all of the information in the electronic committee file and look for the last piece, you will find Mr. Mandel's information there. And I can go through that now, or you can just know that it's there. I look for direction from the chair because he's not here to give it to you.
I think we can look at it later on our own.
Okay.
It's pretty clear and easy to follow.
Then you asked for the bill analysis for 1352, the chart we just talked about, the fiscal notice here. It gives you some idea of the revenues that were available. And do understand one thing to be aware of when you look at the fiscal note to this bill is some of the revenues are going to talk about licensing fees. And if you change the number of entities eligible to get a license, you change the number of application fees you're going to receive as a state for those licenses. And when you switch it to a 4-year cycle rather than a 2-year cycle, you change like when you're going to get the money. So you might get it now and then not any more application fees for another 3.5 years, until the next term. So that's something to think about there. And then as well, as Senator Kime pointed out, there is a decrease in the general fund share of the mobile sports wagering profits. So in that tax rate, so that is something that will be different, but this will at least be a good start to understanding the fiscal implications. There was a question about whether this proposed amendment to 585 would allow or would change the fact that the Passamaquoddy tribe and Penobscot Nation receive a portion of the Oxford Casino tax cascade. And the answer was presented to you, that the answer was no at the public hearing, but I wanted to give you the link to the language so that you could see and confirm it for yourself. So right now, 4% of net slot machine income from the Oxford Casino is transferred to those 2 tribal governments. Under that law, it says a little bit later on, there's like a numbered paragraph. It says that if the recipient of these funds, and there's some other paragraphs included, so there's some other recipients included, but if they own or receive funds from a slot machine facility casino other than Oxford County's casino or the one in Bangor, then the recipient may not receive funds under this subsection, and those funds must be retained by the Oxford County Casino. But as I read the amendment to 585, it doesn't allow either Penobscot Nation or the Passamaquoddy tribe to have a slot machine facility or casino, so that would not trigger this, and they would continue to get money from the Oxford Casino tax cascade. Here's a question about whether Bangor has an OTB, and the answer that I got from Henry Jennings, the executive director of the Harness Racing Commission, was that they do accept those bets, but they're not considered an OTB because they accept bets on simulcast races as part of their commercial track license. The Bangor Raceway does. So I gave you language a little bit below. If you want to consider including them as a potential recipient of facility license or even a mobile license, however you wanted to amend it, there's some language we could use to include them as well. There were some questions that were posed to the governor's office after the hearing, and I just included them here. There were some questions about the fiscal impacts of the Collaboration Act piece, which was Part A, about whether there was an anticipated fiscal cost. And this is where I mentioned that the governor's office said that the tribal liaisons would be appointed from existing staff rather than hiring someone new, and that everything else that they indicated would be performed with existing resources. So this is sort of a preview before you get the fiscal note of what you might anticipate. That obviously OFPR will look at that and decide whether they agree, and they will give their independent determination of whether that constitutes a cost to the state. And there was also a question about whether there will be any fiscal impact to the state entities for all of the other requirements of the Tribal State Collaboration Act. And the answer was it would be a relatively small impact to the general fund and some expenses by the main revenue services to administer those tax provisions. So then here's the language if you wanted to include Bangor Raceway as a potential facility sports wagering licensee. You could do it this way, or you could just say a commercial track, or you could say the commercial track that offers these simulcast racing bets. This was my recommendation about the tribes deemed acting in a government capacity. So this is a tax piece, if you want to remember. What this piece is, I think it's in section C10, yeah, section C10 of the proposed amendment. It says that for purposes of Part 3, those are your sales and use tax, and Part 8 of this title is Title 36, the tax laws, and Part 8 is the income tax laws. It says notwithstanding under the current draft, a particular provision in the Maine Implementing Act, the Passamaquoddy tribe and the Penobscot Nation are deemed to be acting in a government capacity and not in a business capacity. I don't think you need to notwithstand the Maine Implementing Act to get that effective. And it's confusing to notwithstand the Maine Implementing Act because the Maine Implementing Act governs. But what the Maine Implementing Act says right now is that when those particular two tribes are acting in a business capacity, they would be subject to tax, and not when they're acting in a government capacity. And there's nothing preventing the state tax laws from making a rule about when those capacities are being acted in. So that's sort of what this proposed language changes is to say it's sort of a rule of tax law, that this is what we're going to be deemed the capacity that they're acting in. So it's not substantively different. I just, as a legal thing, I would think it makes more sense to draft it this way. You can obviously disagree. And this is one where the governor's office proposed technical amendments would add another sentence about the whole ban of Maliseet Indians to the same effect. And then as far as public records exceptions reviews, I promise I didn't forget you, Representative Babbage. There are some sports betting pieces that implicate public records exceptions. And as I mentioned before, you previously approved those exceptions or didn't express any concern about them when you reviewed 1352. So the specific provisions that create public records exceptions is first, there's a provision that allows the director of the gambling control unit, requires the director of the gambling control unit to keep confidential criminal history record information of applicants for sports wagering licenses, including the results of fingerprint-based background checks. I know that I personally have been the analyst for several bills that have come for public records exception reviews involving fingerprint-based background checks. I know you hear that a lot, that there are federal laws governing the confidentiality of such information. So that's the type of thing you've heard a lot before. There's also a provision of this proposal that was also in 1352 that requires the director of the gambling control unit to keep confidential information provided by a sports governing body for the purposes of investigating or preventing abnormal wagering activity. So when the sports governing body shares that information so that that investigation can go on, some of that's sort of thought of as proprietary information.
I get it.
That would be kept confidential. And then there's also the information involved with the child support interception. And this is a provision that's modeled in 1352, right after the casino law, that provides for similar things. So when you're exchanging social security numbers and winning amounts, as far as who won some sports wagers and as far as who owes child support, that information needs to be kept confidential and used only for the purposes of intercepting child support that's due. So those are the provisions that you'd need to review. And then this is the information about that case from the Supreme Court about the advertising restrictions, just so you have information on that, about why it might not be possible to put in statute in a way that could survive challenge, that you can't advertise sports wagering within 1,000 feet of a school, even though you are saying as a matter of state law that a student, so someone under 21 years of age, wouldn't be allowed to place a sports wager. That type of categorical exclusion has been stricken in the tobacco context. So it's possible it could be stricken as well in the sports wagering context. And then just so that you know, I know you know this, but if this bill and 1626 are both enacted, they conflict with respect to tribal state collaboration and state tax provisions. And based on potential amendment to 1626, they would also conflict as far as the gaming provision, but we can deal with that later when you talk about 1626. I don't think you necessarily want to hear about that right now, but I could be wrong.
Janet, thank you so much for that really detailed and incredibly terrific analysis. Senator Kime's hand is up, but before I call on you, Senator Kime, I just wanted to give Representative Hagan, who's just joined us, a moment to introduce himself.
Thank you very much, Madam Chair. I'm David Hagan. I represent House District 101, Hamden and Newburgh. Thank you.
Thank you. And Senator Kime, go ahead.
Thank you. So Janet, another question that was brought to my attention is that when we passed marijuana laws, I think we had some stipulations there that regulated them entities being located or owned by Maine people. And was that struck down?
I do not know if it was struck down. I know there are representatives of the Attorney General's office who've been at the attendee room, so you can ask, but I believe my recollection is that the Attorney General indicated he would defend those provisions. So residency requirements can implicate the Dormant Commerce Clause of the U.S. Constitution, which, just as a broad brush, generally speaking, there's a Commerce Clause in the U.S. Constitution that says that the federal government regulates the commerce between the states. And it's what's called the so-called Dormant Commerce Clause. So underlying that, it's been interpreted through Supreme Court case law that states can't discriminate against out-of-state businesses. So you can't, in effect, enact economic protectionism laws that say if you are from Maine, then you can engage in all of these businesses, but if you're not, we won't let you. So there have been other cases that the U.S. Supreme Court has decided. So, for example, in the liquor world, there used to be that many states said if you were an in-state winery, you could ship your products directly to the customer, but if you were an out-of-state winery, you couldn't. And those cases went up to the Supreme Court, and the Supreme Court said, as a state, you can decide that no winery can ship its products directly to customers. You can require it to go through wholesalers or something else, or for you to go to the store and show your ID before you buy it. But if you allow out-of-state wineries to do it, you have to allow in-state wineries also, because there was no showing that there was a need to make that difference between in-state or out-of-state, and it was found to be economic protectionism and discrimination against out-of-state economic interests. So that's the type of Dormant Commerce Clause provision. I believe that's what was implicated in the marijuana law. Although I staff BLA, I staff it for everything. In the past, I have accept marijuana. So that is not my area. So I would defer to the AG's office specifically on their response to that and whether there was a.
Okay, because how long ago was the case about the wine? No pun intended there.
Oh, I can't remember. It wasn't that long ago.
But
I
in the
have it
last
cited.
couple of years, was this decided about?
Yes, there was Tennessee Wine and Spirits. There was also the Granholm case, and one was earlier and one was later, but they both have happened fairly recently. That's why now there's a lot more wineries that ship. So Maine's law allows all wineries to apply for that license to direct ship. So we don't have a law that's in trouble. But this comes up a lot in BLA, particularly in the liquor context, because those were liquor cases. But there are cases in other contexts too. There were cases about milk prices and things like that. It's been brought in many areas, so you can't have economic protectionism.
Okay, great. I will definitely ask the AG to comment on that. Thank you.
Representative Moriarty?
Thank you, Madam Chair. Janet, I'm interested in amending section 1206, subparagraph 2, dealing with the eligibility for facility sports wagering licenses to specifically include commercial tracks in addition to the OTBs. My question is, looking at your drafting suggestions on page 9 of the analysis, you've tapped into this issue as well, but you referred to a commercial track that sells parimutuel pools for simulcast races under a particular section. Is it necessary that all of that additional language be included, or is it sufficient just to add commercial track to the language of section 1206 sub 2?
I don't think it's necessary to add it in theory. So the purpose clause, let me reread it. I just want to make sure that you wouldn't have to change the purposes clause. So the purposes provisions in part I talk about that if licensed off-track betting facilities engage in facility-based sports wagering, that would support the harness racing industry and agricultural interests. And I can see in my mind, if there were any kind of challenge to why those industries and not others could participate, that you could say, well, off-track betting is the idea that an event is taking place somewhere else and you're placing a bet on it, which is similar to sports betting. The sports event is taking place somewhere else and you're placing a bet on it. And so a commercial track, I don't know why they wouldn't, maybe they all do, but they don't have to do simulcast racing bets. So this would say, if you are, then you're in that kind of off-track betting facility category. So you could choose to keep that language in to say, if you're a commercial track that accepts bets that look like off-track bets, then we think you're the kind of entity that also should be able to do a similar thing with accepting bets on sports events. Or you could say, you have a choice. Or you could say, if you're just a commercial track, that's good enough for us. And it may be that all the commercial tracks in Maine take advantage of the authority of their commercial track license to do this kind of off-track betting thing, but it's a choice to make. It's sort of a style choice. I don't know if I'm making any sense, but that's the way I see it. You could just say commercial track and that would be fine. Or you could say only the commercial tracks that actually do kind of accept what we would consider an off-track bet will be included.
Okay. Then, Madam Chair, I guess at some point, if there's anybody in the attendee room from the commercial track area, I'd be interested in whether they concur that simply saying commercial track is sufficient for their purposes. I'm not personally knowledgeable about the reference to parimutuel pools and so forth, so I don't want to restrict it or limit it in any way to that particular activity.
So parimutuel pools are the bets you accept on horse races. And don't ask me how they calculate them because I do not know, but that's the language used throughout the harness racing statutes. Those are the bets you accept on horse races. And so that is written in a way that's written in the narrowest way that I could write it to say we want to include the Bangor Raceway, which does do some OTB-like activities. And that's the narrowest way to write it. You can obviously write it broader and just say commercial track, and that's fine. It's a policy choice for you to make.
I see. Thank you. Thank you.
And Representative Moriarty, I will do my very best to remember your question, but I would just ask that you bring it up again at the appropriate time, because I may not remember it.
Of course, I just planted the seed for those who may be listening in.
Okay, great. Okay, committee members, any other questions for Janet on the bill analysis? Go ahead, Representative Babbage.
Thank you, Madam Chair. I'll lower my hand right now. Janet, could you tell me about the segmentation of the bill itself? Because we are talking about taxation early on. And, I think the original bill was quite different. I wanted to ask you if the first few pages of the bill remain substantive without the sports betting component.
What do you mean by remain substantive? I'm sorry, I don't
In
understand.
other words, we're talking about taxation of entities and also dealing with Section 17 corporations, but we're talking about taxation regarding the use of tribal lands, and I'm just asking if the wording of those first few pages of the bill remain substantive as far as being advantageous to the tribes, should the sports betting component not be passed.
I think that they could be viewed independently. So there's no language in the sports betting provisions that's necessary to make the income tax provisions work or to make the tribal state collaboration piece work, if that's what you're asking.
I guess I am asking if as a standalone proposal that it works, or if it's so much entwined into the sports betting component that it might not work.
I would say Part A works by itself. Parts B through H work together as a unit. You need some of the definitions in Part B to understand the rest of the tax provisions. And parts I and J go together in their sports betting. You don't need the tax provisions to make the sports betting piece happen, or vice versa.
Thank you for that.
Committee members, I know Representative Moriarty that you have a question for Janet. Oh, you don't.
I've taken my hand down.
Okay. What I'd like to do is if we are good for now with our questions for Janet, and of course people can ask questions later, but we've had we invited the chairs and leads who had requested from VLA, who had requested to speak to our committee on this. We invited them to this work session. And what I would propose is that we hear from them and then we take a lunch break. And I want to know two things. I guess I want to know, can everybody hang in for a little bit longer while we hear from the chairs and leads, and then we'll take a break? Is that everybody okay with that? Okay. Then I am going to bring in, and I would ask, just because it makes it easier for me to find you, VLA chairs and leads who are in the attendee space, could you raise your electronic hands? And thank you. That is so much easier. Okay, and we have been joined by 3 members of VLA, and I was hoping that you could each introduce yourselves first, and then we would give you a little bit of time to express the concerns that asked you to speak to our committee. So Senator Hickman, we can start with you.
Thank you, Madam Chair. My name is Craig Hickman. I represent Senate District 14, which are 11 towns in southern Kennebec County, including my hometown of Winthrop, and I'm the Senate Chair of the Joint Standing Committee on Veterans and Legal Affairs. I'm going to simply ask, well, I was going to ask Senator Farron and Representative Chiazzo, Chairman Chiazzo, to present to you their concerns because they are absolutely more interested in a certain position than I am. I'm going to respect Judiciary Committee's work on this issue, and whatever this committee does, I will deal with that when it comes onto the floor of the Senate. But with that, I'll turn it over to my co-chair and the Senate lead.
Thank you. Representative Chiazzo, do you want to introduce yourself?
Thank you, Madam Chair. My name is Chris Chiazzo. I represent House District 28, beautiful West Scarborough, and I am a grateful constituent of Senator Carney.
Representative, excuse me, I'm sorry, Senator Farron, go ahead and introduce yourself.
Thank you, Madam Chair. My name is Brad Farron. I represent Senate District 3, which is the majority of Somerset County in the town of Rome and Kennebec County. And I noticed how the representative sucked up right out of the gate, recognizing his senator. That's very nice.
Well, it's a pleasure on behalf of all committee members to see all three of you. And then let's see, Representative Chiazzo, if you can just give us a couple of minutes, and then we'll also ask Senator Farron to give us a couple of minutes, and then I'm sure the committee members will have questions for you.
Yeah, absolutely. Thank you, Madam Chair. I will be very brief. I tried to listen last week, and I've been listening all morning. So I do want to start off by stating for the record that Janet Stocco is the VLA analyst, and we hope to keep it that way. So she's on loan to your committee, but she is just a loaner for now. It does strike me that I certainly do not envy the position this committee is in. We have the advantage of spending, several legislative cycles and several iterations with multilateral people and negotiations and discussions to get to the option that's on the Senate, it's on the appropriations table right now. This committee, unfortunately, for whatever reason, is dealing with legislation that's been introduced very recently, and all of our bills need to be voted out by Friday. So I don't want to give you my position. This is a very challenging, sports wagering as a whole is a very challenging and difficult subject. We had, as an example, in BLA, which is the Committee of Expertise, we had 4 different committee reports come out for 1352. So it takes a lot of coordination, collaboration to get to some form of consensus. And so I totally respect, as Senator Hickman mentioned, totally respect the work of this committee. Whatever you decide, you are the committee of jurisdiction for this bill. I would just ask you to consider a few points. And the points I think are important. And as you get into the minutia, that stuff is critical and important, but I think there's really 4 primary things that this committee needs to take into consideration. The first is that sports wagering will be a new form of gambling allowed in the state. It currently does not exist. So we're entering as a state into a new market and a new field. And so the basic questions are, do you want to advance a unilateral proposal that grants exclusivity to a group, or do you want to try and advance a multilateral proposal that benefits all the parties, or everybody's had a chance to weigh in and discuss over several years of negotiation? Second question is, how much control do you feel the state should have over this new gambling practice? And then last but not least, do you want to consider the best fiscal outcome for the state? And all of the other minutiae and all the other details, I think, tie into those 3 principal positions. And specifically dealing with sports wagering, I don't feel comfortable addressing the issue of the taxation piece or the collaboration piece. That is certainly your bailiwick. But I'm just speaking specifically towards the sports wagering side of things. So I appreciate the opportunity to appear before your group. And with that, Madam Chair, I will yield the floor.
Thank you. And Senator Farron, go ahead.
Thank you, Madam Chair. Ditto to what the House Chair said. I really, there's no question, right? You folks have been dealt this bill, and it's in your jurisdiction, and you obviously have the authority and control to debate and talk and whatever. But I've been watching for part of it, and as well as last week, and just some of the questions that have raised. What Representative Cazzo was talking about. We spent years, literally, working through these pieces with stakeholders all at the table. And you know what? I think 1352, at the end of the day, regardless of not everybody was 100% happy, because it was truly worked through the process to get there. And regardless of how you feel about how the tribes have been treated, regardless of how you feel about sports betting, I've been more focused on the process of this. And as a legislator, sometimes on transportation, we pass a law that has a criminal impact to it, and we defer to it, to either criminal justice or sometimes to you folks, because we know that that's not in our purview from a transportation standpoint. And it's the same here, quite honestly. I'm more upset about the process. This was put together without many of the stakeholders. I shouldn't say any, but without many of them. And I don't believe you folks are in an envious position, because if you did go back and look at the history of sports betting and mobile betting in Maine, it has been a journey for several sessions, several bills, a veto, and lots of collaboration and work through that process. And to try to get this through in 2 weeks' time and to get it right, I think that's going to be really tough. You are very fortunate to have Janet, and we do want her back, and because she makes all of us look a lot smarter than we are at times. And so with that, Madam Chair, just thank you for the time and thank you for the opportunity, and you folks have got your hands full.
Thank you both. And to all three of you, thank you for all your work on this issue as well. We've benefited a lot from your careful work, and we're grateful for everything you put into 1352. I know that committee members will have questions for you. And so at this point, if you're willing, we'll open the floor up to questions. Go ahead, Senator Keim.
Thank you. I have two, and one I think is specifically in reference to what Representative Cazzo mentioned about how much control do we want the state to have, or how much control should the state have? And I was wondering, I don't think that I know I hadn't really thought about that question. And do you see anything in 585 that rises to, in regards to sports betting, that raises concern for you about changes of oversight?
May I respond, Madam Chair?
Yes, please do.
Okay, thank you. To be honest with you, it's I haven't seen anything particularly that jumps out as a big red flag, but this is also the first work session you've had on the bill. And we had the benefit of having the gambling control unit involved in many of those discussions up front. They were involved in many of the language is very similar. So that clearly is a testament to the work that was done on 1352. I just think that I don't know enough about the sovereignty portion of what portions the tribe would be in control of and what portions the state would be in control of. It may be there. I'm just not familiar with those issues and how that negotiation has gone. So I'm more familiar with 1352 in terms of the checks and balances and the oversight mechanisms we put in place for that. We also, one of the big points of contention in our committee was on the subject of what's called tethering. And tethering means, do you require those mobile betting applications to be tied to a brick and mortar facility, or do you allow them to be open and just compete in the state of Maine? And so there was a great amount of discussion around that particular issue And I don't know what that situation is here in terms of the mobile aspect of it, because the tribes, I don't know if they're considered a facility because they don't have the brick and mortar. So I don't know if there is a tethering piece or if they're just the operator. I haven't had a chance to dig into that stuff yet. So I hope that answers your question, Senator Khan.
Yes, it does. And the tethering piece is something that we haven't discussed because I don't believe it is in the bill, but yes, I appreciate that. I also appreciate just overall you all recognizing that this is overwhelming for us, because it makes me feel better about my lack of understanding, as I feel like I'm, struggling through to understand. And this bill has taxation in it as well. So it's a lot. My other question is has to do with kind of with tethering, actually, but I was wondering if we are lowering the bar on sports wagering gambling facilities because the casinos have greater protections around them. And I don't know which of you is the best to answer that, or if anybody has an idea. It's kind of a broad question, but I was hoping one of you might take a stab at it.
If you don't mind, Madam Chair, I'll take the first stab. And so, the protection piece, if you go back, and I apologize for the LD number, I can't remember off the top of my head, the first mobile betting, sports betting bill that we had that the governor vetoed. Part of that veto was because it didn't have some of the protections in there that she thought we should have. And that's one of the things that was really worked on in 1352. As far, specifically with child and minors having access to the applications and doing those things. So that was a lot of discussion as we move forward. Kind of piggybacking on what the House Chair said, I have to tell you, I don't know. This is, like I said, your first work session on this, and I don't know what's in the bill in front of you, if that carried all of those protections and languages through. That's number one. Number two is, as the House Chair again reiterated, this is a brand new product. And I can tell you from being on VLA and dealing with adult use marijuana with a whole new process and rulemaking and everything that goes along with it, it's a lot. And so to that point, I'm not sure anybody can specifically answer that question about what the security piece is if you're just doing a mobile application and it's not tied to that tethering and brick and mortar piece. I think it's almost, you can't answer that question until you dig into those details like we had to on the previous one.
So the idea, if I understand the idea about there being sort of lowering the bar on protections is directly tied to tethering.
No, two separate pieces, Senator.
Okay.
Two separate pieces. There were pieces of actual, I want to use the term geocaching, but so that minors can't use the application of the mobile piece, right? And that was addressed. And then I think the question that you were asking, and not to put words in your mouth but a casino, a brick and mortar structure offers some level of protection above and beyond just issuing a mobile license. And I agree with that in concept. And I don't know what in this bill that you're working right now, whether those same protections are in place or not.
Okay, thank you.
Representative Harnett, go ahead.
Thank you, Madam Chair, and thank you all for very much for being here today. Representative Chiazzo, you raised three questions in your summary, and I want to focus on the last one. I think, and if I'm stating this incorrectly, please tell me that I'm wrong. But the third question you asked was, are we looking out for the best outcome for the state, and is that important? And I'm wondering what that means to you, the best outcome for the state. Is it simply the maximum amount of revenue being generated, or is it something else?
Thank you, Chairman Harnett, for the opportunity to clarify that. And I hope I didn't say that. All I suggested was that the committee should evaluate the fiscal impact on the state. And did you want to make that a consideration of it? And the only reason I mentioned that was because of the previous discussions around the fiscal note and the fact that a fiscal note has not been generated yet on 585 that I'm aware of, but there is a fiscal note on 1352 that is apparent. And again, you're all going to do your work. As I don't know if you'll vote this today. I don't know what your schedule is or how you're going to work it. But obviously, I think both will be revenue positive, and I think that is a discussion for this committee and for the body as a whole as to, should they be tied together in relation to sovereignty, or should they be standalone issues? I don't have an opinion on that. I just want to talk about the comparison of the fiscal impact of the gaming piece, because that is certainly something that we look at in VLA as well. I don't think that should be the primary piece, but I think it does warrant consideration on some level.
May I have a follow-up, Madam Chair?
Yes, please do.
Would just on that point as a follow-up, there can be benefit to the state other than simply the revenue that goes into the general fund in terms of rural economic development, development of infrastructure for the tribes. Would you agree that there are more things than revenue to consider when we're looking at best outcome?
I would agree 100% with you, Chairman Harnett. And I think when it comes to the sports betting piece associated with how those revenues are going to be generated, I think that's a very fair question of what that split would look like. Even in 1352, there's revenue that's being generated for the tribes through the gaming piece itself. I don't know how much it would be generating for them because the fiscal note on 1385 didn't break it out specifically, but it did look at the total revenue to the state and how much would be shared on the marketplace. And so I can't really, I agree with you. The fiscal responsibility or fiscal trigger should not be the only by any stretch of the imagination, but it should be a component, I think, especially when it comes to how we are going to manage the gaming portion of it. That's all. Does that help?
Thank you very much. It does. Thank
you.
you.
Are you done with your questions, Representative Burnett?
I am. Thank you.
Okay, thank you. Representative Moriarty?
Thank you, Madam Chair. To all of my colleagues on VLA, two quick questions. Number one, what is the fiscal note on 1352? And secondly, why, in your judgment, has it rested on the table for so long?
Representative, well, okay, we can let them try to answer. I just wanted to remind you that we did, Janet has provided us with that fiscal note.
Oh.
And it's linked in the bill analysis, I believe, kind of toward the end of the bill analysis.
Okay, I didn't check the link. Sorry.
Yeah, no, that's okay.
Madam Chair, if I may answer the last question first.
Yes, please go ahead.
Not to step on anyone's toes, but so just for the committee's information, I support tribal gaming generally. I do not support sports betting generally, which is why in both times we've had a vote on sports betting and Veterans Legal Affairs, I've simply voted ought not to pass. I'm a former tennis writer, and I have seen the detriment to the sport of tennis that sports betting has caused all over the world. And this was years ago before it became popular to do in the United States of America, legal or not. So to answer the second question first, I'm aware that when the tribal gaming bill, LD 554, was vetoed and the veto was sustained by the House of Representatives from very reliable sources who were serving in the legislature at the time, there was already a discussion that tribal sovereignty around economic self-determination might be advanced in the future through the mobile sports licenses that are contemplated in LD 585. And so if you put 2 + 2 together and know now that the compromise negotiations on tribal sovereignty that have been happening with the lawyers, the tribal lawyers in the office of the chief executive. It's probably safe to make a couple of deductions that this process here today would determine whether or not 1352 comes off of the table. So I think that answers your question, Representative Moriarty. And if it doesn't, I can be more explicit, but.
No, I think that's fine. Thanks.
Thank you.
All set with your questions, Representative Moriarty?
Yes, I'm all done.
Okay. Senator Sanborn, go ahead.
Thanks. I was hoping we might just give Janet a minute because I felt as though there were a couple of things when Senator Farron and Representative Piazza were talking about tethering, and we're talking about not understanding the sovereignty implications of 585 and the ways in which it was different with regard to tethering and with regard to state control of gambling operations. I felt like Janet might be able to sort of reiterate some of the elements of her chart and help us untangle those two issues, because I think there was some confusion introduced by some of those comments.
Thank you, Senator Sanborn. Janet, are you able to introduce those? I think that would, or review those with us?
Sure. If it becomes helpful for me to put the chart back up, I can. As far as tethering, actually, I can't describe this without looking at the chart myself. So I'm going to screen share. I have actually clicked over to the fiscal note that Representative Moriarty wanted, but that is linked right to the bill analysis. That's how I found it, was just clicking through the link. So sorry to scroll. I know that's annoying. Okay, tethering. Remember, there are two types of licenses to be offered. They're facility operator licenses. You can only get those licenses if you have a physical facility, because you have to accept the bets only within that physical facility. So there's no question about tethering there. Do you have to have a facility? It's sort of inherent. You have to have a facility to accept facility sports wagers. The so-called tethering debate was all about the mobile operator licenses. So if we look at 1352, the way that it is written, and in the form that is on the special appropriations table right now, a licensed commercial track, an OTB, these are the ones not at the track, so we're covering both here, a casino, or a federally recognized Indian tribe in the state could apply for and get a mobile sports wagering license. The debate occurred because there was an alternative proposal that would have added a fifth bullet point here, and that would have been, I can't remember what it was called, whatever it was called. I don't know why I'm blanking on it. Maybe it's nightmares from too many late nights. But there was another phrase, and it covered an entity that was licensed in another state to conduct mobile sports wagering. So that entity would also be able to apply for a mobile sports wagering license in Maine. There would be no requirement that it have some underlying connection to Maine itself. And the majority amendment to 1352, this was one of the reasons why there was a four-way split. The majority amendment said, no, we don't want to allow somebody who's just licensed out of state to get that license directly themselves in Maine. We only want these four types of entities to be able to obtain the license, and these are ones with the connection to Maine. And so that's the sort of tethering. I don't see a difference in that tethering debate in 585 before you. Yes, you pick a different subset of these four. You only pick federally recognized Indian tribes within the state, but they were already allowed in 1352 to get a mobile sports betting license, so they have a connection to the state. They may not have a physical location, but they're not required to under 1352 either. The idea was, as I understood it, but I'm glad you have the VLA members here because I just do it from the nonpartisan side, was to have this connection to Maine. And that connection is here. It's not any federally recognized Indian tribe. It's only the ones in the state. As far as the protections for youth, there is a difference in the protections for youth, and that was about the advertising. I forget where that is. I don't remember where it is, but it's in here somewhere. Okay, here it is. is that we're going from statute specifically saying certain advertising restrictions as a matter of statute that can then be embellished through rulemaking to say, no, all of those advertising restrictions will be made straight through rulemaking. So we don't know exactly the scope of what those restrictions will be, other than they have to prohibit misleading, deceptive, or false ads, and they have to require disclosure of who's operating it. That's not required in 1352. But it's my understanding that while that looks less protective, and it may end up being less protective as far as what rules apply, it's in response to the US Supreme Court case of which I was unaware when the VLA committee went over these bills. And so the way it's written, as I understand it, the Gambling Control Unit director could make less restrictive advertising rules, but they're supposed to be as restrictive as possible as far as is permissible under Supreme Court precedent, etc., to try and restrict it. I don't see any other differences in the protections for folks, but I understand what Chair Chiazzo to be saying. I'm going to stop sharing so you can see me now. I understand what Representative Chiazzo is saying about the concern about sovereignty. And this bill, if you just look at it alone, doesn't change tribal sovereignty. It just gives the tribes and the OTBs the authority to engage in this new market of sports betting. But you do have other proposals before you which involve sovereignty, and they might be what's leading to that concern. And I would point out that there's no reason Representative Chiazzo should know this, but in the 1626, there was that provision that the tribes would not be able to engage in gaming under the Indian Gaming Regulatory Act. And so then there were questions raised by the Attorney General, what exactly are the rules applicable? And we haven't gotten to that yet. And there are some proposed amendments to that language that have been discussed, because I asked some questions of the tribal attorneys. I asked it in the bill analysis. They viewed them as questions to them. And so they answered in a submission that they've given and that I've sent out to you and posted online. And then I since asked for further clarification because I wasn't quite understanding the response about the gaming piece. And I believe there might be a proposal to amend that, whether you agree with it or not, is up to you, to say that state laws would apply with gaming. So there was no way that Representative Chiazzo could know that, because he'd have to be able to read my mind, which he hasn't figured out how to do. I'm not sure why. But I don't think that sovereignty would impact just gaming, but sovereignty generally is a big issue, definitely before this committee. It obviously depends how 1626 plays out though, because it could allow for sovereignty over gaming. You haven't voted it yet.
Can I ask a follow-up question, Senator
I
Carney?
was going to ask if you had a follow-up. Go ahead.
Thank you. Thank you, Jana. That was, I think, really, really helpful. But I just want to try and pull out the last point that you made about sovereignty. If we were to pass 585 versus 1352, with respect, and only 585, like let's say we don't pass 1626, we just pass 585, compared to if we just pass 1352, would the state have the same amount of control over more mobile sports betting under either of those two statutes? The same ability to regulate the activities of the licensees?
The state would have the same ability to regulate the activities and tax it, but I believe that the Gambling Control Unit director would have to consult with the tribes when making the rules under Part A.
Okay. Thank you.
Representative Babbage, go ahead.
Thank you, Madam Chair. Thank you for all of that. While we have our VLA colleagues with us, Madam Chair, if I may, I'd like to ask about the fiscal aspect in 585 as opposed to 1352. And I apologize to the committee earlier because I did ask about other states and I knew I had seen it, but it was stapled behind another cover page and I finally was alerted to where those charts were. But I noticed that in other states, the amount taxed by the state varies from 6% and single digits by a few states to 50, 50, and 51% by certain other states. And I wondered if you could help me to go through your process of how did you happen to determine that 16% with 12.5 going to the general fund was appropriate for 1352?
Who would like to answer that? Go ahead, Representative Chiazzo.
Thank you, Madam Chair. Thank you, Representative Babbage, for the question. The numbers we land on, there were two mechanisms that we were playing with: the fee structure up front, and then the tax rate on the back end. So there was a lot of discussion between stakeholders back and forth about whether some states will front end load the fees and reduce the tax rate. Some states will waive fees and have high tax rates. It's really kind of a potpourri of different approaches. So what we tried to center on and land on, and I think we did successfully with 1352, was that balance between having that initial fee appropriate in terms of the seriousness of the gaming piece and the potential profit to be made there, and the complexity of having to manage it and award it with the tax rate. So if we had too low, the state is not going to realize as much revenue on it. If we go too high, competitors may not want to come in and participate because the barriers to competition would be just too high. Ultimately, I think what we landed on was a compromise, if you will, for that. And that was over, I would imagine, like everything, there were multiple meetings and discussions about setting those points and setting those levels.
And you were, if I may, Madam Chair, you were interpreting that the tax rate would be more influential or more of a deterrent than the initial fee.
No, I wouldn't say that. I'd say that they're equal, right? Some companies may not want to spend $400,000 or $500,000 on an initial fee because they don't know what the market's going to be, right? They have to recoup those costs somehow. So not understanding what the market was going to generate for potential revenue, estimating what those numbers would be, we had to balance and land on something that was fair and equitable to anybody who was going to not create a barrier to entry to the point where people couldn't, but certainly create a requirement that the state would benefit from it on some level. Does that help?
It does. Thank you.
Representative Thorne, go ahead.
Thank you, Madam Chair, and welcome. My brothers from the Veterans Caucus. I don't get a chance to see you at work. And Senator Hickman, we need to talk about your dad. I didn't realize he was a Tuskegee Airman, and I've met many Tuskegee Airmen over my 21-year career at various leadership academies and schools. So thank you for being here today. And don't take this the wrong way, gentlemen, but I almost think that you've raised more questions than you've answered in my mind, just because of the complexity of what I'll call the main triangle between 1626, 1352, and 585. The nuances of each are complex and complicated. And my question is, obviously, we're not going to be able, I don't feel comfortably vote this out, knowing that we have a full grasp on it today. And I didn't know, and I may be out of line by suggesting that there was a compromise and a hybrid of the three bills that could be put forth in the future to merge together to one package, or if that was possible, or would it require scrapping two to go with one and just make amendments on the one that satisfied both our committee and VLA committee requirements of the straight face on this? And I'll open that up to whoever would like to take a shot at it.
Representative Thorne, I thank you for recognizing my father's service. He means a great deal to me. I'm sure he's smiling down from heaven at the fact that we're having this conversation right now. I want to make it clear to the Judiciary Committee that I have listened to just about every piece of testimony and all of the work sessions on all of the bills that you have in front of you related to the tribes. And the reason why I have done that is because I am a 100% supporter of tribal sovereignty. It is complicated. Tribal sovereignty has always been complicated in the state of Maine, and it remains so today. And the legislature has grappled with the issue of tribal sovereignty for at least 5 years of my 10 years that I have paid attention to it. And we haven't gotten it solved yet. And so I heard testimony on 1626 and on 585 from supporters of tribal sovereignty that said one should not be a substitute for the other, that whatever has been negotiated to satisfy tribal sovereignty or self-determination interests in the negotiations around LD 585, cooperation, taxation, and sports betting, to me, are something I hope this committee gets right. I also hope the committee gets 1626 right. Even though I don't agree with sports betting for the reasons that I've said earlier, and I'll just put a little bit of meat on the bone. Tennis, as many of you know, is an individual sport. Doubles is doubles, but it's an individual sport which I love. You figure it out for yourself on the court, how to beat your opponent. And the professional players who are not superstars and who do not win Grand Slams do not have entourages where they go around the world and perform and compete at these challenger events. They are, if you will, the working class of the tennis world. And for that reason, sometimes they may take a bet on themselves via a sports betting channel and tank the match. And as an astute observer of the sport, I can tell when that happens. And I don't like it very much. And so that's why I have this negative reaction to sports betting. That may not be true in every sport, but it's certainly true in an individual sport like tennis. That being said, if sports betting is going to be made available to the tribes in a way that allows them preferential treatment compared to everybody else, I will honestly say that I'll be okay with that if that's what this committee decides to do. I don't want to be unclear about that. And so I don't know in that scenario if 1352 has a life. I didn't vote for it, so it's not going to hurt my feelings if it doesn't pass. But it will hurt my feelings if there is no tribal sovereignty and if there's no economic self-determination for the tribes. And it really is up to you all to figure that out. And I don't envy you because that's really difficult work. But the indigenous people of this country taught us a lot, and we haven't treated them very well. And so I respectfully disagree with my Senate lead who says it should not matter how one feels about how the tribes have been treated, because to me, that goes to the crux of the issue that you are looking at here. And I do know that you can write a law that creates all the protections that are needed to make sure that the public health and safety of this state are protected, even if sports betting mobile licenses are all in the hands of the tribal nations of Maine. I hope that answers your question, sir.
Representative Thorne, can we give Senator Farron a chance to speak as well?
Yes, Madam Chair, I just want to make sure that, you know, I'm seeing and hearing that the gambling or the sovereignty are somehow tied together, that is a way for the tribes to fund their sovereignty is through the gambling aspect. And I want to know if I'm drawing a fair conclusion on that.
Yeah,
and I'm just trying to see if they're tied together by chance or by design.
Okay, let's have Janet answer that question because I think she can point to the analysis and help us through that. Thank you.
So as far as 585 is concerned, it's my understanding that the sports wagering piece, based on the testimony at the hearing, is designed as a tool of economic development for the tribes, which, based on restrictions on their taxing authority and other restrictions on their sovereignty, have less of an ability to raise money. For example, if you remember, their Indian Territory and Hope Land Trust lands are owned by the U.S. Secretary of the Interior, a lot of the portions of that, so they can't have property taxes, for example. They have the authority under current law, two of the tribes, to impose taxes to the same extent as a municipality, but municipalities can't impose income taxes or sales taxes under Maine law. So there are restrictions of economic development. And it's my understanding that gaming is one way that tribes across the country have spurred economic development. I don't want to pretend or speak for the Wabanaki nations, though. You may remember Chief Francis has said multiple times that what the tribes want is the opportunity, but it doesn't mean that they will decide that gaming is the way to go. They just want to be given the choice that the other tribes across the country have. So I don't know, I hope I'm covering all the bases with that as far as the economic development. Now I've forgotten the rest of the question.
I think the other aspect was the sovereignty, and I would point out, Representative Thorne, and I think Janet said this earlier today, that 585 actually doesn't address tribal sovereignty.
Right. And that was to Senator Hickman's point, is that, can we support one without supporting the other and not undermine the actual premise of the sovereignty? So that's I guess where I'm getting to on that.
Yeah.
I think the only things between 1626 and this bill proposal before you that conflict are the consultation piece, because they're written differently, and then the tax piece, they're written somewhat differently. So you'd have like technical conflicts if you look between the two. I don't think the sports betting piece really conflicts with the way I understand 1626, what the intent is behind it. It may need a little bit of language tweaks to get to that intent, but it wouldn't be a conflict, because it's my understanding that the intent of 1626 as far as sovereignty is to address everything but gaming. So you could have this gaming proposal and it wouldn't be a conflict, because gaming would still be under state law. It depends on how you amend 1626, if you tweak it the way that's being proposed, but that's my understanding of the intent.
Okay. Thank you for that. Thank you for the answers, and thank you for indulging me, Madam Chair.
Representative Thorne, do you want to give Senator Farron a chance to respond to your question as well? I thought he was.
I would really appreciate that if he has a different take or a way that he can present it.
Well, thank you. I this is part of the conversation, right? And while we respect each other, Senator Hickman and I have a different opinion on this. And part of this, I go back to the process, right? We passed the bill and make clear 1352 included the tribes. That was specific. Go back to that analysis that Janet just showed you. That was a key component of that. That was part of the compromise that was brought through, as well as the tethering piece, right? And that's why the casinos and the OTBs and how everything was broken out. So to say that this bill that you folks are considering that only gives the mobile licenses to the tribes is better from that standpoint. The tribes are included in 1352. And I think I've heard that people not understand that piece of it. We have partners in this state, brick and mortar places that have made millions of dollars in investments and in the communities going forward on this. That was all put into the percentages and the fees and everything else that was going through from a business standpoint. The tribes were not left out of 1352. And I just think that's an important piece to make through this whole conversation. And this is what we do in politics in Augusta, right? We add a little sprinkle here, and you do this here, and I'll support your bill, and and we confuse the subjects all around until you get a poison pill and no one can support anything. And then we wonder why we can't get things done. We have a bill setting an appropriations waiting to be engrossed that passed the majority. Let it run and see where it falls. And don't confuse these issues. In my opinion, setting on the Kennebec River in Norridgewock, Maine. Thank you, Madam Chair.
Thank you for that, Senator.
Representative Libby, go ahead.
Thank you, Madam Chair, and thank you to all of you for being here from VLA and helping us get clarity on this very complex bill. My question is maybe a clarifying question for Janet, and then a question directed to anyone who would like to answer it from VLA. So Janet, my clarifying question is to ask if I'm understanding this correctly, that in 1352, under the mobile operators, that the licensed commercial track, the OTBs, and the casino or slot machine facility, those would be tethered, and that the federally recognized Indian tribe in the state would not be tethered. Is that correct?
I don't know. So tethering was sort of a political debate, and I don't know how people were using that term. My understanding was that there had to be a connection to Maine, was sort of how it was talked about in the committee. And so the federally recognized Indian tribes in the state were one of the entities, the casinos, the OTBs, and the tracks. What was not being included in this version, as opposed to a different report out of the VLA committee, was this other out-of-state entity that had an authority through another jurisdiction, had already been licensed, and could offer mobile sports wagering out of state. There was another version. It's actually in the original 1352. So you can look at the bill sponsor and figure out who we're talking about, that that would allow them to get their own mobile sports betting license. And the reason it was described, I thought, as tethering was, if you remember, there's these management services licenses that are available. So if you're an entity, and I just kept using the only names I knew off the top of my head, I'm not promoting them, like a DraftKings or FanDuel, you might be licensed out of state to offer mobile sports betting. Under one version, which is not the version on the table, you would have been able to get that license directly. In the version that's on the table, you had to be tethered to one of these four things, the casino or the tribe or the OTB or the track, because you had to get your management services license and tether yourself, as in entering a contract with the actual entities that were allowed to get the operator license, and you'd work out how much of the revenue do you get. You might actually be offering the sports wagering, but the licensed operator would be the tribe or the track or the OTB or the casino. So in that way, you were tethered because you had to do it through them and through a contract with them.
Okay, so perhaps I am not understanding tethering correctly, because what I was understanding was that tethering would mean that the mobile operator that was connected to the track, that's because the track was a physical location, and so that there had to be a physical location tethered to the mobile operators. Is that?
So that was how a lot of the speeches were given. So I heard a lot of that same thing, but there's no requirement for the mobile operator piece of 1352 that there be some physical facility somewhere, because it includes the tribes and doesn't have a requirement, for example, that you have a high stakes Beano facility or some kind of facility. What you are tethering to is to one of these licensed operators.
Okay, thank you. That is helpful. So I'll go on to my question for VLA. Looking at the difference here between 1352 and 585 in that specific mobile operator section, I wonder if you could speak to the effect to the Maine consumer, and if you have any concern about creating a monopoly here in this mobile operator section.
Go ahead, Senator Hickman.
I will defer to Chairman Chiazzo and come back.
Okay. Representative Chiazzo?
Thank you, Madam Chair, and thank you, Senator Hickman. I think you can tell just from the conversations between VLA members that this is a complicated issue. And I don't know I don't know if there's time between now and when these bills need to be voted to get a good compromise with what's in front of you, or whether it's a homogenization of the two or whatever it is. But specifically to your question, Representative Libby, my concern around the mobile operations licensing is that you've in essence, you've given exclusivity to one group. This group happens to be the tribes, and for political reasons, we may agree with that. And I don't necessarily disagree that they should not have the opportunity to generate that revenue. And if we want to give them exclusivity, that's up to this committee to determine, and your recommendation, and certainly up to us to decide on in both bodies. The differences between the two options right now are the number of licenses and who can get those licenses. 585 is a proposal. I've heard it's a compromise. It's a compromise between the executive and one entity. 1352 is a compromise amongst multilateral parties, including the executive and including the tribes, up until that point. So I want to be clear. I haven't heard, I'm not advocating one avenue or the other. I'm not advocating one approach or the other, but physically the difference between 585 and 1352 in terms of the number of, in terms of the mobile licensing is by, and correct me if I'm wrong here, Janet, I cannot read your mind because I'm not that smart. There are 4 licenses, at most 4 licenses can be awarded under 585 because there's 4 tribal entities, if I understand it correctly. Under 1532, you can have up to 7 or more, including the tribal entities. So it's the more players in, the more competitive, the better the product. I think in any situation. But I also can fully recognize the desire to, with exclusivity comes profit and comes opportunity for one entity. And if this body determines that is the mechanism that you want to grant as in conjunction with the sovereignty as an economic driver, then that's a debate and a discussion that we have and we continue to have. I don't preclude that. I don't think I think there's merits to that conversation for sure. I don't know if we can resolve that between now and Friday, but maybe you can. So I hope that answered your question.
Thank you.
Senator Farren, did you want to weigh in or are you all set? Okay, and then Senator Hickman, how about you?
Thank you, Madam Chair. Representative Libby, I appreciate the question, and I will be very diplomatic with how I respond, I think. The Wabanaki people of the place we call Maine are not one entity. They are separate nations that represent probably more people than we can see. I don't recall in the 2 times we worked on LD 1352, and it was in a different LD, of course. Prior to that, I don't recall, and I could be wrong, Senator Farren may have been there. Well, he was there for the last disco around, but I think it was a different senator the first time we did this. I don't recall anyone from the tribes being at the table in the negotiations around sports betting. So there's that. I said earlier, preferential treatment, that may sound odd to some people's ears. Really what I'm saying is that there has to be some preferential treatment to make up for historical harm. And so if that make up for historical harm, the state decides, the legislature decides to only allow federally recognized Indian tribes in the state of Maine to have this particular kind of sports betting license, that's not going to hurt my feelings. And I don't think that it's a harm to the people of the state. That being said, I'll go back to Representative Thorne's question. All 3 of the pieces of legislation we've been discussing can pass. LD 585 can pass. LD 1352 can be finally enacted, and LD 1626 can pass. You don't have to decide what to do about those 3 things in this committee, because one has already pretty much gotten to the finish line. So the chief executive will decide what to do if all three of those pieces of legislation ultimately end up on her desk. And then the legislature will decide after that if we agree with her or not. And so I just want to state the obvious that these bills don't really compete with each other. I think the legislature in my 5 terms has passed overlapping pieces of legislation. It's one of the reasons why we have an errors and inconsistencies bill, which this committee contemplates. And so to me, it's not really a question of, do we choose one entity to receive an unfair benefit? It is, how are we going to treat a people that deserve better treatment? And you've got 3 bills in front of you, pieces of which can do that or not, completely up to you. I hope that answers your question, Representative.
Thank you. It's very helpful to hear both of your perspectives. I appreciate it.
And Representative Evangelos, you could go ahead with your questions, and then I think we will end this portion of our work session and take a little break. So go ahead, Representative.
Thank you, Madam Chair. It'll be brief. I just wanted to respond just to the general discussion of where we put our priorities and this discussion about money and comparing the bills. But the reason I serve on the Judiciary Committee is because of human rights. And, it's a high calling. And in 1980, the state of Maine put no money into the settlement. In fact, Richard Cohen, the Attorney General, said they were making money as a result of it. So I'm not measuring this in those terms. I'm here for the human rights of people. And in this case, it's the Native nations. And we're trying to address those inequities. That's where my focus is going to be. That's all I have to say.
Thank you, Representative. Committee members, can you join me in thanking the VLA members who attended today and helped us with this legislation?
Thank you for having us, Madam Chair.
We appreciate you being here. Thanks so much for your contributions to our conversation. And committee members, we've been going for 3 hours. It's definitely time for a break. I think we could probably unanimously agree to that. I would like to know whether committee members want to take a break until 3 o'clock or 3:30 so that we can have lunch and also caucus, or whether a shorter break is in order. Anybody have strong feelings about that one way or another? Representative Libby?
I would have strong feelings to 3:30.
That's what you prefer. Okay. Representative Evangelos?
Well, I don't necessarily have strong feelings either way, but strategically, if we come back into work at 3:30, and given the tasks that are in front of us, some of us have cutoff times. How late are we going?
Okay, yeah, I appreciate that. I think maybe the right thing to do at this point is to compromise and say that we'll come back at 3. And that gives us some time to get some lunch and to caucus. We do have a fair amount of information to still cover. And I know that we're facing a deadline to vote, but I also, I know that it's important to get some more questions answered. Senator Keim, did you have some feedback on that?
Yes, yeah, I'm fine with the break till 3. I just, are we going then into 1626 or are we sticking with 585?
I need to think about that, and I'm sorry that I can't give everybody an answer right now. I just need to look at my notes and assess whether we've reached the same point on 585 that we did on 1626, in which case I think that we should table 585 and take up 1626. So, but I need to think about it, and I'm actually too hungry to make a good decision right now. So if others can think about that as well while we take our break until 3 o'clock. Everybody okay?
Thank
with
you.
that? All right. Thank you, everyone. Don't forget to deactivate audio and video, and we will see everybody at 3.
See you soon.
Hello, everyone. Committee members, if you are off camera but in front of your computers, could you please activate your video so we can resume our work this afternoon? We'll give people another minute or two to join us. Welcome back, everyone, and Representative Newell, welcome to the committee. I know that you were tied up this morning. Would you like a moment to introduce yourself?
Thank you, Madam Chair. Good morning. Oh, good afternoon, everyone. My name is Rena Newell, and I serve as the Passamaquoddy Tribal Representative. And thank you for excusing me from this morning's portion of this piece of legislation. However, I did log in and have been listening in via my cell phone. So I've listened to the majority of the conversations, beginning with the bill analysis. So thank you so much.
Thank you, and it's nice to see you. Okay, committee members, I had a chance to regroup and look at my notes while we were on our break. And we realized that we have one more piece of LD 585 to cover. It's actually part 5 of the amendment. So we're going to cover that, and then we'll table 585 because we will have completed our work on the OPLA analysis. And then we'll take up 1626. So let's start with our conclusion of our work on 585, and we'll turn the virtual floor back over to you, Janet.
Thank you. I realized that I had forgotten one piece of the 585 proposed amendments. I can only say I must have been tired finishing sports betting, and I just simply forgot to include it. And on the bill analysis, I'm going to share my screen with you to show you what it says, and I'll quickly summarize it so that you know what I'm talking about. If you have the amendment, it is on pages 30, and it spills over a tiny little bit to page 31. So this is section J10 of the proposed amendment, and section J, or excuse me, part J, as you know, is the sports betting piece, and then this is at the bottom. This would be an amendment to Title 30. It would be a new part within Title 30. This is not within the main implementing act, but it is located nearby because that's where some provisions in Maine law about the federally recognized Indian tribes in the state are located. So it's
Janet,
located near.
I'm sorry to interrupt. Could you make it a little bit bigger, please? Thank you.
Sure. So all this stuff up here is the end of sports betting, and it's all the type of language you need to put in about collecting fingerprints because they're fingerprint-based background checks. So this is just the other provision I forgot to include. I'll add a few lines about it to the bill analysis and post a correction, but I didn't want to not have told you about it. So it's a new chapter that would be within Title 30, again, not in the main implementing act. And it would provide that the key is down here, although there's a purpose section and some definitions. What it would provide is that notwithstanding any other law to the contrary, federally recognized Indian tribes in the state would have the same right as any other person or entity to obtain authority to conduct mobile gaming under any law of the state that's enacted on or after the effective date of this legislation that would authorize mobile gaming, as long as that tribe meets all the qualifications for licensure, except that the tribe wouldn't have to meet any qualification that it just cannot due to its status as being a tribe, or any qualification that requires it to possess any other type of gambling or wagering license, registration, or permit. So if there's a new type of gaming of which I am unaware, because, well, like I said earlier, I understand the laws about gaming in Maine. I do not understand actual gaming in Maine. So I don't know the reality of how it works. But if there's a new market that comes up and it's some kind of mobile gaming, and there is a law passed that would say, for example, it would be a license available to commercial tracks and OTBs or to agency liquor stores or any other entity, restaurants, bars, wherever it would be. This provision would say that even though there isn't a line in that statute that says that a federally recognized Indian tribe can apply for that license, it would be able to, as long as it met any other condition for licensure other than the possession of some type of gambling license that it doesn't possess currently. So for example, if you had to be an OTB and the tribe didn't have an OTB license, that wouldn't be a disqualification point. But if there are requirements about capital outlays or physical premises or other kinds of requirements, the tribe would have to follow those to the same extent. I guess they would be physical premises because it's mobile gaming, but if there are requirements about the type of application to be used, those would all equally apply to the tribe.
Thank you, Janet. And I see that Representative Hagan has a question. Go ahead, Representative.
Yes, thank you very much. I did miss quite a bit of the earlier part of the meeting, so my question may be redundant. If the bill does pass, if this passes here, would the tribes be under, would they be accountable to state laws as far as gaming goes, or federal Indian laws, the IGRA, and not state?
So this proposed amendment to 585 creates a new state law, two new state laws. One would be a state regulatory scheme governing sports betting, and that state law would control and allow the tribes to obtain mobile sports betting licenses. And then this provision would also be a provision of state law, saying that if state laws were enacted for other mobile gaming pieces, the tribes would be able to apply for those licenses and permits. It's all state law in this bill.
Thank you.
Committee members, any additional questions about Part 5? Senator Sanborn?
Deanna, just so I'm clear, this is sort of, if at some point in the future there was online poker that was legalized in Maine, then the tribes would be able to apply for a license okay. So it's something other than sports betting.
Correct.
Okay.
Well, let me be clear. If sports betting were taken out of this legislation so that it wasn't in effect before the effective date of this provision, then, and sports betting happened in the future, then the tribes would be able to apply for the mobile piece. This is only about mobile gaming.
Are you all set, Senator Sanborn? Okay. All right. So I thank you, Janet, for taking us through the second amendment to 585. And committee members, as you'll recall, last Thursday, we got to this point of having thoroughly completed the OPLA analysis of 1626, and we tabled 1626. And now we've gotten to the same point on 585. And so I'd request a motion to table 585. Representative Harnett, is your motion?
Am I moved to table LD 585?
Thank you. Is there a second? Seconded by Representative Evangelos. And so committee members, let's start with a show of hands. And if we'd like to have Supi call the roll, then we can do that. But let's see if we have a unanimous vote on the tabling motion. Looks like it's a unanimous tabling motion. Thank you, committee members. And with that, LD 585 is tabled. And now we are going to, Supi, do you need anything else from us? Okay, good. Thank you. So we are going to, I'm just going to put all of my 585 stuff to the side, and we're going to open up a work session on 1626. When Janet took us through the bill analysis last week, there were a bunch of questions that committee members had, And I noted all of those questions on my bill analysis, and a lot of them were for the Attorney General's office. There were some questions for others as well. But I think a good way for us to start is to bring over the representatives of the Attorney General's office and start to go through the questions that we had made note of on Thursday. And I don't mean to usurp the questioning, but I did take note of everybody's questions. And so with your permission, I think I'll ask the questions and then people can ask additional questions. I just wanted to make sure that we're able to kind of get through everybody's questions. So let me start by bringing over the Attorney General's representatives. And if you're the representative of the Attorney General's office who are in the attendee space, could you please raise your electronic hands? It makes it a lot easier for me to find you. So we're being joined by Chris Taub and Kimberly Patwarden. And let's see. Welcome to you both. We appreciate you joining us today for our questions. And it's just going to take me a moment to go through the document and highlight the questions that committee members had for you. First of all, thank you for pointing out the inadvertent omission of Washington County. We appreciate your careful reading in that regard. The question that the committee had for you, and give me just a moment here. Let's see. I'm just, there were questions for other people, and now I'm sorting out which are for the Attorney General's office. As I read through the document, I think that a lot of the questions actually were questions for the tribal attorneys. And so I feel like the more appropriate approach at this point would be to ask committee members if they have specific questions for members of the Attorney General's office. And maybe Representative Harnett, can you chair the committee member questions while I take a little bit more time to look through this document and find the ones that I noted on Thursday?
Absolutely.
Thank you,
Carney. So if I could have committee members raise their hand if they have questions for representatives of the Attorney General's office. And I will begin with Representative Moriarty.
Thank you, Mr. Chair. We just had some mention of an amendment to include Washington County. And I want to be clear. My understanding is this would only be an amendment to section 6205, subparagraph 1, dealing with the Passamaquoddy Indian Territory. And we would not be amending the comparable section of the statute dealing with Penobscot Indian Territory. I want to make sure I'm correct in that assumption.
I believe that's a question better directed at our analyst who has her hand up to respond. Oh. Am I seeing that correctly, Janet, that your hand is up or not?
Yes, the tribal attorneys did submit a response to several questions, and they They listed it for Passamaquoddy Indian Territory. And that's the only place they listed it. So I'm sure you can confirm that with them. I think the idea is to have them later if that's true, but that's what their tribal response was.
That's what I understood. Okay, thanks.
Okay. Does that conclude your questioning, Representative Moriarty?
To this point, yes.
Point. Okay. Again, following up on Chair Carney's request, are there questions for representatives from the Attorney General's office from committee members? If so, please raise your electronic hand. Representative Hagan.
Thank you very much, Mr. Chair. I'd like to start with the definition of federal Indian law, if I may.
Okay. Please direct your question.
Am I in the right area? I'm at the beginning of the analysis. So I'm looking at the definition of federal Indian law, and please correct me if I'm wrong, when I'm wrong. As I read this, I'm looking at the Attorney General's concerns. It's on page 2 or 3 of the bill analysis. Looking at the definition, it seems like to me that the definition of federal Indian law is very vague. It's based on case law, judge decisions, and things like that. And according to one of the second argument with the Attorney General, that under federal Indian law, this could lead to increased future litigation because of the definition thereof. Could you explain more of that to me, as I don't really understand the complexities of federal Indian law?
Good afternoon, everyone. Thank you to Senator Carney and Representative Harnett for having us here today. And as to your question, Representative Hagan, I understand you to be asking, what is the definition of federal Indian law?
Yeah, we get a lot of them, but I'm not sure I have anything that I can sink my teeth into.
I think that's because there isn't really a single definition of federal Indian law. Even the United States has never defined what federal Indian law is. It's really a common law. It is a body of law that has developed over time through Supreme Court cases, other cases. It is interpretations of statutes and treaties that have been entered into between the federal government and the federally recognized tribes within this country. So there isn't really a single definition of what constitutes federal Indian law. It is sort of an amorphous concept. There are certainly definite principles that apply in federal Indian law, but there isn't one single definition that anyone could look to that says this is federal Indian law, but this is not.
Okay, so, and what kinds of litigation would you be concerned with as part of your concerns?
Well, I think there's a couple different aspects of that. There are, because in many respects, each tribe or nation or band within the state is unique. And there are historical relations that the United States has entered into with that particular nation or band or tribe. And so in some regards, while again, there are general concepts and principles in federal Indian law, the relationship between the federal government and each of those tribes is unique, and they have a different history. So whenever there is a case that comes up, there is always going to be an interpretation of perhaps treaties that were entered into in the 1800s or statutes that were enacted perhaps 100 years ago, or perhaps only 70 or 80 years ago. So when you're trying to incorporate an entire kind of body of law, Here, there are concepts that don't necessarily always fit in. So some of the potential for sort of additional litigation that could ensue would be, again, what, as we talked about, what is that general body of federal Indian law itself, but also, there are other parts of 1626 that are, would affirm certain treaty rights that were in the original agreements that Maine and Massachusetts entered into with the tribal nations within the state. And so there could be additional litigation with respect to those sort of treaty rights that are being recognized in 1626. So that's some of the litigation.
Thank you.
Thank you, Representative Hagan. Thank you very much, AAG Pat Warden. Next, I have Representative Galgay Reckitt.
Confess I'm a little confused in the sense that because I have been really interested in this field, I went and at the suggestion, I think 3 years ago, picked up a copy or ordered a copy of American Indian Law in a nutshell, which I was given to understand as a sort of a broad overview of the various kinds of issues that might be raised. And I didn't read the entire thing, but I read some sections of it that had to do with things we were considering on this committee at that time. I'm not pretending I knew everything or know everything or really even a significant subsection, but I understand that any law gets modified by court decisions and all manner of things like that. But it seems to me that I was told, and I could have been wrong, that this particular publication would give a sort of a broad overview of what has been interpreted as law applied, American Indian law. So feel free to tell me I'm wrong. Somebody who knows that, but I have found it helpful to read some sections when we talk about a particular type of issue. Am I crazy or?
No, you're not. You're certainly not crazy.
Good sentence there.
I think a good analogy for the point that I'm trying to make is that trying to say like that there is a single definition of federal Indian law is like trying to say that there is a single definition of contract law, or that there is a single definition of insurance law or of employment law, right? This is a large subject that has many different aspects. So yes, treatises are an excellent source of information when you are looking for generalities about a particular topic, whether it's the nutshell book or any other treatise on a general body of law. But just the point I'm trying to make is that, again, general federal Indian law or federal Indian law, it doesn't have one sort of definition, just like contract law doesn't have one definition.
Thank you.
Thank you, Representative Galgay Reckitt. Representative Moriarty. You're muted, Representative.
Sorry, thanks. Thank you. We have received so much paper over the past couple of days. I always am concerned that I have the latest edition of everything. But Assistant Attorney General Pat Warden, I want to just draw your attention to the bottom of page 2 of what I believe is the current version of the bill. There is a spelled out definition of federal Indian law. And I realize it's broad and covers many different sources, but when you say there is no definition, as I read it, the statute in fact includes one. I wonder, do you take issue with the definition as it appears in the bill?
Let me see if I can pull that up.
Yeah, it's section 6203, parentheses 1-A.
Yes, it is a definition that is created by statute of federal Indian law. Yes, it is the state defining what federal Indian law is. I think how that interacts with what this kind of like general body of federal Indian law is, I'm not sure. Is it narrower? Is it broader? You know, is there case law? Does it include only federal cases? Does it include state cases? You know, it's just not it's an interesting concept, but it's not something that's typically done with respect to sort of like bodies of law like that.
I understood.
Yeah.
Would it be fair to say that the statute contains a definition which is inevitably multifaceted in nature?
I don't know if I would disagree with that characterization. I'm not sure if I would agree either.
Okay, fair enough. Thank you.
If I may, Representative, I'm Chris Taub at the Attorney General's office. I think just to put this in context, I think if you look at our testimony on page 2, the broader point we were trying to make is that federal Indian law is incredibly complex. I mean, as we point out, the leading treatise is over 1,400 pages. So the point we were trying to make is that to the extent that the committee has an interest in bringing more certainty to sort of the issues that arise between the state and the tribes, simply incorporating federal Indian law isn't necessarily going to achieve that result, because there's all kinds of litigation all across the country over, you know, how to apply federal Indian law to a particular issue that arises between a tribe and a state. So the point that we were just trying to make is that incorporating federal Indian law is not necessarily going to result in less litigation.
Thank you.
Thank you, Representative, and thank you, Assistant Attorney General Taub. Representative Hagan, I saw you had your hand up. Are you done at this point?
No, I actually, I'm not sure if I'm done with so many questions. Representative Moriarty, I love when he asks questions. He always gets my brain going. I was curious as to what, basically based on Representative Moriarty's question, if there's no real definition of federal Indian law, I did see that there is a definition in this bill. Would this bill become would Maine become the leading definition for this concept if the bill passes? Would this do it?
I'm not sure that I understand your question, but it certainly would be unique for a state to be defining sort of like a general body of law.
Okay, it was just a thought that popped into my head that would we be breaking new ground as far as you know, the go-to, as far as when you Google it, it's the main definition.
I couldn't speculate. I apologize.
I mean, I think that the point of that provision is the idea that so currently, for the most part, when disputes arise between the tribes and the state, often what the court is going to look to are the settlement acts themselves. They're not going to look at, you know, what we're referring to as federal Indian law for the most part. They're going to be looking at the text of the statutes. And I think what the intent of this bill is to say that going forward, the way to resolve disputes is to look at all these sort of general principles of federal Indian law. So instead of just looking at the statutes, you're going to look at this much broader body of federal Indian law. And again, our point was just that that's not an easy endeavor. You know, for example, a judge can't simply pick up, you know, the nutshell book is sort of a good overview, but it's not like you can just flip through the nutshell book and say, oh, the answer to this dispute is Y, because that's what it says in the nutshell book. These issues, when you look to the body of federal Indian law, become incredibly complicated to resolve. And that's why there is litigation over these issues. And that's why, you know, so much has been written about the topic. So I don't know if that's helpful, Representative Hagan, but I just kind of wanted to put that in context.
I appreciate it. And thank you, Mr. Chair, for allowing that. I wasn't sure if I kept putting my hand up and down. I wasn't sure if I should even ask. So I do appreciate it. And that does clarify things for me more. So thank you.
Thank you, Representative. Senator Carney?
Thank you. I have been looking through my notes and I appreciate everybody's patience. I guess the first question that I would ask to the members of the Attorney General's office is with regard to the provision, and it's related to the land in Calais that originally, I guess, was contemplated to potentially be a casino. This proposal is to take any reference to IGRA, the Indian Gaming Law, the Federal Indian Gaming Law, out of the main implementing act, and instead substitute a provision that would simply say that state law on gaming applies to the Wabanaki nations. And can you comment on that, please?
Are you referring to the proposed language that was sent last night around 6:37 p.m.?
I am. It was raised as an issue in the bill analysis, and then we received that updated language last night.
Yes. Okay. So I have seen that updated language. I think we'd want to look at it a little bit further. But the issue in the testimony that the Attorney General provided, the issue that was identified was sort of the concept of what happens if state law doesn't apply, but also the bill is not effective in making federal law apply as well. And would that create a situation where there would be no federal law or state law that would govern the conduct of gaming? And so that was an issue that we raised in our testimony. And so I think this does address that concern by saying that gaming, may only conduct gaming in accordance with state law. I think that would address it. I do want to make sure that I understand it fully, though, in how it reflects with other parts of the bill, because, for example, Section 6204 of the Implementing Act is also being repealed through 1626, and that's the provision that says that, except as otherwise provided in this act, state law will be applicable. So again, I'd want to look and see how this particular provision would interact with some of how the other portions of the bill would do it. But if the intent of the legislature is to have gaming conducted on tribal lands only pursuant to state law, then I think that accomplishes that.
Thank you.
And maybe Chris has some other thoughts here as well.
I agree with what Kim just said.
Okay, and I saw that Janet also had her hand raised on this point. Go ahead, Janet.
So the language that was sent at 6:30 was sent to me, and I think the chairs, I didn't share it with everyone yet because I had already sent about 1 million documents to everyone last night, and I tried to take pity on you all and not send another one, but I have it ready to screen share if you want to see it. It was what happened to explain to everyone. What I sent to you all yesterday were the tribal attorneys' responses to the questions that were raised in the bill analysis. Some of them are responses to AG concerns, like this particular piece about gaming. Some of them were responses to the drafting questions I had. And there was a proposed language from the tribal attorneys to deal specifically with gaming. And I followed up with them and said that I was concerned that it wasn't clear to me with that proposed language exactly which law would apply. I thought it didn't quite get to the clarity that AG Pedwarden just said was their original concern. And so I asked if there was any more language or different language that they would be comfortable with proposing. And so they did send me that. I could screen share it with you if you want to, just to address this one question. And I'm happy to send it to you. I wasn't trying to hide it. I just felt like I'd sent you too much already. So that was my only point at that point.
Could you please screen share it, Janet?
Sure. So this is just showing you the email that Corey Albright sent to me in response to my question. I had said maybe move the language to a different section. I had a lot of proposals. I was just looking for some clarity. And so there is a provision in 6216 of the bill as printed, and this shows you the markups to that, which would talk about saying that AGRA does not apply in Maine. And then, as AG Pedwarden said, There are other provisions that make it so state law doesn't apply to the tribes in most areas in Maine, in most areas as in topical areas, topical types of law, including gaming. And so the proposal that I think the tribal attorneys would be comfortable with is that you would say, notwithstanding any provision of this act, which is the implementing act, to the contrary, Passamaquoddy Tribe, Penobscot Nation, and the Holton Band of Maliseet Indians may only conduct gaming activities in accordance with state law and not under the Indian Gaming Regulatory Act or regulations thereunder. This, as a matter of claimed inherent authority, was what they originally proposed in the longer responses to all of the questions raised during the first work session and bill analysis. Well, not every question, but many of the questions raised. And so they, it sounds like will no longer put in this as a matter of claimed inherent authority and then just affirmatively state that gaming would be only conducted by these three affected Wabanaki nations under state law.
Thanks, Janet. And Representative Harnett, co-chair, do you want to take chair, or I'm happy to continue? I just realized I just stole the virtual gavel from you.
No, I'm fine with having it go back to you as you were going to run through your list of questions, but I do note that Representative Babbage has a hand up.
Okay, thank you. Representative Babbage, go ahead.
Thank you, Madam Chair. Attorney Pat Warden, if you could I'm looking at 62055, and there's a repeal of a section in the Maine Implementing Act that says if title is transferred to a non-member of the tribe, the land is no longer part of the tribe's Indian territory. And I was trying to understand that if in fact it is land that is not subject to state regulation because it has gone into trust, then would those advantages be able to be transferred to a new owner? Do you understand my question?
Yes.
If the title is transferred to a non-member, then the land is no longer part of the tribe's Indian territory. It's current. And they want to repeal that. And I'm trying to assess what significance that has.
That is an interesting question. And I think I want to take a little bit more time to think about it.
Okay. Okay. I'm actually looking right now. It'd be easier if I were looking at the bill, but I'm looking at the bill analysis. And let's see, my next question was on page 18 of the bill analysis. LD 1626 also repeals 6204, 6202, and 6206, parts of those, and enacts that the affected Wabanaki nations and state agree under the Federal Settlement Act to adopt federal Indian law, except, and then they talk about civil regulatory jurisdiction. And I was trying to understand, we over 3 years, we've talked a great deal about criminal jurisdiction. And I wondered what the consequences or significance might be of also including civil jurisdiction. I think your office had some concerns about civil jurisdiction and corporations.
Well, I mean, civil jurisdiction is everything that is not criminal jurisdiction. So criminal law is a somewhat more defined amorphous body of law. But civil is just everything that isn't criminal law. So it would be, the regulatory authority over professions. It would be environmental laws. It would be, the ability to adopt a commercial code or a corporate code, or essentially anything that is not classifying conduct as a crime is civil law.
Okay, thank you. That's expansive. Yeah, okay, thank you very much. I don't think this is as important, but when we're talking about the granting of more sovereign rights, I don't actually know what the current rules are regarding the Passamaquoddy and Penobscot, but we're also talking about authorizing the Holton Band of Maliseets to be able to have their own tribal schools. And I wondered if you were aware of whether or not they are asked to follow the state's educational standards.
My general understanding is that the schools that are operated at the Passamaquoddy Reservation and the Penobscot Reservation are subject to the same requirements as other public schools in the state.
Okay, those are my three questions right now. I appreciate it, Madam Chair. Thank you, Ms. Van Worden.
Yeah, thank you. Representative Evangelos, go ahead. We're not able to hear you, Representative.
Sorry. Thank you, Madam Chair. I have just one question directed to Janet, please. Given that what I just read, that these businesses will be operating under state law, does 1626 contain the same robust processes for a dispute resolution that the governor's lawyer explained to us on 585? Basically, Janet, I remember when we did it in 2000 or 2021, that bill had dispute resolution in it. Is that same language in here?
There is a provision at the end.
It was at the end last time, I remember. I haven't gotten to the end this time.
On dispute resolution in section 42.
Okay.
I'm looking at the tribal attorney's proposed amendment. That's the one that has some red text throughout. If that happens to be the one you have in front of you,
okay.
It's at page 36 at the bottom. If you're looking at the original bill, it's page 42.
Okay, thanks.
And it requires an ADR work group to work on that. I don't know if I think it's involving disputes between the state and the tribes. I don't know that it's businesses and the tribes. I think I heard you say.
Right, but it becomes that point a jurisdictional issue between the state and tribal nations, and it fits perfect with that process. Presumably the tribes are going to be operating the facilities at some level. So that's important to me. So now I've heard two pieces of information today. One, that this operation is going to be operating under state law, an important concession. And two, when we run into problems, there's a process where they can sit down and talk about it and work it out. I think it's the best we're going to do. Thank you.
Thank you, Representative. Representative Babbage, could you please put down your hand? Thank you very much. Senator Kime, go ahead with your question.
Thank you. I wasn't here when we started onto 1626, so I'm unaware if we're supposed to be limiting our conversation to certain sections of the bill.
We began with me sort of losing track of where we were because I had agreed on Thursday that I would go through and ask the questions that people had highlighted in our bill analysis on Thursday. And as I was looking through my notes, I realized that most of those had been questions actually for the tribal attorneys, and they had answered them. And so at this point, what we're doing is we're asking any questions that we have for the representatives from the Maine Attorney General's office. And there are a couple that I noted in the work we did on Thursday, but if you have a question that you would like to ask them, please proceed on any topic.
I'm not sure. So I was looking through the town of Carabasset Valley's concerns with the bill. And so I wanted to ask through some of those because I think they're important, but I'm not sure if they, I mean, I know that the AAG could answer them. I probably that she's not the only one, but happy to ask through these if I may. And if you'd like me to just ask two, I'll stop there.
Yeah, go ahead and ask two, and then we'll take
Okay.
some other questions.
Great.
And if you need to ask more, we can.
Okay. So what they're saying here is on page 10, and I'm just looking at their testimony. So if these numbers are wrong, then you can help me out here. But I think they said on page 10, section 5, that this changes the acquisition of trust land would not be subject to approval by the state or a local government within the state. So I think prior to, I mean, without this right now, municipalities have to agree to sell their land. Does that change this, in fact?
So it's not that municipalities have to agree to sell their land unless they are the actual owner of the land. It's that right now, if there is a particular parcel that has not been identified as eligible to be included in Passamaquoddy Indian Territory or Penobscot Indian Territory, if either tribe wants to add to that list, and that parcel is included within an organized area, then that organized community has to approve of that change in sort of jurisdictional status. And so that's what MIA, the Implementing Act, provides right now. That section is repealed in 1626 for a different process.
Okay, so help me understand if it's I live in the town of Dixfield, and if I want to sell, 100 acres to the tribes, at that point forward, so I can make that sale arrangement, but if they're going to take it into tribal land, then it doesn't, then the town no longer collects property taxes on that.
If you sell 100 acres to a tribe, then they are just like any other landowner.
Right, they
own
own
that
it in
land
fee.
in fee simple, right? And so they would continue to pay taxes to the municipality or organized community where that property is located. The only reason why the tax status would change would be if that land was taken into trust by the federal government.
Right. And so I guess what I'm asking is that so this changes the process of how it can be taken into trust, as that's their complaint is. It changes how it can be taken into trust, but then at that point they no longer collect taxes on that. Is that right? Property taxes.
They would not assess taxes, but the process that's listed out in 1626 says that the tribe and the municipality are supposed to engage in a process in order to bring that land into trust, where they try to reach an agreement about what the status of that land is going to be going forward. So that agreement would be to make annual payments in lieu of taxes, or that agreement would also include potentially like what the uses of that property would be. So that's in paragraph B12 of the amendment, or what 1626 is, how it would amend section 6205. So right now, a municipality can decline to approve a parcel for any reason or no reason. Under 1626, there are sort of more, I would say, guardrails that go into the process by which the relationship will happen in between a municipality and a tribal nation, and what are the considerations that will be taken into account with getting that land into trust. Does that make sense?
Yes, it does. But I think what I'm trying to understand is, so do the municipalities still have option on whether the land would go into trust under 1626?
They would have not, essentially a municipality can right now have a veto power. They can decline to take land into trust for any reason or no reason. That would be not the same under 1626. If the tribe and the municipality are unable to reach an agreement on the topics that are identified in section B12, then they would have to go to binding arbitration in order to settle that dispute.
Okay, I understand that better now. So, and then the next question that they had was, and I know that we chatted, I know that this was covered at one point, but I don't remember the answer, so I'm asking again. And they said in section 56205 2B1 that this paragraph relates to Indian territory pertaining to only 6 counties in Maine, exempting southern Maine. Do you or can you help me understand why we're singling out, there we go, it must be a long day, certain counties and not others?
I think that's probably a question better directed towards the drafters of the legislation as to why these particular counties were selected.
Okay, thank you. I have other questions, but I will wait and let others go while I put down my hand.
Thank you, Senator Keim. And I did want to, and I know Representative Hagan, you have your hand up, but did want, actually, Representative Hagan, go ahead with your question, please.
Okay, it's not really a question. Thank you, Madam Chair. I appreciate it. My brain works strangely. For me, if we jump around on this bill, it's going to confuse me. My notes are pretty organized, and I have a lot of questions, of course, as does everybody probably. It's a really complicated and very large bill. Can't get my brain to understand many things in it. I would prefer if we go in order of the bill and not bounce around. It would be really helpful to me. As we bounce around, I have to scramble through all the varying, I've got so much paperwork and notes and things and da-da-da. So it would be my preference that we go in order of the bill in order to give it a more thorough look, and it would be easier for me personally. I hope others to just be keep our thoughts in order.
Yeah, I appreciate that, Representative Hagan, and I agree with you. And I'm not feeling well. I need to take a little bit of a break. And so I'm wondering if we can recess until 4:15. And during that time, I will take a look at how we can group our questions into topic. And I apologize to ask for recess because I know we're under a lot of time pressure. But if we could take a recess until 4:15, and when we come back, we can proceed in a more topical fashion. I think that's a great suggestion. Thank you.
Very much. Take care of yourself, Madam Chair.
Hi, committee members. If you are able to return to the meeting, could you please activate audio and video? Or at least video. All right, it looks like most committee members have returned. Thanks, everybody, for that brief recess. I just wanted to say, I am not feeling well. I know that Representative Hagan made a really great observation, is that we have lots and lots of documents and information in front of us, and I originally thought that a good way to organize our work would be to bring on the attorney generals and go by who would be answering the questions rather than by topic. And I think that Representative Hagan is right. It's probably better for us to organize our work by topic. And so I'm also conscious of wanting to make the best use of people's time. And I know that folks have been waiting around today. And we all, as committee members, have been working very hard today. But what I'd like to suggest going forward is that we table 1626 for today, that Chair Harnett and I meet with the leads, Representative Hagan and Senator Keim, and that we come up with a little bit better and more efficient way to complete our work on 1626, because I do feel that we're sort of and some of it is because I'm not feeling well and able to lead the committee through a good process, but we're not following a good process that's going to answer our questions and use committee time and also use the time of the members of the public who are here to speak to us very effectively. And so I would ask the committee, oh, and I also wanted to let everyone know that we do have time on Thursday afternoon, and we will reschedule 1626. And also we will schedule our final work session on 585, likely Thursday afternoon. We also have time on Friday. And so I would just ask those who are all of the interested parties in this legislation to check the website tomorrow for a schedule as to when these two bills will be rescheduled. And committee members, please do so as well. And so with that, I'd entertain a motion to table LD 1626. Motion by Representative Moriarty, seconded by Representative Evangelos. And committee members, if we could start with a show of hands on the tabling motion, and if that doesn't work, we'll do a roll call. All those in favor of the motion to table?
Counting 11.
Thank you. And thank you, everyone. I really appreciate your understanding.
Take care of yourself.
Okay, and with that, is there a motion to adjourn? So moved. Okay. Thank you, everyone.
Bye-bye.